Okay, we're on the record on State versus Loyd. Mr. Loyd's present with his attorneys. The state attorney's office is present. Mr. Loyd is wearing a long sleeve, sort of burgundy civilian shirt, civilian pants. He's got on shoes, but he is shackled. His feet are underneath the table and cannot be seen from anywhere in the courtroom by the jury. The mask mandate in the Orange County Courthouse has been lifted by the chief judge. So if you do not want to wear a mask, you may remove them or you may leave them on. It's up to you. All right, let's bring the jury.
Can you hear me, Chris?
Yes, sir.
Okay, I think that's loud enough.
Jury's coming in. Hang tight.
State recognized presence of the jury.
Yes, Your Honor.
Defense. All right, good morning, everyone. Welcome back. I hope you had a nice Sunday. It was a beautiful day, so I hope everybody's relaxed and ready to go. The chief judge has lifted the mask mandate here at the Orange County Courthouse, so if you choose not to wear your mask, you can take it off or you can leave it on. It's completely up to you, all right? The defense is still presenting their witnesses. Mr. Lenneman, you may call your next witness. Yes. Mm-hmm.
Madam Clerk, this can be a composite. Good afternoon, Mr. Robinson.
Hold on, you still haven't called him. You need to call him.
Good morning, Mr. Lemon.
I haven't sworn him in, so you're going to need to call him.
The defense would call Christopher Robinson.
You recognize the gentleman on the screen as Mr. Robinson?
I do.
State, you recognize him as Mr. Robinson?
I do, Your Honor.
All right, sir, if you can raise your right hand, please. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you may inquire.
Would you tell me your name, sir?
My name is Christopher Robinson.
And how are you employed?
I'm a private forensic consultant in Atlanta, Georgia.
Hold on one second. That's the computer, because I've turned down the court's volume. All right, let's try it again. All right, go ahead.
And can you give me an overview of your experience, education, and otherwise?
Yes, sir. I received my Bachelor of Science degree in chemistry from Berry College in Rome, Georgia in May of 1995. I began my career in the forensic field at the Georgia Bureau of Investigation in July of 1998. I worked there as a firearm examiner from the 98 to 2008. I then became the director of the crime lab for the City of Atlanta Police Department and worked there for 2.5 years in that position. I then started my own company, Chris Robinson Forensics, and I've had that now for the past 11 years. During my career, I've logged over 15,000 hours in the comparison microscope and performed over 100,000 forensic examinations. I'm into 8 honors courses. I'm into 8 manufacturing plants, and I've currently worked over 12,000 actual cases.
Now, there come an occasion when I reached out to you to hire you on this case?
Yes, sir.
Okay. And in the course of hiring you, I provided you some documents to review?
Yes, sir.
Was one of the set of documents I provided to you was the report of Richard Ruth, who is the FDLE firearms examiner, and his bench notes?
Yes, sir.
Can you explain to the jury what bench notes are?
Bench notes are essentially the worksheets created by the analyst. For example, if we look at a weapon, it'd be a weapon worksheet. A cartridge case would be a cartridge case worksheet. The bullet will be a bullet worksheet. It details what they examined, what they saw when they measured the bullet weight, the dimensions of the lands and grooves, the number of lands and grooves, anything that they could determine about the particular piece of evidence that they were examining.
Was there a particular bullet labeled Q13 that was found at the south entrance of the Walmart?
Yes, sir.
Did you have an opportunity to review both his report and his bench notes in regards to that particular item?
Yes, sir.
What was that item?
This item was a bullet, a piece of a bullet jacket that was recovered from the southeast entrance of the Walmart area parking lot.
Okay. Was that bullet enough to actually identify with particularity where it came from?
Okay, so when we examined, Mr. Ruth examined this particular piece of evidence, and so did I. We both came to the same conclusion with regard to the bullet weight. We looked at the rifling structure of the bullet itself. It has the same rifling structure as the firearm that was used by Officer Clayton. It has the same overall consistent measurements between the lands and grooves on the test fires from the officer's weapon to the actual lands and grooves on this particular piece of evidence. So according to Mr. Ruth and myself, it is most consistent with having been fired from Officer Clayton's service weapon.
Was it eliminated from Mr. Loyd's weapon?
It was based on the overall characteristics of the guns, the caliber, the type of rifling. So all the weapons that were handled by Mr. Loyd, they were eliminated as being consistent with firing this particular bullet jacket.
Now, I kind of glossed over, was there a time when the Orange or the Orlando Police Department sent you all the ballistic material, including the firearms and the casings and the projectiles?
Yes, sir, they did.
And when you were talking about that you reviewed that stuff, did you look at that particular bullet?
I did.
Okay. I had talked to you yesterday about a sheet that is identified which has 10 photographs of various projectile. Did you have an opportunity to review that in the course of your responsibility?
Yes, sir.
And here it's marked as Defense Exhibit 1. Can you tell me which bullet is the one that is, or projectile, or piece of projectile is the one that is identified as coming from the south end of Walmart?
Do you have the photograph for me to review, sir? I'm sorry, I can't see it on my end.
Okay.
I mean, yeah. Okay. Yes, sir. Okay, I'm sorry. Yeah, it's the Q13. You can see it identified right there. Yes, sir.
Okay. Can you describe what that bullet looks like to you?
Yes, sir. It is a portion of a bullet with a portion of the jacket is missing. That means that this particular projectile has struck something very hard and it has caused
Wait.
about half of the bullet to be lost. It weighs 88.0 grains and it should weigh approximately 124 grains. So it's lost a significant amount of weight due to striking the surface of something extremely hard.
So there's been testimony by several officers that particular fragment looks old and worn out. Can you give me your opinion about that?
No, sir. I see no evidence. You can see on those photographs that you just had in your hand, they all look the same. It's a copper jacketed projectile. There's no tarnish. There's no corrosion to the jacket. It looks like it's a new jacket. Now, the problem is it looks abraded. Abraded means it has abrasions on it from, again, it's spinning, and then as it strikes a material, it's impacting that, so it's abrading the sides of the projectile. It is damaged. So again, to the untrained eye, they may think that bullet looks old, but again, Mr. Ruth and myself, neither one of us said that this bullet appeared to be old. No corrosion was observed. It just has damage to it, sir.
Now, was there a particular substance that was discovered on this projectile?
Yes, sir. There was a white-colored residue on the base of the jacket, but again, this bullet could have possibly ricocheted or it struck something and then it impacted this concrete area. When a bullet's spinning and it impacts concrete or a hard surface, it creates this white substance that you see on the base of the projectile. Again, it's the byproduct of impacting an extremely hard surface. It doesn't mean anything. It's just a residue that's created by the two surfaces impacting each other.
And when bullets ricochet, is it unusual for them to hit more than one item?
Oh, no, sir. You have to understand, this particular bullet was traveling about 1,000 feet per second. So when it hits something, it can hit multiple things before it slows the bullet down and it finally comes to rest wherever it loses its energy.
Okay. Going on to the next area. Yeah. Oh. We have an opportunity at some point to discuss both the vest and the shirt of Sergeant Clayton?
Yes, sir, we did.
And in the course of doing that, did you review a number of photographs?
Yes, sir, I did.
Judge, I'd move in, I think by agreement, identification V.
No objection, Your Honor.
All right, this will be received without objection as defense composite exhibit number 18, consisting of, how many pages is that? 10 pages. Is it 10 photographs?
Yes.
10 photographs.
Do you have the photographs that we are talking about in front of you?
I do. I have them on a disc, but I do not have the individual photographs in front of me, not at this moment, but I can get them if I need to, sir.
Yeah, why don't you get those, and it will save some time.
Okay. All right. And do I need to share my screen then, sir? I guess what we're going to do here? Okay.
That's fine.
Okay. Okay, let me me see how we're going to do this. Okay. All right. Okay, it says the host is disabled participant screen sharing, sir. So I need to be allowed to share my screen.
Okay, so these items that are in front of you are
Yes, sir.
Identified by a number, correct?
They are.
Okay. So I want to talk to you about what I asked you to do and look at in regards to that material. Oh, you can screen share according to.
Okay. All right. All right. Let me see here. Can you see my screen, sir?
Yes.
Okay. Okay. Hang on. Let me pull this over, sir. Sorry. Okay. We're looking at the vest that was worn by.
Hold on a
Go ahead.
second, Chris. What did I ask you to do in regards to the vest and the shirt that was worn by
Okay. You asked me to first of all. Okay. I'm sorry.
Lieutenant?
You asked me to first of all examine the autopsy, to look at the wounds on Officer Clayton's body. And then you asked me to look at both the vest worn by Officer Clayton and her shirt that was worn by Officer Clayton to see if the wounds on the body correspond to the defects that were observed in the vest and the shirt.
Okay, and so what we're talking about there is the vest, and it's actually labeled photograph 18 in the discovery?
Yes, sir.
Okay, can you tell me what that is?
This is the front of the vest, and you see the stickers that were placed on the vest when they examined the vest. You can see it says vest front 1, vest front 2, and vest front 3 is what they observed the defects that were in the front of the vest.
When you say defects, what do you mean?
It means that these are the bullet defects for the projectiles actually passed through the vest itself.
Okay, now before we talk about that one, I want you to go to 17.
17, okay, yes, sir.
Now, at some point, Mr. Robinson, you were asked to look at Mr. Loyd's vest. Is that right?
Yes, sir.
And you were examining that for possible bullet holes.
Yes, sir.
Okay. And you did not note any.
I did not.
Okay. And so here we see in 17, there are some items that are placed next to the vest. Can you explain to the jury first what those items are, how they work, what is important, and then I want you to talk about Mr. Loyd's vest in comparison to Lieutenant Clayton's vest, okay?
Yes, sir. Okay, at the top of the screen, that's a ballistic plate. That is the plate that's designed to stop the projectile from passing into the body of an individual who wears the vest. So it's about a 1/4 inch plate. I believe this is rated at 3A. The rating tells you the types of bullets that it will stop. So again, this is the critical piece in the vest. The vest is just a carrier. You stick these plates inside the vest, and when you slide those in there, those plates are what stop the projectiles. Now, the yellow piece that you see there is called a trauma pad. You wear that in coordination with the plate. What that does is, if the bullet does strike the plate, then it dissipates the energy through that trauma pad, so your body's not taking the full brunt of that projectile, because when it hits that metal plate, it's just going to reverberate through your body, but the trauma pad will dissipate that. So it protects your body, again, as a secondary feature of the vest.
And if someone is struck by a bullet that hits the initial black piece, in your opinion, professional opinion, what kind of things happen to the person who is standing up wearing that?
Again, you're going to feel depending on the type of bullet now. I mean, the more powerful the bullet, the more energy is going to be exerted. So when that energy, which it's going to be somewhere between 330, 350 to 400 foot-pounds of energy. So when that projectile strikes that plate, again, it's a steel plate. So when the plate, it reverberates and it starts to move, you can feel the impact in your body. Now, again, it's going to stop the bullet, but the energy is going to be impacted into your body. So you're still going to feel a significant amount of force impacting your body, and it's going to do some type of damage, bruising. It can cause, bones to be broken in your ribs. Even though the projectile stopped, the plate can still do damage to your body because the energy of the bullet itself.
Okay, and when you compared Mr. Loyd's vest, was there a difference between his vest and Lieutenant Clayton's vest?
Yes, sir. Essentially, what Mr. Loyd has is called soft body armor. It's just a softer, again, it is a 3A rated vest. It will stop bullets, but again, the vest is flexible. That's a plate that you see in front of you in this picture. It's an actual plate, a steel plate. It does not move. It is solid. Mr. Loyd's vest was very soft and you can move it. It's called soft body armor. So it's a different type of vest. It does essentially the same thing. It's not as strong as, this is a ballistic plate. This will stop almost, anything with regards to handguns, where the soft body armor will stop a lot, but it's not the same as this hard body armor that you see in front of you.
When you look at Mr. Loyd's vest in comparison to Lieutenant Clayton's, does Mr. Loyd's vest cover more area in terms of protection than Lieutenant Clayton's?
Yes, in the sense that it is an overall vest. It's rated 3A, and because of the soft body armor, the entire vest around the chest area is, it protects you. In this sense, what you see in front of you, again, I want to explain, that's called a carrier. You place the plates inside the carrier, and therefore the plate is what protects you. So its only protection is that plate. If the vest is struck anywhere besides that plate, the bullets are going to go through just like any normal surface.
Okay, I want you to go back to photograph 18.
Okay.
You had talked about the areas where there were bullet holes, correct?
Yes, sir.
Are the two bullet holes down at the bottom of this photograph, were they in the protected area of the plate that you were talking about?
No, sir.
Okay. What about the one that is above that particular bullet hole?
No, sir. Unfortunately, where you see the top defect right above the police, in that particular area right there, you can see there's a Velcro that goes across there. You open up the Velcro, you place the plate inside, and unfortunately, in this instance, the plate is lower than the defect. So, no, sir, that defect went straight through the vest.
Okay, based on your examination of the vests and the shirts, and we'll continue to go through that, there were actually 4 different wounds on the body of Officer Clayton that were a result of gunshot wounds, correct?
Correct.
Okay, can you describe those for us?
Yes, you have the one that you see right there in the neck area, which is at the top right. Then you had the shot that you see right there on the left abdomen area. You had a defect that comes through the right buttock and exits her right abdomen area. And then you had the shot to the right thigh.
Okay. Now I want to go back to the one that deals with the chest and neck.
Okay,
Can you pull up 19?
Yes, sir.
Can you turn it around or turn it?
I can, yes, sir. Hang on 1 second. I gotta move this out of the way. Sorry. I'm not sure. Hang on a second. I gotta move this because my picture's in a different, okay, let me see right here. Okay. No, sir. When I do try to move it, you say I don't have permission to rotate that. So unfortunately, I'm unable to do that based on the permissions given to me when it was sent. But this picture is upside down, ladies and gentlemen of the jury. I'm sorry. But again, you can see where the neck straps are. It goes over your shoulders, and those are your shoulder straps that go on either side of your shoulder. And you can see the defect that's on the right side, right above where the sticker is. I'm sorry. Again, Mr. Lindeman, it says best front 1, and the defect is right above that sticker.
So that obviously missed the plate and ended up in the chest and neck of Lieutenant Clayton.
It did.
All right, I want you to go to number 21. This is a blow-up of what you were talking about before?
Yes, sir.
And describe those.
Again, this is kind of unique because on this particular vest here, you see 2 defects. Now, in a minute, when we go through the pictures of the shirt, there's going to be 3 defects. The bullet goes into the vest, and then it exits the vest right there at number 3, and then it re-enters the body of Miss Clayton. You can see through the shirt. So it's in, out, in. But on this vest, you can see where it entered, and then it exited the vest.
Okay, so that was just one shot?
It is.
Okay. And then where is the other shot? I think the right, the
Okay.
buttock?
Let me continue forward, sir.
I think it's 27.
Okay, yeah, 27. This is on the back of the vest. Again, you can see where it enters. These are just the flaps that help you tuck your vest down into your pants. Therefore, you have a nice tight fit on your vest. There is no protection there. That's just a cloth. There are things that can be purchased that, again, will make the vest heavier, but you can place different panels inside of these flaps. But again, that depends on how much weight you're willing to carry. It's not generally done by service officers because you can be carrying an extreme amount of weight. So you can see where the bullet enters her right buttock, goes through the vest or through her pants, through the right abdomen area. And then let me go forward, sir. Okay, and then now I'm going to the shirt just to elicit. This is picture 29, Mr. Lindeman. Okay. I want the individuals you can see on the right abdomen there. There's actually 2 different defects, and if I go forward, sir, let me continue forward just for a second. I'm sorry, I'm getting out of order. I didn't mean to do that, but again, I just wanted to show you that it's kind of confusing. Going back to what I said earlier, you can see the defects to the right abdomen. It just clipped where it says shirt front 7 there. That's a fold. So it nicked that, and then it went into the shirt at 6, exited at 5, re-entered at 4. So on the shirt there, you can clearly see on that left abdomen how it goes through the shirt. Now, what I was saying was on the right side, it went through her buttock, and as it came through the front of the shirt, it caused 2 different defects because the bullet was kind of exiting, a partial exit according to the autopsy, and then it kind of ricocheted and went back into the body. So there's 2 different defects there, but that again, that's one shot through the buttocks.
Okay.
And then if I go back now, sir, that I got out of order, I didn't mean to do that. This goes back to, and let me go forward. This is the close-up of the defect that was in the shirt itself. This, again, you can see it. It went through the shirt and then down into her neck area. Again, this is, again, I'm sorry, it was upside down. This is how it was given to me. But again, you can see the overall, how it entered and it into the neck area of Miss Clayton.
Okay. And 52 and 53?
Okay. 52, this is the back of the shirt. This is where her shirt is tucked into her pants. Again, it went through the pants, through this shirt, through the vest that I showed you earlier, and then it exited her right abdomen area.
Sir, just a second, please. Folks, we need to take a quick break. If you all step out of the courtroom, please. Thank you.
Hold on, Chris.
All right, Mr. Loyd has returned to the courtroom. Mr. Loyd, I'm going to remind you again that you are not to address any comments to the audience. First of all, you're not to be making comments during testimony, and you are not to address the audience. Let's bring the jury back in. State recognized presence of the jury?
Yes, Your Honor.
Defense?
Yes.
All right, welcome back, folks. You may resume, Mr. Lennon.
Thank you. All right, so this is photograph 52. Can you explain what that is?
Yes, sir. This is an overall picture of the back of the shirt worn by Officer Clayton. You can see the entry wound that passed through her right buttock and then exited her right abdomen area. If I go to the next photograph, sir, that's a close-up of the back of the shirt. That just shows you that it passed through her pants, through the shirt, through the vest, and then it exited her right abdomen. Now, when it exited her right abdomen, there was no defects corresponding in the vest itself, only in the shirt.
Okay, I want you to go back to 43 for a second. There appears to be, I guess, 6 pieces of tape on there which identify different things. Have you
Yes,
covered
sir.
all those?
Yes, sir. What I explained earlier, that when you see the shirt front 7, that's just a nick in the shirt. That could have been due to a fold. The shirt could have been folded up close to 6, so when it passed through there, it goes in and it goes out at 5, and it comes back in at 4. On the right side of the shirt there, that's what I was talking about. It went through the right buttock, and then according to the autopsy report, he describes a partial exit where the bullet kind of exits the body and then it re-enters. So again, it's like a double defect there, but that's from the one shot that entered her buttock. So both of those defects on the right side correspond to the entry into her right buttock.
Thank you, sir. Judge, may I publish this to the jury?
You may.
do you still need for me to share my screen, Mr. Lindeman?
Yeah, I'm going to have you pull up the demonstrative that was prepared by, that I sent you yesterday.
Yes, sir. Hang on 1 second. Now, I'm going to stop sharing just for a second. Let me find it, please. All right. You want this diagram or do you want the actual picture? I'm sorry, sir.
No, this diagram,
Okay.
and then have the picture available.
Okay. All right. Okay.
Actually,
Sorry.
why don't you pull,
I'm sorry. I'm sorry. Go ahead.
why don't you pull up the picture first?
Okay. Okay.
Yeah.
No objection to that exhibit. I don't know what number it is. It was in evidence, Your Honor.
Hold on, you can't show exhibits before they're in evidence. Sir, take that down, please.
Okay. Sorry.
Thank you. How is that exhibit identified? W? All right, this will be received without objection as defense exhibit number 19. It consists of one photograph. All right, sir, you can put it back up again. Thank you.
May he publish?
Yes, sir.
Yeah.
Mr. Robinson, you can put the picture back up again.
Okay. I'm sorry. Okay. Thank you. All right.
Okay, Mr. Robinson, what is this?
This is a picture of the scene of the shooting during the incident, indicating where different cartridge cases were identified and recovered at the scene.
Now, you also had another, the diagram prepared by the state attorney's office.
I did.
Pull that up.
You want me to bring that up now, sir?
Yes.
I'm sorry.
No, you can bring it up.
Yeah. Bring up the diagram?
Yes.
Okay. You can see the diagram, correct?
No.
You cannot?
No.
Okay. All right. Hang on a second. Sorry, sir. Okay.
Okay, perfect. Okay, so I want you to explain to the jury how on, I guess, both Lieutenant Clayton's and Mr. Lloyd's gun, how the casings eject.
Okay. Hang on 1 second, sir. Okay. Yes, sir. On both the weapons, they eject to the right and rear of the shooter at about a 45-degree angle. This is due to the fact that the extractor's on the right side of the weapon at 3 o'clock and the ejector's on the left side of the weapon at between 7 and 8 o'clock. So when the gun cycles, it ejects the cartridge cases out due to the physics and the nature of the weapon.
Okay. And you had an opportunity to review this diagram.
I did.
Would you agree with the statement that all but marker K are near the area where Lieutenant Clayton was?
Correct. Markers B, C, D, E, G, H, and I are relatively close together on the right side of the screen there, sir. And then K is on the far left of the screen in this diagram.
Now, do you note a Q there?
Yes, sir. The Q was, according to this diagram, I have an A, O, and R. I don't have a Q per this diagram, but I do note the Q there. Yes, sir.
Okay. And LJMN, what firearm did that come from?
Those are the A, O, and R, and F, L, M, and N, and the J are from the 40. So the A, O, R, F, L, M, N, and the J are from the 40 caliber.
So the only one over there that belongs to the SIG, which is Lieutenant Clayton's gun, is K, right?
That is correct, sir.
Okay. Now, did you have an opportunity to view the actual shooting taking place?
I did.
And do you recall that there was a point where Lieutenant Clayton was running towards the area where she ends up, and that she fires her gun as she's running from behind, and the bullet actually hits the concrete?
I did. Yes, sir. I saw that.
And is that the area where the red is?
Correct.
Okay.
Correct.
So if she fired from there and she's running, what direction would the casing go?
And again, if you do what you just did again, sir, when you bring your arm to the rear, see, now you've inverted the gun, which means you've turned the gun upside down. So what I'm telling you, the gun ejects, if I hold it in normal fashion, it ejects right and rear. If you turn the gun upside down, you've changed the whole controls of the weapon. Now it ejects to the left instead of to the right. And now if you turn the gun upside down, it's going to kind of eject toward the left and rear of the shooter, but it's going to eject it toward the ground more than, the other one would be up into the air, and then it's going to land back 6 to 8 feet. If you turn the gun upside down, it's going to go left and rear, but it's going to impact the ground much sooner.
Okay, so let's assume for the hypothetical, if she didn't turn it upside down and she fired, which direction would it go?
To the left.
To the left being like left of A?
Left of the shooter. Say if you turn your gun like that, it's going to go to the left of the, instead of to the right, which almost every gun does. If you invert the gun, it's going to go to the opposite side of your body, to your left. And if you're running away now, it's going to go to the left of the weapon. Let's just say that instead of to the right of the weapon.
Okay, so hypothetically, let's first take that she doesn't turn the gun around.
Okay.
She's running from the area which is going to be, let's say, close to, you see A?
I do.
Okay, and if you move a couple over there, like the second one that goes over, she's in that area.
Okay.
And she was running towards Q. You understand what I'm saying? Okay.
I do.
And she has the gun regular. She doesn't have it turned upside down, and she fires a shot into the ground. So her gun is pointed downward to some extent, that it's the bullet's hitting the ground, and you can see it. You follow me?
I do.
So where would the casing go in that circumstance?
If the gun's in normal fashion, the cartridge case is still going to be ejected. Now, the angle of your gun, if you start to angle it downward, it's going to still eject to the right and rear. It's just going to eject the cartridge case more up into a perpendicular fashion, and then it's going to come back down. It can bounce around. But if you have the gun at a downward angle, you start to change that. But it's still going to go right and rear of the shooter as long as she's got it in normal fashion. It's just going to be a different, angle that it ejects.
And so if that's the case, it's going right and rear. If she's on the concrete heading towards Q, where would that casing supposedly end up?
It would be like you said, over there in the concrete, and it would be back toward the area where all the rest of her cartridge cases were found if the gun's held in normal fashion.
Okay, and what happens if it's held upside down?
Well, then it would eject to the left, and then I could understand the cartridge case being in some kind of position like it is, because it can eject onto the ground. It's cylindrical, it's smooth, it can bounce, it can roll. What I'm telling you is where it would hit the ground, not where it would end up. But yes, sir, I would understand that. If you told me the gun was held inverted, then it makes sense. It would go the opposite direction. But if the gun's held in normal fashion as she's running away, it would eject to the right where all the rest of the cartridge cases were found.
And if she's on the concrete, when the bullet is fired, it would go left. I'm talking about if it's inverted now.
That's correct.
Inverted, it's going to go left. And because the gun is pointed down, is it going to shoot out and go down, or is it continue to go up?
It's gonna go up slightly, because when you invert it, it's gonna be right and rear, but it's gonna eject it in a downward angle, but it's gonna be, depending on the angle of the weapon. But yes, sir, it's gonna eject it in a downward angle, not upward like this in normal fashion. It's gonna eject it downward into the concrete. Yes, sir.
Okay. And now, hypothetically, if she is standing near that second blue, 2 over from A, you see what I'm talking about? And she fires in the direction of where Mr. Loyd is, where would that bullet go?
She's aiming where Mr. Loyd is. It would eject to the right and rear, but again, that distance right there, it would eject to the right and rear. So, I guess, if you're saying that second blue pillar like you're talking about, or the blue column right there, yes, sir, she's shooting at Mr. Loyd, it's going to go right and rear at an angle. And again, they could roll, they can bounce, they can travel a little bit further, but it's 6 to 8 feet in a normal fashion, normal fly. And that's where they impact the ground, 6 to 8 feet from the shooter. Then they can bounce, they can roll. So that would give it a little more distance. So, yes, sir, I can understand that now. If you said she's at that second pillar, yes, sir, then I would understand. If she's shooting toward Mr. Loyd in that fashion, that makes a little bit of sense. Yes, sir.
Those are all the questions I have. Thank you, sir.
Thank you, Mr. Lemon.
Thank you.
Mr. Buxton, you may inquire.
Morning, Mr. Robinson.
Good morning, sir.
Now, in the beginning of your direct examination, you said that you reviewed Richard Ruth's, who is the Florida Department of Law Enforcement firearm analyst. You reviewed his bench notes and conclusions, correct?
Yes, sir.
And you performed your examination on the same casings and projectiles that Mr. Ruth did, right?
I did, yes, sir.
And your conclusions were the same as Mr. Ruth's, correct?
Correct.
Your conclusions were that the .40 caliber casings that were recovered from the Dixon scene came from the defendant's .40 caliber Smith & Wesson, correct?
Correct.
And the .40 caliber casings that were found at the Walmart scene came from the defendant's .40 caliber Smith & Wesson.
Correct.
And the 9mm casing found at the Captain Carter scene came from the defendant's 9mm Glock 17.
Correct.
and the projectile from Sade Dixon's body and the projectiles from Debra Clayton's body came from the defendant's .40 caliber Smith & Wesson.
That is correct.
Okay. Now, referring to the diagram that you have shared with the jury. Oh. I'm putting it up for the jury. Hang tight. Referring to diagram, the marker K on the diagram, which I believe is what Mr. Lenneman you were discussing.
Yes, sir.
Letter K designates a 9mm casing, correct?
Yes, sir.
Fired from Lieutenant Clayton's 9mm, 6 hour.
Yes, sir.
All right. Let me give you a scenario and tell me if it makes sense. If Lieutenant Clayton is running with her back facing the entrance of Walmart, she is running away from Walmart and running away from Mr. Loyd, who's shooting at her. Okay? You follow me so far? She's running towards the parking lot with her Sig Sauer in her right hand. Okay?
Yes, sir.
And as she's running, her Sig Sauer is inverted, pointing towards the ground. Okay?
Yes, sir.
And she pulls the trigger.
Yes, sir.
Will that casing go in a direction consistent where marker K is on the diagram?
Yes, sir. That does make sense. If you tell me it's inverted, it's going to go to the left, not to the right. So it would be different than all the rest. If all the rest were fired in normal fashion, and then you tell me K was fired inverted, yes, sir, that makes sense why it's so far from all the rest.
And you have reviewed the video, correct?
I did.
Would you agree with me that in the video, it shows Lieutenant Clayton running away from Walmart and from Mr. Loyd with the gun pointed down and a projectile strikes the pavement behind her?
I agree. Yes, sir.
You examined Mr. Loyd's vest, you said, correct?
I did. Yes, sir.
And am I correct that you saw no indication that this trained law enforcement officer ever fired a projectile that struck Mr. Loyd's vest?
No, sir. There were no defects observed in the vest.
Okay. Shifting gears to the projectile jacket that was found on the south entrance of Walmart. I believe you designated as Q13, right?
Yes, sir.
That was the projectile found by Detective Shane Overfield, right?
Yes, sir.
That was a copper jacket, correct?
It was.
Not a brass jacket.
That's correct.
And would you agree with me that copper jackets don't tarnish if left in the elements as quickly as a brass jacket would?
Absolutely.
All right, so you can't say when this jacket was initially placed there, correct?
I cannot.
Okay, and like Richard Ruth's analysis, you can't say that it came from Sergeant Clayton's Sig Sauer, right?
I cannot.
You can, and you say it can't be excluded either.
That's correct.
Okay, and am I correct that there are numerous types of firearms that could leave the markings that you saw on that jacket?
Yes, sir. Any 6 right firearm, which means there's 6 lands and grooves of the right hand twist that have the same measurements as the Sig Sauer, and there's numerous in that particular area. Yes, sir. I have to say that it is consistent with any number of different guns with that same design. Correct.
But for the sake of argument, let's assume it came from Lieutenant Clayton's Sig Sauer. Your analysis cannot say in what sequence of shots that projectile was fired, whether it was shot 1, 2, or 10.
Oh, no, sir. No, sir.
Your analysis can't show what threat Lieutenant Clayton would have been perceiving at the time she fired that projectile, assuming it came from her gun.
No, sir. There's no way to determine that. For me to determine that.
Last thing I want to talk to you about is Lieutenant Clayton's vest and her shirt and her pants that you discussed earlier.
You need me to bring those photos up, or oh, you're okay?
No, that's okay.
Okay.
You indicated that the injuries that were on Lieutenant Clayton's body were consistent with the defects you found in her shirt, in her pants, and her vest. They were in the same locations.
They are.
And none of the gunshot wounds that Lieutenant Clayton suffered initially struck the vest plates, correct?
It did not.
They all struck areas of her body that were not protected by the vest plates.
That is correct.
And the whole purpose of body armor or these vest plates is to protect vital organs in the body, right?
It is, yes, sir.
So if the defendant was aiming towards the vest, necessarily he would be aiming towards vital organs of the body like heart and lung.
That is true.
Being shot even in the vest plate can still cause some catastrophic damage, can it?
Oh, absolutely. The shock and the force that's exerted on a steel plate. Your body's not made of steel. Your body's made of tissue, organs, as you just stated, muscle, tissue. When that plate gets struck by a projectile traveling so fast, it causes that plate to reverberate and move in a fashion that your body takes the shock. Now, the plate does dissipate the energy somewhat, but yes, sir, you take I've observed individuals who've been shot in the plates, and they are, it does, sir, it can be catastrophic. I agree with you, absolutely.
It could even be deadly.
It could be, depending on the caliber and the energy of the bullet, absolutely.
You would agree that if Lieutenant Clayton was shot in the right buttock as she ran away, and that projectile fractured her hip bone, that is not an area covered by a vest plate, right?
It is not.
And if she was shot in the back of her upper right thigh as she ran away from Mr. Loyd, that area is not protected by her vest or a vest plate, right?
It is not.
And you've watched the surveillance video, correct?
Yes, sir.
You would agree that at the end of the encounter, Lieutenant Clayton was lying on her back or her side area in the parking lot, right?
I understand, yes, sir.
And having fallen to the ground after being shot in the right buttock and the upper right thigh, right?
Yes, sir.
And you agree that the video shows that the defendant ran over towards her and stood over her
I do agree with that.
and fired additional shots.
He did.
And right after that additional shot, Lieutenant Clayton's hand immediately went to her neck where that wound was located, correct?
I do agree with that.
And the muzzle of his .40 caliber firearm was only about 3 feet away from her exposed neck when he shot her that last time, right?
Yes, sir. According to the video, that's what it appears to be. Yes, sir.
So she was shot at pretty close to point blank range.
I guess you could call, I wouldn't say point blank just because 3 feet. Point blank to me means it's a contact, a near contact. It's a close range shot, sir. It's a close range shot. Yes,
Fair enough. And you agree that her vest plate does not cover the area of her neck where the defendant shot her at about 3 feet away as she lay on the ground, already suffering from multiple gunshot wounds.
I agree.
Thank you, sir. No other questions, Your Honor.
Redirect.
Mr. Robinson, when you say 3 feet, that is a minimum. Is that right?
Yes, sir. That's approximate. Yes, sir. I'm looking at a video. I mean, it's approximately 3 feet. It could be further. It could be, sir. Yes, sir. I'm just saying that's what it appears. It's an apparent 3 to 4 feet, but that's on a video now. I didn't measure anything. There was no stippling identified on the body. There was no gunpowder identified on the body. So gunpowder generally stops at 3 feet. So therefore, it had to be at least 3 feet away because there was no gunpowder found on the body.
Okay. And you viewed the video that she had her gun held up and she was shooting at Mr. Loyd while she was laying down.
Yes, sir. And that is, again, this diagram that's up on the screen, you can clearly see the cartridge cases surrounding her. So she is clearly firing her weapon as she's on the ground. Yes, sir.
Okay. Now I want to talk about this diagram again. and what the prosecutor talked about in regards to this shot being fired, because I'm a little confused, okay?
Okay.
Now, let's assume we're talking about an angle, because we have a video that shows the actual point when she is pointing her gun behind her and fires. Okay?
Yes, sir.
Okay. So let's assume she is in the middle of that, between A and I. She's in
Okay.
the middle of that. Let's say it's closer to the blue pole that's at the end, the two over from A.
Okay.
So if you would make an X on this so we can see.
Okay, I'm sorry. Let me see. Okay. Annotate. So draw. Okay. So you want.
Yeah, imagine she's between the last pole, right, no, over here. No, go all the way over to the other side. Yeah, that pole.
Okay.
Okay. And that she's running towards Q.
Okay.
Okay?
Okay.
So now she fires her shot. Let's say she fires her shot in the middle of that. So if you can circle the middle.
Okay. That's a wide circle, but yes, sir.
Okay. So now you said that that shot would go, I think you said because it was held upside down, it would go left to right?
It would go toward the left there. It would go toward the K area, but from where this is circled at, that would be a significant distance. And like you indicated earlier, it's going to eject down into the ground because you've inverted the weapon. So it's going to eject downward very rapidly. So again, K is a great distance from where it would be if the shot's fired from in that area where I have circled. Correct.
Okay. So now I want you to draw a line.
Okay.
And what I'm going to ask you so we can put this in evidence is you're going to email this to me. I'm going to have it marked, and we're going to submit it as an exhibit, okay?
Okay.
You need to be able to send this to me, okay? So now
All right.
imagine she's at the blue pole where she begins, right?
Okay.
And then she fires towards Mr. Loyd.
Okay.
And show me the pattern of the ejection. If it's right at a 45-degree angle, where would it go?
In this area.
Okay. Now you're placing her body. Place her body where she is actually turned. She is turned in the direction of Mr. Loyd. She's not standing straight. She's turned.
Okay.
Okay. Where would it go?
Okay.
Where would it go?
You're saying if she's running like we're talking about?
Yeah, she's running and
I'm sorry. Okay, I'm sorry.
And
Sorry. Let me clear that then. Sorry, sir. I'm sorry. Okay, so yes, sir. I got you. Okay, so if she's running, then I'm sorry. My fault. Now it's not going to be exactly 45 degrees anymore because the gun's inverted.
Okay.
So if she's running and holding the gun rearward, it would eject somewhere in this area. You know, as she's running and the gun's upside down, it's going to eject backward and to the left here, but it's going to be very close. It's not going to be 45 anymore. It's going to be like a 30 degree, 25 degree. So somewhere in this area, very close to, as she's running along that line, because again, the gun's upside down. It's going to eject the cartridge case down into the ground there. So it's going to be very close to her as she's running.
so the bullets that are marked hers, HIQ, I want to make sure I'm correct. HIQ, G.
It's BC, DE, GH, IK, and then the Q. Yes, sir. I'm sorry. I see it right here. So all of those are hers.
Okay. So between the one that goes down and the one that goes over, that's your estimate when she's holding the gun and fires, if she fires, That's where the casing would end up in that direction.
That's where it would be. Yes, sir. It'd be on her left, very close to that path that she's running because the gun's inverted.
And so with that in mind, would HIQ, well, I don't want to get her bullets wrong. Would HI, we know Q is not part of that, G, E, all those would be within distance of where the casings are recovered.
Yes, sir. I mean, but see, she continues on that path as you're stating toward Q, and then when she gets to that area and she's shooting, yeah, that all makes sense. B, C, even the B and C are a little bit far from me, but again, they can bounce and roll, so that's fine. But the B, C, D, E, G, H, I, no problem. That's how the gun ejects, right in rear in normal fashion. The K, though, you can clearly see it is 15 to 20. It is a long distance from all the rest of these cartridge cases.
Okay, and you would agree with me, Judge, I'd move this into evidence. We have to have it emailed to us because of technology.
Mr. Boxman?
If they can just do a card for identification.
I'd like to be able to see it after it's printed out before I agree to that. It looks like
Yeah, I'm going to reserve on this just to see what we get from
Okay.
that on the email, okay?
Okay, thank you very much.
Sure.
Okay, the one other area I want to talk to you about is, have you been involved in scenes where there's a missing casing?
Yes, sir.
Okay, and you would agree with me that is important to know,
Sustain.
is it important to know where that casing is to determine where the gun was fired or the vicinity of?
Absolutely.
Those are all the questions I have, Judge.
All right, may this witness be excused? State,
Yes.
defense?
Yes.
State? No objection, Your Honor. All right, thank you so much, Mr. Robinson. You are free to go.
Thank you. Okay, one more question. So I'm gonna make a copy of this and email it to you, Mr. Linneman.
Yes,
Okay. Thank you.
thank you.
All right, folks, this seems like a good time to take your morning break, so why don't you all do that? Okay, let's take a 10-minute break. You can get your Zoom witness set up. All right, we're back on the record on State versus Loyd. He's present with his attorney. State Attorney's Office is present. Ready to go? Can't hear you.
We'd like to call Brian Savelli.
Same objection as before.
Yes, Your Honor.
I'm going to sustain the objection. I think it's hearsay. It's double and triple hearsay. It's already been testified to by Mr. Loyd. So, all right. Do you have any other witnesses? Mr. Lenneman, do you have any other witnesses? All right, so I'm going to let you rest in front of the jury. Let's bring him back up.
Judge will rest.
Hold on. I want you to do it in front of the jury.
Oh, and then can I have like 5 minutes to do put my JOA together?
Your JOA is after their rebuttal.
Oh, that's right. I'm sorry.
Yeah. So no, you can't. Let's bring the jury back in. State recognized present to the jury?
Yes, Your Honor.
Defense?
Yes.
All right. Welcome back, folks. Mr. Lenneman, you may call your next witness.
Judge, at this time, the defense rests.
All right. All right, ladies and gentlemen, the defense has rested their case. The state has an opportunity to put on a rebuttal case if they so choose. State, you may call your first witness.
State calls Ronald Stewart. Can you hear me, Mr. Stewart?
Yes, sir.
Your Honor, I recognize Mr. Stewart. Sorry.
Mr. Lenneman, you recognize him to be Mr. Stewart? Mr. Stewart, raise your right hand, please.
Raise your right hand, Mr.
Mr.
Stewart.
Stewart, can you hear me? This is Judge Marquez. Raise your right hand. Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
All right. You may inquire.
Can you please state your name for me, sir?
You can put your hand down.
My name is Ronald Allen Stewart Jr.
What do you do for a living?
I'm a software engineer.
And what state do you live in now?
Currently live in Texas.
Okay. Do you have a degree that lets you do software engineering?
No, I don't have a degree particularly for software engineering.
Understood. Let me direct your attention to December 13th of 2016. Where were you that evening?
I was at my mom's house.
And what was her address?
Address is 6031 Lone Peak Drive, Orlando, Florida.
Back then, how tall were you?
6'2".
What did you weigh?
Roughly around 180,
What's your
175.
What's your mom's name?
Stephanie Dixon Daniels.
What were you doing that night at your mom's house?
I was building out a web application.
What do you mean by that?
During the time, I wasn't doing trucking during that time. So I was doing projects and stuff for clients. So I was building out this one application for a client.
Okay. Repeat that one more time for me. I had the volume too high up.
No, I was just saying during that time, I wasn't doing trucking during that time.
and I was actually working on a web application for a client that I was working with.
Okay. Did you know Sade Dixon?
Yes,
What relationship was she to you?
she was my sister.
Do you know a man named Markeith Loyd?
Yes.
How do you know Markeith Loyd?
First, I met him as my sister introduced me to him as a personal trainer in my mom's house at the kitchen table. And then later on, they were boyfriend and girlfriend.
I'm showing you what's been marked as State's Exhibit BV for identification. Do you recognize this photograph?
Yes.
What does this show?
It shows the front of my mom's house.
Okay. Does this fairly and accurately depict what the front of your mom's house looked like on December 13th of 2016?
Yes.
This time, State would move BV into evidence as next in line.
Any objections? This will be received without objection as State's Exhibit number 62.
May I publish, Your Honor?
You may.
Do you have a copy of this same photograph I just showed you available for you to look at too?
Yes.
Okay. While you were working on this web application at your mom's house that night, where were you located in relation in the house?
When we first entered through the doorway, I was right past the stairway room, going to like a dining room kind of area. That was like my office / bedroom area during that time.
Sir.
Hold on, Ron, 1 second.
I'm sorry?
Okay, okay, hang tight, Ron. Okay, let me, I'm gonna ask you a question about the photograph. You said that you were in a room in the front of the house?
Yes.
Okay, and the room that we're looking at, is that the room to the direct right of the red front door on the far left of the photograph?
Yes.
Okay.
That window area, that would be where my room was.
Were you able to see the front yard from that room?
Yeah, I was able to see from the front yard, but I think during that time the blinds were closed. But yeah.
Did there come a time when Markeith Loyd arrived at your house that night?
Yes.
How'd you learn he was there?
He knocked on my window that night and asked if and then I went to the door and he asked if Sade can come out, so he talked.
All right, still having trouble with the volume for the court reporter, please?
Okay, I'm going to turn the volume even down a little bit more because there's a little bit of a feedback. So can you repeat your answer again? How did you know that Mr. Loyd was there?
So yeah, I knocked on the window of my room window, and for the most part, after he knocked on the window, I went to the door and he asked if Sade can come out to talk.
And was your sister Sade there at the time?
Yes, she was in the kitchen area during that time.
What did you do when he asked if Sade was there?
I closed the door and asked Sade if she, Markeith is out there.
Okay. And what did Sade do?
She went outside and that was it.
Okay. And while Sade was outside, what were you doing?
I just went back to my office desk near the window and just went back to building my application.
At some point, did Sade come back in the house?
Yes, she did.
About how long after she left the first time did she come back in the house?
Probably between 30 to 45 minutes, possibly.
Do you know if she left the house or what she was doing during that period of time?
No.
Okay. After Sade came back to the house, did she come inside?
Yes.
And what'd she do?
She went upstairs, and then like soon after, she went right back downstairs and went out the door.
Do you know what she did upstairs?
No.
Do you also have a younger brother named Dominique?
Yes.
At some point during this, did he come home?
Yes.
Do you remember about when he came home? Not the time, but in the sequence of events.
Yeah, I'm trying to remember, but it definitely is probably a little bit before my sister came back in, I want to say.
Okay. After your sister came back in the house, went upstairs, came back downstairs, and went outside, did you hear something that drew your attention towards the garage area?
Yes, there was a bang on the garage door, and I asked everyone in the house, did they hear that? And they said they didn't. So I actually went to the back garage door area near the kitchen area, and opened up the door, and yeah, I saw through the window Sade on one side and Markeith on the other side.
Okay, so you went through your kitchen door. Did you go actually into the garage where you could see in the garage?
I just opened the door and checked if it was like our dog who knocked on the door, and she looked kind of like freaked out.
Okay.
So I looked at her, and then I looked up, and it was a window near the garage door, so you can see through the window the two cars, and Charlotte was on the left side of the car, and Markeith was on the right hand side of the car, closest to the front door.
So as I'm assuming your garage door is closed at this time,
Yes.
but there are windows that you can see out into the driveway area through the garage door?
Yes.
Okay. And you said that your sister was on one side of the car and Mr. Loyd was on the other side?
Yes.
Which car are we talking about? We see two cars in the photograph. Which car?
It was the one closest to the front door
Okay, so the SUV type?
on the left-hand side.
Okay. And
Yeah.
looking at the photograph, your sister was on the passenger side of that car, am I correct?
Yes, that's correct.
And Markeith was on the driver's side.
Yes.
When you saw them in that position and you saw your sister looking freaked out, like you said, what did you do?
Yeah, she looked really scared. Her eyes were wide open. I immediately put on my shoes, put on a hoodie, and went outside the door.
And did you go out the red front door that we see in the photograph?
Yes, the front door, yes.
When you got outside and walked out the front door, where was your sister, Sade, and where was the defendant, or where was Mr. Loyd?
Mr. Loyd was still on the passenger side of the car, and my sister was on the, Mr. Loyd was on the driver's side of the car, and Charlie was on the passenger side.
When you walked out, did you say anything to anybody?
So, y'all good?
Okay, you said, are you all good? Is that what you said?
They said they're good.
Okay.
Well, it doesn't look like you guys, yeah.
Repeat that last thing you said, Mr. Stewart.
I said, are you guys doing good?
And did Mr. Loyd say anything in response?
Yeah, he said, yeah, we're doing good. We're just talking. And so it doesn't look like you guys doing much talking right now.
Okay. Did your sister say anything when you asked if they were good?
Yeah, she said, yeah, we're good. You know, you can go back inside.
Okay.
Yeah, and I didn't accept that answer.
Repeat that last thing again.
My sister said they were good and that I should go back inside.
Okay.
And I said, it doesn't look like you guys are good.
Okay. You said it doesn't look like you guys are good?
Yeah.
Okay. Did you stay where you were, or did you start to walk towards them?
Yeah, I was walking down the path, on the concrete path on the house, and then as I was walking, Markeith was moving towards the center of the driveway out towards the street, and then my sister was coming from the back of the passenger side of the car, on the back, on the left-hand side, the driver's side of the car, where she was standing a little bit behind me.
Okay. So as she is walking towards you, did you say anything else to them?
So I don't recall too much other than Markeith saying, yeah, I've been hearing that she's been smoking with my baby, and also definitely another dude with my baby. And then Sade said, "Why are you telling our business? And why, since you're telling our business, why you didn't tell them that you had two guns pointed to my head in the backyard?"
Okay. Was your sister pregnant at the time?
Yes.
All right. At any time during this conversation, did your sister say anything about you being able to whip Mr. Loyd's ass?
What's that again?
At any time during this conversation, did your sister Sade say anything about you being able to, quote, whip Mr. Loyd's ass?
Yes, she did say that. And I said, no, we're not going to be doing no fighting today.
Okay. After your sister said these things, did you do anything to try to end the situation or de-escalate what you saw happening?
Yes, I pretty much was telling that Sade should, walk inside. And 1 second. I told my sister she should walk inside the house, and Markeith should go away in his car. Yeah, I need to talk about this another day, because this is not a situation that we need to be talking about right now, today.
How did Mr. Loyd respond to that?
Me and my sister started walking towards the door when I told her to go inside, and then Mr. Loyd was saying, no, she ain't going nowhere. I'm talking about this today.
Okay. What did your sister do?
She stopped, and she was really frightened during that time.
At some point around this time, did you see your sister start moving quickly towards the house?
Yeah, it was, at some time, when he was still talking and stuff like that. And after he said, no, she's not going nowhere. I do remember my sister running, but I didn't see her running right away. I saw Markeith running, and I looked behind me, and she wasn't there no more. And I seen on the other side of me that she was running towards the door, so I started running right behind her.
Again, down that path towards that red door that we see in the photograph?
Yes, going inside the pillar.
What happened when you got to the door?
The door seemed to be locked. She was banging on the door, and I stood in front of her from the door, and seeing Markeith pull out the gun from his jacket and cocked it back. And then I told him, "Yo, it's not that serious, bro." And then I heard a pop, and then I fell uncontrollably to the floor.
Let me stop you there.
And yeah.
Okay. Where was Mr. Loyd standing when you saw him first with the gun and him cock the gun?
Just like in the middle of the yard.
Okay. About how far away was he from you and your sister?
I'd say approximately 10 to 12 feet, I'm going to say, or more.
After you saw Mr. Loyd raise the gun, you said you heard a pop?
Yeah.
And what happened after you heard that pop?
I fell down. I started hearing ringing in my ears, fell down on the floor, couldn't move my body, and all my limbs just locked up. I couldn't actually get down to on the left side of my body.
What was the last thing you said, the last phrase?
Yo, bro, it's not that serious.
No, what, the answer to the last question, you felt you couldn't control the limbs of your body? What else did you say?
Yeah, I fell down on the left side of my body.
Were you still conscious and aware of what was happening after you fell?
Yes.
Okay. Did you?
The ringing wouldn't work. Yeah, I'll go for it.
Did you eventually figure out what caused you to fall to the ground?
Yeah.
What?
Meaning that it definitely was a bullet. Felt like someone kicked me in the stomach. And I continued to hear like more popping, come closer and closer, and more stuff like hitting my face as the popping is going. It felt like rocks or something. But yeah, I kept continuing to hear him pop, shoot a gun, and kept on going, weaving in towards the right side of the pillar, where he came down the inside of the pillar, and continued to shoot her. Yep.
After you were shot in the stomach initially and fell to the ground, do you know where your sister Sade was?
She actually ran towards me, shaking me.
She came towards you, you said?
Telling me to get up. Hello?
She came towards you, you said?
Yeah, she ran towards me outside the pillar.
All right. And at this point, you're on the ground, shot. Where are you located in the photograph that the jury's looking at?
I'm like towards the middle doorway on the right hand side of the doorway, on the right, on the pillar side, on the right pillar side.
Okay, so we see two pillars, and in between is the red door. You're more towards the right pillar next to the door?
Yes.
Okay. After you go down, your sister comes to your side. Do you hear additional gunshots?
Yeah, more gunshots, popping, and I'm just seeing him run towards the right-hand side of the pillar, more and more.
You said, did Mr. Loyd run to the right side of the pillar?
Yeah, Mr. Loyd run right towards us.
Repeat that last line.
Yeah, Mr. Loyd running to the right-hand side of the pillar, and continue shooting.
Okay. Did Mr. Loyd eventually come onto the concrete stoop where you were on the ground and your sister was next to you?
Yes, he came through the side that we ran towards initially, and was continuing to shoot my sister, and he stepped over me during that time.
After did he at some point step over you? Did he step over you?
Yeah.
Okay. After he stepped over you,
And
hold on. After he stepped over you, did he, and continued to shoot, did he turn his attention to you again?
yeah, he was shooting my sister, and then he stopped, and then came towards me and pointed the gun at me. It seemed like he was pointing at my heart, and I tried to rotate my body to the left so he doesn't hit it. But he just continued to shoot upwards, hitting my leg, and then hitting more parts of my body, and also hitting my chest.
How many times did Mr. Loyd shoot you?
Roughly around 5 times.
About 5 times, did you say?
Yeah.
Do you remember where in your body you were struck?
My left leg, my right leg, my arm, my abdominal, and also in my heart.
After you were shot, at some point, did you hear the front door of your house open?
Yes. Yeah, the front door did open. And then it immediately shut and slammed. And by that time, Markeith had started running towards the car, and still more shots coming in the door.
Did those shots that Mr. Loyd fired as he was heading towards his car actually strike the door in the side of the house?
I believe so. He was firing towards the doorway.
In the photograph I showed you, that we're looking at, which direction was Mr. Loyd's car?
It was pretty much like in the front of the house. Right in front of the house on the curb.
If you're facing your house, would it be directly in front of the house, to the right, or to the left?
Directly in front of the house. What did he say?
At some point, were you able to tell that Mr. Loyd left?
Yes. He left. He pretty much like ran in front of his car and got inside passenger seat, the driver's seat, and he left, went down the street. The only thing I saw was tail lights after that.
What was the last thing you said?
The only thing I saw was tail lights after that.
Okay, you saw tail lights. Okay.
No.
Were you taken to the hospital?
Yes.
How long did you stay there?
Over a month.
Did you have surgeries?
Yes.
Okay. Did your sister own a firearm?
Yes.
Had you seen it before?
Yeah, I've seen it once before the incident. Yeah.
When did you see it in relation to your sister's murder?
It had to be like 2 months or past or so. Okay. Before my sister. Yeah, it was in an iPad box, but I want to say it was roughly like 2 months before.
You said it was in a box?
Yeah, iPad box.
What were the circumstances in which you saw that gun?
She wanted to know how I can take out the magazine, and I told her I didn't know how to do that.
Okay. Except for the gun that you saw Mr. Loyd pull out and use to shoot you and your sister, did you ever see any other guns that night?
I didn't see no other guns that night.
Okay. I don't have any other questions for you, Mr. Loyd. If you want to stay on the line, the defense lawyer is going to ask you some questions, okay? Thank you, sir.
How you doing, sir?
I'm really good. How are you?
Did you ever tell anybody that Markeith came to your house and banged on your door and Sade answered and Markeith gunned her down and you came to the door and he shot you?
Say it again. I can't hear you.
Where's the microphone? Where's the microphone on this so you can't hear me? Can you hear me now?
Yeah, I can hear you.
Okay. Did you ever tell anybody that Markeith came to your house, banged on your door, Sade answered, and Markeith gunned her down, and you came to the door and he shot you?
No.
So if that's something the detectives put out, then it wouldn't have come from you.
I mean, it's a kind of weird sequence, but I mean, yeah, doesn't sound right.
You would agree with me, sir, that this event was very traumatic for you?
Very much, yes.
And during that period of time, shortly after you got to the hospital, you found out that your sister was deceased?
Yes.
And
I was going to say a little after.
okay.
Yeah.
And the detectives, when they came to talk to you, asked you numerous times if you had attacked Markeith, didn't they?
Yes.
And you kept denying it, right?
Pretty much, yeah. I didn't attack him.
Excuse me?
I did not attack him.
So when you say pretty much you didn't attack him, what does that mean?
I said I did not. Well, meaning to be exact, it's just I did not attack him.
Okay. And if you had attacked him, then you would agree with me that your sister's death may be in part to the actions you had committed?
Objection, Your Honor. Calls for speculation of something he said didn't happen.
Sustained.
And the two detectives that came to talk to you were Detective Savelli and Detective Garcia-Pagan. Remember that?
Say it again?
The detectives that came to see you were Detective Savelli and Detective Pagan. Correct? Garcia-Pagan?
I would say those names definitely sound familiar. I can't remember to this day, but it sounds familiar.
And they actually took two statements from you, didn't they?
I believe so.
And in the first one, you had given us some information about Markeith, but when they asked you why this happened, you told them you didn't want to talk about it. Remember that?
I can't remember exactly, but what was the context behind that?
Well, let's start with this. Did the prosecutor tell you to make sure you had all your statements, your deposition, and your trial testimony nearby?
Yes. And I do.
You have that?
Yeah.
And so in this first statement, that's when you tell them that you don't want to talk about it.
What page is it?
I think it's towards the end. I don't have the date. What date is that statement given, Mr. Stewart?
It says May 16.
Thank you. Yeah, thanks.
Yeah.
Did you send him both statements? Because he has two.
Yeah, I'm trying to look at the other one.
Do you have two in front of you?
Yeah. I do see Detective Savelli and Detective Garcia on here, and that was December 15th.
Okay. And you told them that you didn't want to talk about it, right?
What page is that?
I said, I think it's towards the end.
Is it page 19?
Is that the page?
Give you a number at the bottom. It doesn't have like a 241 on it or 242.
Did you find it? I'm sorry.
I didn't find it. I'm still looking for it.
I think it's page 6,
But
line.
is there a number?
I think it's page 6, line 18.
Page 6, line 18.
I think that's the page on the first statement. Were you given a first statement to review? How much-
Yeah, I was given a first aid.
So you have 2 statements that you gave, right?
Yes. I'm still not seeing the page or the item that you're seeing.
Yeah, that's it. Okay. Apparently, that statement wasn't that statement wasn't recorded. It was the actual recording. Do you remember specifically not wanting to talk to them about it the first time that they talked to you?
Can't remember exactly. Maybe I was probably in the hospital on heavy drugs. So maybe that's probably the context behind why I didn't want to talk about it the first time.
Okay. But do you have an independent memory of telling them that you didn't want to talk about it when they asked you why you think this happened?
I don't recall exactly.
Now, you said that you never saw her with a gun. Is that right?
I never seen her with a that night.
But you knew she owned a gun, right?
Yes.
And as a matter of fact, you knew it was recovered in the yard where the shooting took place, right?
It was probably like months past or something. Like, yeah, it was recovered in the yard.
But you found that out, correct?
It was after the whole incident.
Okay.
Way
that's fine.
after.
So, but you did find out that that gun was recovered by the police in the yard.
Yes.
Is that right?
Yes.
Now, you mentioned that during this conversation with Markeith and you, your sister stated to Markeith that my brother can whip your ass.
Yeah, she did say
She was
that.
saying other stuff too, right?
What's that again?
Other stuff too.
No, just probably she stated that I can whip his behind.
Well, isn't it true that your sister stated that my brother can whip your ass and stuff like that?
Yeah, probably like that. Yeah, but
Why don't
just that.
Do you have your trial testimony in front of you?
Trial testimony? I don't think so.
Yeah. The prosecutor's saying you have it. You should have it.
Okay.
It's like in the 2800s. And I'm looking specifically at 2841.
24. Okay, and do you know what page that is?
2841 at the top. It's like the first question at the top.
First question at the top. It's 2841.
Yeah. You want to see the question and then your answer?
Okay.
Do you want me just to read it to you?
Yes, please.
Okay. So the question I'm asking you, and this was at the trial of Mr. Loyd in 2019. Question, while you were out there during this confrontation, your sister stated to Markeith that my brother can whip your ass and stuff like that. Isn't that right? And your answer was, oh yeah, yes. Is that correct?
Okay. And they also stated that that's not going to happen today.
I'm sorry?
Also, like, they also state that that wasn't going to happen today, saying that maybe, but that wasn't going to happen today.
I'm not understanding you, Mr. Stewart. First of all,
I'm saying, like, is there more to that?
I'm reading you. I'll read you before that, okay?
Mm-hmm.
Your question about having omitted your
Sustained.
isn't it true that you omitted? No, this is a
Sustained.
predicate question, Judge.
You need to proceed to rephrase.
Did you
that.
ever not tell the prosecutor?
Sustained.
What? Did you have contact with law enforcement, Mr. Loyd?
What's it again?
I'm sorry, Mr. Stewart. Did you have contact with law enforcement right after this happened?
After I got shot.
I'm sorry, what?
I'm objecting to the form of the question. At what point?
Yeah.
While you were at hospital and after that, did you have contact with law enforcement?
So after I got out of the hospital,
Well, let's talk about while you were in the hospital. Did you ever tell the police that your sister stated to Mr. Loyd that my brother can whip your ass and stuff like that?
it's possible, but I don't know if that was in the statement.
So on the night of this incident, you were at your mother's house and trying to get some stuff done, correct?
Yeah,
And you knew that Markeith was the boyfriend of your sister Sade.
yeah,
They had been together about 3 months,
roughly around there.
and she was 2 months pregnant.
I believe so. Not exactly sure.
And so when Markeith came to the door, he tapped on the window and he did a little light flash. Isn't that right?
Yeah, I think it was with his phone.
Okay. And you told your sister that Markeith was outside. Is that right?
Yeah,
And then you went back to working.
yes,
And as you testified, the first time you became concerned was when you heard what you thought was the dog in the garage, correct?
yeah.
And you had stated on direct examination that you thought it was maybe a bump that your dog made against the garage, correct?
Yeah, it was like a loud bump that I heard that I mentioned to my family. Did they hear that?
And after that, after you heard that bump, your sister came back inside.
No,
It was before the bump.
it was before the bump.
Okay, so she came back inside, she went upstairs, and then she came back downstairs and went outside, correct?
Mm-hmm. Yes.
And you said it was about 10 minutes. And at that point, you thought it was a little louder than what the dog makes. Is that right?
Yeah.
And so you decided to go outside to check on your sister, right?
No, not right away. I went to the garage door, and opened it and checked on my dog to see if it was her. She was freaking out. Yeah, I seen in the window of the garage my sister on the passenger side of the vehicle and Markeith on the driver's side of the vehicle.
And you certainly didn't know what happened before
And her
that.
eyes are wide.
You didn't?
Hello?
Go ahead.
Say it again.
Yeah,
No, go for it.
all right. So at that point, when you looked out, before then, you didn't know what kind of communications they had?
No, I didn't know.
You didn't know what they were discussing?
It didn't look like they were discussing anything during that time.
You didn't know what had occurred between the two of them?
I did not know. I just seen that her eyes were wide open, scared.
Okay, but you knew that Markeith probably took the gun away from her.
I didn't know none of that at all.
Okay, I want you to look at your statement. It's dated 12/15/2016, Ronald Stewart. You have that in front of you?
Is this December, we said?
Yeah, December. And it's going to be on page 10.
Page 10.
Page 10, lines 20 through 25.
So, I mean, during that time, I didn't know Sade had a gun at all. So, I think probably before all of this, they probably mentioned, did you know Sade had a gun? And I said, yeah. Did she have a gun that night? I said I didn't know.
But you said also,
So,
what else did
I
you
think
say?
probably,
What else do you say in that
go for it.
conversation? What else do you say in that conversation with the police?
Yeah, I see it on line 23. It wasn't out. I believe he probably took the gun away from her.
And then do the police ask you, did you ever try to take Markeith's gun?
I believe so. Did you ever try to? Yes. And I said no.
But when you were talking to them on that date, you knew that she had a gun, correct?
I did not know she had a gun. Oh, well, I did know she had a gun, but I didn't see a gun that night. I didn't see her gun that night.
Okay. And so at some point you decide to go outside, correct?
Yeah, I put on my shoes, I had to check in the garage, and then I went outside through the front door.
And in your mind, you're alerted to that there's something going on out there, in your mind. Is that right?
Yeah.
And you put your shoes on,
Yeah.
and you walk to the front door,
Yeah.
and you open the front door,
Yes.
and you close the front door,
Yes.
and the door is not locked when you close it.
I don't
I'm sorry?
remember the door being locked.
So would your statement refresh your recollection?
Yeah, that'd be great.
Okay. So I want you to look at page 2846 of your trial testimony at the very bottom and read that and let me know when you're done.
bottom.
Yeah, it's line 23 through 25.
At the very bottom, like
On page,
on page 109.
no, page 2846 of your trial testimony.
I don't see it. Page 2846.
Did you give him his trial testimony? Does he have a different numbering system? I'm not impeaching him, I'm refreshing his recollection. Okay. Mr. Stewart, are you there, sir?
Yes.
Okay. First of all, do you have the trial testimony in front of you? It would be in the 2800s.
I have 113 pages here.
The prosecutor said he sent you the testimony on,
I do have the trial testimony, but it's not labeled how you have yours labeled.
well, does it have a page 2846?
I only see on the right, top right-hand side, numbers 1, 2, 3. I don't see 24 or 26 at all.
Then that's not the trial testimony, sir. Would you like me to read it to you to see if it refreshes your recollection?
Yeah, I definitely want to see the page for sure, but you can definitely read it for me so I can know
Well, the prosecutor has a copy.
context.
Yeah, so the prosecutor has a copy, and if he thinks I'm doing something improper, he'll make an objection, okay?
All right.
And can I read the context a couple before? Okay. And I'm asking you the questions, and you walk to the front door, isn't that right? And your response is yes. And you open the front door, yes. And you walk outside the front door, yes. And you close the door behind you, yes. And it's not locked because two of you are outside now, isn't that right? And you answer yes. Did that refresh your memory?
Yeah.
So the door was open.
Yeah, it seemed to be open during that night.
Now, you are concerned that you're going outside because you're concerned about your sister, is that right?
Yes.
And you don't tell anybody you're going outside, right?
Yeah, I don't remember telling anyone.
But based on your observation of what you see through the garage, you believe that she is afraid of something, is that right?
Yes.
Now, later on, just so we're clear, she tells you to go back inside, leave them alone, it's none of your business, all those things, right?
Yeah, I was just telling me to go inside.
And she said, leave us alone, right?
I think she should have said, we're good.
I'm sorry?
I think she said, we're good.
Okay. And before she says that, you asked, is everything okay?
Yes.
And Markeith said they are chilling, right?
Yes.
Just talking.
Yes.
And while you're out there, there's this interaction that's taking place between the two of them. Right?
No. I mean, as soon as I came out there. So, why are you saying, like, what context are you saying that in?
Well, you already admitted that your sister told you to go back inside, right?
Yeah.
And Markeith said, we're just chilling, right?
Yes.
But in your mind, you believe that, this is out of control, this needs to end. You're trying to, be the good big brother and quash any possible issues that occur, right?
Yeah, seemed like this situation was wrong, right?
And you were saying we need to end this and come back another day, that kind of stuff.
Yes.
And you noticed while you were talking that Markeith had his hand in his pocket and he's being kind of fidgety, right?
Yes.
And he pulled out that hand from that pocket and started trying to offer you an explanation of what they're dealing with. Isn't that right?
Yes.
And he's saying to you that she's smoking pot, smoking weed, she's pregnant, right?
And effing this dude, yeah.
She didn't hear you, Ron. Did you?
And effing this dude.
And you know that your mom doesn't like Markeith, right?
Yes.
Even though Markeith would come over the house on occasion, right?
Yeah, at first it was on occasions, and then she wasn't allowed to come inside, but yeah.
And so you were aware that there was friction between your mother and Markeith.
Yeah.
And you were aware that just prior to that, your sister had been living with Markeith in a house. Is that right?
I wouldn't call it living. I was probably say spending a night.
Okay. So was your impression that she was only spending a night?
Yeah.
Okay. And it's your belief that she, in the last 2 months prior to that, was living with your mom at the house?
For the most part, yeah.
And you tell him at some point when he's telling you about that she's smoking weed, and you said that he mentions about effing another dude.
Yeah.
He's actually saying to you that she has his baby and wants to get an abortion, and they were talking about that.
I don't recall.
So you don't recall any talk about an abortion?
I don't recall.
But your goal...
not right now.
Okay, I'm sorry. Your goal is you're trying to diffuse this situation, isn't that right?
Yes. And have my sister go inside and have them go in this car and go back home.
Okay. And so while they're having this situation, this conversation between them, she brings up that Markeith has 2 guns that he pointed at her. Isn't that right?
Yeah, she mentioned that, since you're telling our business, why you mentioned you had 2 guns pointing to my head in the back of the yard.
So she's talking to him now. She's saying, why you bringing out our business, why don't you tell him about the 2 guns that were pointed at her on the side of the house? She says that to you, right?
Yes.
But she doesn't mention the fact that she went upstairs, got a gun, went to the side of the house, and pointed that gun at Mr. Loyd. There's no conversation about that, right?
There's no conversation about that day.
And you find that out later, right?
I can't, I don't recall.
Sustained.
And so at that point, you have a real heightened awareness that Mr. Loyd has 2 guns and that he apparently, according to your sister, had pointed them at her, correct? For no reason.
Sustained.
That's what I heard.
And so at that point, you are super concerned about this continuing on. Isn't that right?
Yeah, trying to just escalate the situation, and like I said, try to have them part ways and talk about this another time.
And so it's your claim that you tell your sister to go inside. Is that right?
Yes.
And the door was open, so she could have went inside, right?
Not when I saw her run to the door and she leaned on it and she couldn't open the door. So
So it's your
it
testimony.
wasn't open when we ran to the door.
So it's your testimony that between the time that you came out, which was minutes, and the time that this thing happened, the door happened to be locked. Is that your testimony?
I believe so, yes. Actually, I don't believe so. Say it one more time.
It's your testimony that when you left your house, you left the door open, and that between the time that you left the house and this interaction blew up between you and Mr. Loyd, that the door had become locked somehow.
Yeah, I believe it was locked.
Okay. Now, at this point, besides knowing that Mr. Loyd has guns, he has a hand in a pocket, maybe holding a gun up in his shirt. You know he's got 2 guns, and you're really concerned.
Yeah, I knew guns were in the area.
And even though Mr. Loyd and your sister Sade had said to you to go inside, your focus was on protecting your sister. Isn't that right?
Yeah, trying to have her go inside, yes.
So while you're standing there in the minute or more, because while this is going on, you're conversing back and forth with Mr. Loyd, right?
Yes.
So while you're standing there, becoming aware of the dangerous situation that is unfolding, your belief of an escalation becomes very heightened.
Belief in exhalation.
Yeah, you're thinking, maybe I should go after him. Maybe I should tackle him. Maybe I should do something to protect my sister. Isn't that right?
No.
So that never crossed your mind?
Never.
And it's your claim that Mr. Loyd, who had just broken up with your sister and only cared about his child, just went off and started shooting for no reason.
I didn't know they broke up during that time at all.
Okay. But you found that out later, right?
I don't recall.
Okay. And Mr. Loyd just out of nowhere started shooting, right?
No, he didn't start shooting right away. It was after we ran to the door, me and Sade, and she was banging on the door. I was standing in front of the door when he stood in the middle of the yard, cocked the gun back to put one in the chamber and pop one off in my stomach.
So you were at the door?
I was at the door with my sister.
Okay, so you would have been kind of shielding your sister, right?
Say it again.
You would have been shielding your sister, right?
Yeah, I stood in front of her with my hands up, saying it's not that serious, bro.
Now, you remember that no one in your family told the police that they locked the door.
Sustained.
Did you hear Mr. Loyd at any point say, "What the fuck"?
I don't recall that.
That sounds like a response to somebody who's being attacked.
Sustained.
Your brother Dominique was inside, right?
Yes,
He gave statement to the police, right?
I believe so, yes.
He told them what he had heard and... I'm not impeaching him, Judge.
Sustained on hearsay.
You wanted to do everything you could for your sister.
Yes,
You love her very much.
very much.
And you did everything you could.
I believe so.
I have no further questions.
Thank you, Mr. Werner. Mr. Loyd, settle down. Cross, or redirect, sorry.
No, Judge, I'm not done. Where in this testimony? Where in this testimony? Sir, when you were answering questions from Mr. Buxman, you had said that you didn't find out about the gun until months later. Remember that?
It's a while. It had to be a while back. While past, I believe.
No, what I'm saying is today you said it was several months before you found out about the gun when Mr. Buxman was asking you questions. Is that right?
I would say that product statement is probably incorrect because during my deposition with the police, I believe there was a mention of Sade's gun, and yeah, I think that statement was probably not right.
So the statement today was not right?
I believe so because after reading the deposition today again, I believe it was a little after the incident in which the gun was mentioned of Sade's gun.
Well, you actually had a conversation 2 days after this incident with the police where you talk about Markeith taking the gun from her. You remember that?
I believe I said she probably took it away from him, and there's probably some context behind that. Because I didn't know there was any guns. I didn't know her gun was out there at all.
Now, today, you talked about that you and your sister were running towards the door, right?
Yes.
But you had said earlier that you were walking towards the door. Isn't that right?
I don't remember walking towards the door. Definitely running towards the door.
So you never said that. Is that right?
I don't recall walking towards the door at all. If I did say that, I was wrong.
Okay. It was a mistake. Is that right?
Yes.
One moment, Judge. I have no further questions, Judge.
State, redirect? No other questions, Your Honor. All right. Thank you, Mr. Stewart. You are free to go.
Thank you, sir.
All right, ladies and gentlemen, this is a good time to break. Your lunch is here. Enjoy your lunch. We'll see you afterwards. We're going to come back at 1:45. Thanks. All right, folks, see everybody after lunch. Court's in recess, 1:45. All right, we're back on the record on State versus Lloyd. Who's present with his attorney. State Attorney's Office is present. We're ready to go?
We're ready to proceed, Judge, but we do need, I would ask to approach before the first witness is called
All right,
to
come on
avoid a
up.
later break.
All right, let's bring the jury back in. State recognize presence of the jury?
We do, Your Honor.
Defense? All right, State, you may call your next witness.
State calls Dr. Michael Gamache.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Have a seat, sir.
Thank you.
You may inquire.
Thank you, Your Honor. Sir, could you please tell us your full name and spell your last name?
It's Michael Gamache, Gamache.
And where are you currently employed, sir?
I'm self-employed. I'm a forensic psychologist and forensic neuropsychologist.
And how long have you been a forensic psychologist and neuropsychologist?
In Florida, I've been licensed to practice, and I've been doing that kind of practice for 35 years. But I started seeing people originally. I am.
Okay. Can you tell us what you do on a day-to-day basis as a self-employed forensic psychologist and neuropsychologist?
Most of what I do, the vast majority of what I do is legal cases. Most of them are criminal cases. So forensic is simply a fancy term to say that it's the practice of psychology as applied to legal issues. And most of my practice is criminal cases, especially very serious crimes, sex crimes, and violent crimes. But I also do civil cases and some consulting work of another kind or a different nature.
Now, you alluded to it, but what type of professional work did you do prior to your own practice? If you could just take us through your professional experience.
Sure.
Prior to that.
Sure. So I earned a bachelor's degree in psychology from St. Louis University. I was awarded a National Institute of Mental Health scholarship to pursue a doctoral degree, a PhD in clinical psychology at the University of Missouri, Columbia. I completed those graduate studies, and then I did specialized training in clinical neuropsychology at the University of Florida, Shands Hospital in Gainesville. When I finished all of those things, I decided to pursue a career in research and science of psychology and neuropsychology. And my first job after completing that was as a new faculty member at the University of South Florida. I was an assistant professor in the Department of Law and Mental Health. And then I was also subsequently appointed as an adjunct professor in the Department of Neurology at the College of Medicine. And so I spent about 3 years there on a full-time basis. I wrote several grants, did research, did training for mental health professionals around the state of Florida. And during that time frame, I had started beginning to accept private cases after hours, and that's when I got involved directly in forensic clinical work. I applied for and was accepted to the board of expert examiners in the 13th Circuit, which is in Tampa, Hillsborough County, and I started conducting court-ordered evaluations.
Doctor, you mentioned earlier that you're licensed in the state of Florida. What do you have to do to become licensed as a psychologist in the state of Florida?
It's changed a little bit since I was licensed. It's been some time ago, but at the time that I was licensed, it was largely the same. You had to complete a doctoral level program that was approved by the American Psychological Association. The APA became the accrediting agency for the applied practice of psychology. So clinical psychology involves issues of mental illness, and the University of Missouri had been accredited by the APA for many years before I was a graduate student there. But that's the first requirement. The second requirement is that you complete a minimum of a year of postdoctoral supervised training. I did that, and then you sit for a written examination, and I did that and was awarded my license.
Do you have to renew your license ever, or is it good for life?
Well, every 2 years it has to be renewed, and part of the renewal process involves proving that you have, I have to complete 20 hours a year of continuing education. So by now I have about 800 hours of continuing education. That's all education and courses that I've taken to meet the requirements since I became a licensed psychologist.
What privileges as a professional do you gain from being licensed in the state of Florida? What can you do with that an unlicensed person cannot do?
I guess privileges is one way of putting it. The licensure in Florida relates to the practice, both the practice of psychology and the use of the title psychologist. So you cannot say that you cannot represent to the public that you're a psychologist unless you are in fact licensed as a psychologist in the state of Florida. But the law, basically, it's chapter 490 of Florida statutes. It explains that the licensure is to protect the public. The state of Florida recognized that mental health problems are a serious problem, and that people in Florida that have mental health problems need help for those problems. They need competent evaluations and treatment. And so the state of Florida, like most states, has taken it upon itself to regulate the profession.
So earlier you told us that the overwhelming majority of your work is forensic work.
Correct.
And that the majority of that work is criminal in nature, correct?
That is correct.
Can you give us an overview of what your forensic work in criminal cases consists of? What types of cases you look at?
Well, in terms of the type of charges, as I mentioned, it's over the course of 35 years, I've done every kind of case you can imagine, from misdemeanors to the most serious felony cases. Most of what I do now is strictly serious felony cases, and those are predominantly violent crimes, homicides, aggravated batteries, sexual crimes. And my involvement can be at any stage of the case.
So would that include evaluating individuals for sanity under the law?
Yes, absolutely.
Would it also include competency?
Absolutely.
And would it also include looking at potential aggravators or mitigation in capital cases?
Yes, that is another area where psychological science has some application.
So have you had an opportunity within the last year or two to look at the number of criminal forensic cases that you've worked to sort of see, how often you testify on behalf of the defendants or criminal defendants on behalf of the state?
Yes, I did have the opportunity to do that. I did it specifically to respond to a question during a deposition, or I knew that that was going to be a question, so I got together with my assistant. We don't keep a database of that, but in order to be able to be responsive during the deposition, we just calculated like the last 150 cases that I either had pending or that I had completed.
And can you tell the members of the jury what your split between state and defense has been over the course of those last year or two?
It was 52% of the cases I'd been retained by defense attorneys, and 48% I'd been retained by prosecutors.
Now, have there been occasions during your forensic career where you reached an opinion after being hired as an expert by the state that was unfavorable to the state's position or their prosecution?
There have been a number of times, whether I'm hired by the defense or hired by the state, that my opinion is not perceived as necessarily supporting the posture of that party.
In fact, can you tell us about the first post-COVID case that you recently testified in, and if it fit that description?
Well, in that case, I was retained by the defense, and I testified at a jury trial with regard to the issue of insanity or sanity at the time of the offense. I can't keep all of these cases in mind, but that one is distinctive to me because it was the first time I had testified in person again in front of a jury since the onset of COVID.
Now, have you previously been asked to provide opinion testimony to a jury in the field of forensic psychology or forensic neuropsychology in the past?
Yes, I have.
And do you know approximately how many times you've provided such opinion testimony within the courts of the state of Florida?
I do not have an exact number. I can try and give you an estimate. Again, I've been doing this for 35 years. I didn't testify quite as often in the first few years of my career, but on average, it's about 60 to 75 times per year, sometimes more than that, sometimes less than that.
Has there ever been an occasion where you were asked to provide opinion testimony but were not permitted to do so because your qualifications were not sufficient?
No, I'm grateful. Every single time I've appeared to testify, I've been determined to be qualified to offer an expert opinion.
And you have been previously retained by the Fifth Circuit of the state of Florida, and specifically myself, on other cases besides this case. Is that right?
Yes, you or other prosecutors in the Fifth Circuit have retained me before.
Now, your work in this case, State of Florida versus Markeith Loyd, came at our request. Is that the state attorney's office? Is that right?
That is correct.
Now, we asked you specifically to evaluate the testimony of a defense expert, Dr. Toomer. Is that right?
That's correct. You asked me to consult with you and the state regarding his testimony and his opinions.
And how much do you charge per hour for the forensic work that you do?
$250 an hour.
And do you know approximately how much you've billed the Office of the State Attorney up to today for your work in this case?
I don't know up till today, but up to the mid-October, I had billed for 80 hours or thereabouts. I started working on the case in November 2019, and so before my deposition with Mr. Lenneman, I'd gotten together with my assistant, and we'd figured out how many hours I'd billed for already.
Now, I specifically asked you about your role in evaluating Dr. Toomer's testimony. Can you explain to members of the jury how your role or what the work you do changes depending upon the type of opinion you're being asked to give in a criminal case?
Sure, yeah, it seems like a subtle distinction, but it is useful to know about. So if I'm hired by a defense attorney and the referral question from the defense attorney is, you know, my client is charged with such and such, and I'm concerned about whether he might have a defense or she might have a defense of insanity. When I'm hired by the defense and I start reviewing the records, and if I evaluate the defendant, I'm in the position of generating hypotheses. In other words, I'm coming into the case fresh. Nobody else is necessarily given an opinion. I'm going to review everything there is, and I'm going to consult with that defense attorney. I'm going to generate hypotheses, and I'm going to consider those hypotheses in relation to the legal question in the case and share my opinion with the defense attorney. By contrast, when I'm hired by the state, I'm not, and when I'm hired in the state in particular in an issue of insanity at the time of the offense, I'm not so much generating hypotheses, but instead I'm testing hypotheses that have already been generated. So in this particular case, when I was retained by the state, the defense and the defense expert, specifically Dr. Toomer, had generated some hypotheses. And when I agreed to be retained, it was for the purpose of testing those hypotheses. So my agreement with the state is I'm going to look at anything and everything that is potentially important. I'm going to look in particular, of course, very carefully at Dr. Toomer's work and his opinion. And I'll tell you honestly and truthfully whether I think it's supported
or sustained.
I will tell you whether I think it is supported or it is not supported. And that's exactly what I did in this case.
Did you, therefore, have a chance to review the deposition that the state took of Dr. Toomer prior to your testimony today?
Yes, I did.
Did you also, just this weekend, have an opportunity to review Dr. Toomer's testimony from the witness stand in this case.
Yes, I did.
Could you tell the members of the jury, and if you want to use some general terms to describe, because there's a lot of documents, what other materials you reviewed in preparing for your testimony and reaching an opinion in this case?
There was a massive amount of material, but I'll try and just give you the categories. The categories included the discovery, the police reports and related documents, legal documents pertaining to this particular case. The discovery, the legal documents pertaining to the case of Ms. Dixon. It included the reports in many instances and the testimony in many other instances of various expert witnesses that have previously that testified at the previous trial, that evaluated Mr. Loyd. It included transcripts of testimony of lay witnesses. It included medical records and psychological or psychiatric records pertaining to Mr. Loyd. It included jail and prison records. It included some raw test data from evaluations that had been done previously, including the evaluation by Dr. Toomer. I think I've covered the major areas. I may have forgotten a couple. I can look back and be more specific if necessary.
No, sir, I think you covered it. Did you also conduct an interview with the defendant, Markeith Loyd?
Yes, I did.
And that occurred on September 10th of this year, is that right?
It did.
Was it video recorded?
It was, the entire thing.
So was you previously, well, do you know if Dr. Toomer did an interview with Mr. Loyd?
I understand that he did.
Was that video recorded to your knowledge?
I understand that it was not.
Do you know how do you know what Dr. Toomer heard from Mr. Loyd during his evaluation?
The sources for that would be three off the top of my head. One would be that Dr. Toomer either provided directly to the state and they provided it to me, or Dr. Toomer provided it directly. I don't recall as I sit here today. Notes from that were purported to be from his examination. I read Dr. Toomer's deposition taken by the state where he was questioned about the examination or the examinations, and the third source would be his testimony.
Now, do you agree with Dr. Toomer's conclusion that Mr. Loyd was insane at the time that he killed Lieutenant Clayton? Just generally, and then we'll talk more specifically.
No, I don't.
Now, could you inform the members of the jury what the legal criteria for insanity are within the state of Florida? And before you do that, would a diagram help you do so?
Sure.
And may I approach the witness to what's been marked and shown to defense counsel as State's Exhibit BU?
You may.
Dr. Gamache, I'm handing you what's been marked as State's Exhibit, or I'm going to show it to you. BU, do you recognize that?
Yes, I do.
And how do you recognize it?
It's an exhibit that I have prepared for use and application in insanity cases.
Does it, in your training and experience, accurately represent sort of a roadmap of the law of insanity within the state of Florida?
It does. I've found it useful.
And at this time, I'd ask the court to admit State's Exhibit BU as the next numbered exhibit.
Any objection? All right, this will be received without objection as State's Exhibit number 63.
Permission to publish State's Exhibit 63, Your Honor?
You may.
So, Dr. Gamache, we can do this one of two ways with the court's permission. I can put this easel here and sort of turn it so that everyone can see it, and I can hand you a laser pointer, or if you'd like to step down and the court permits, you can step down and go through your explanation that way, however you'd like.
It makes, maybe the easiest, I probably don't trust myself with a laser pointer, so
You can step down,
Thank
Doc.
you,
I'll
Judge.
step down.
So the specific question, and then I'm actually going to ask you, yeah, if you could stand on that side, that way we don't block any of the jurors. Hold on. They're going to hand you a microphone because nothing's easy in this courtroom. So the specific question I had, Dr. Gamache, was could you explain the law of insanity using your diagram to the members of the jury?
So the black box with the white print at the top is the actual statutory language that comes from Florida statute 775.027. And down below it, I've tried to lay out kind of a decision chain for how I, as a psychologist, not a lawyer, but as how I, as a forensic psychologist, apply findings from psychology to the legal criteria. And so what I often refer to, and that many other experts refer to, is the A prong for establishing a defense of insanity.
Sustained.
So could you tell us about the first prong of insanity under the law in the state of Florida?
The first prong of insanity is that it must be established that the defendant suffers from a mental infirmity, disease, or defect.
And what is the second prong of the insanity defense within the state of Florida?
What we refer to as the second, or the B prong, has two elements to it. The first element is, as a result, if the defendant does in fact suffer from a mental infirmity, disease, or defect, does that mental infirmity, disease, or defect, is it of a nature, is it of a magnitude such that it would affect their cognitive abilities, their thinking and their reasoning, so much so that they don't know what it is that they're doing when they commit the crime, or they can't comprehend the consequences that may come from what they're doing.
Well, so they don't know what they're doing or the consequences. Is there a third aspect that is a possibility?
There is, because even if it's established or even if it's accepted that they meet the A criteria, they have this mental infirmity, disease, or defect, but the data doesn't support that they didn't know what they were doing. In other words, the data and the evidence suggests that they did know what they were doing, and the data and evidence suggests that they knew what the consequences were. You could still support a finding of insanity if, even though they knew what they were doing and knew the consequences, they didn't appreciate the wrongfulness of what they were doing.
So on your diagram, there's a stop sign up the top right stop sign. Explain what that means to the members of the jury as it relates to prong A.
Well, logically, if the evidence in the psychological data doesn't support the conclusion that a defendant suffers from a mental infirmity, disease, or defect that's capable of interfering with these cognitive functions, then you can stop there. They don't meet the A prong. The B prong is only relevant, or the second prong is only relevant if you can adequately establish the A prong.
So you have, is my understanding that a defendant has to meet both prongs of the chain that you just described in order to be determined, or for you to render a conclusion that he or she is legally insane.
They must meet the A prong, and they must satisfy either the first part of the B prong or the second part of the B prong.
Okay, thank you, Dr. Gamache. You can have a seat again.
Great, thanks.
That's going to block my view of you from there. So now let's, if you don't mind, turn back to Dr. Toomer's opinion that you were asked to evaluate. Were you able to determine which mental illness, disease, or defect Dr. Toomer believed Mr. Loyd suffered from as to the A prong?
I could not determine that with certainty.
And can you explain to members of the jury why that is, why you had a difficult time determining that?
Well, the two fundamental sources of information I had to enable me to understand that and interpret that were Dr. Toomer's deposition, taken by the state and his testimony on this past Saturday. And when I read his deposition and I consulted with Mr. Williams, I explained to Mr. Williams that
Without saying what you said, without saying what you said to me, walk the members of the jury through the process.
So I carefully reviewed the deposition. I identified each of the parts of this deposition where Dr. Toomer was asked a question about his opinion with regard to what mental illness or mental defect that Mr. Loyd suffered from in January of 2017. And the deposition reflected testimony from Dr. Toomer regarding multiple conditions, including schizophrenia, delusional disorder, post-traumatic stress disorder. The deposition might have included bipolar. I don't remember that, but I remember him saying that on Saturday. And so it was difficult for me to determine with certainty from his testimony exactly which condition he believed, or which conditions, it could be more than one, that he believed that the defendant was suffering from on January 9 of 2017, and how any of those conditions affected the defendant with respect to those B-prong criteria.
So you referenced January 9, 2017 on a couple of occasions. You probably made this clear, but why is that the significant date in your analysis?
Well, it's sanity at the time of the offense. That's the date of the offense.
Why is it important to be able to identify or if established, multiple specific mental illnesses in support of an insanity defense?
Well, if I'm going to test a hypothesis that another doctor has generated, one of the ways that I approach testing that is if they identify a particular mental illness or mental defect that they say existed on that date, one of the things that I'm going to do as I look through all of the records, as I consider all of the information, all of the data, all of the testimony, is I'm going to try and compile a list of things that are consistent with the diagnostic criteria for that particular condition. So if it's schizophrenia that is being purported to be the mental illness that a defendant suffered from on the date of an offense, then I'm going to be carefully going through all of the material I have, and I'm going to be looking at the diagnostic criteria for schizophrenia and trying to identify any and all of the diagnostic criteria, that is to say, any and all of the signs and symptoms of schizophrenia that might have been present, in particular on the day of the offense. But because schizophrenia is a chronic condition, I'm also going to pay attention to any evidence at all that the condition existed prior to the offense and continued and was active on the day of the offense.
Now, are you aware of anywhere in any of the testimony of Dr. Toomer that you've reviewed where he specifically examined the diagnostic criteria for any of the mental illnesses that he opined Mr. Loyd suffers from?
My understanding from his testimony is that he did not do that.
Now, you used the word diagnostic criteria on a number of occasions, and you sort of explained it. Is there a specific text where you find those diagnostic criteria?
Sure. In the United States, for mental illnesses, the specific text that those of us in psychology and psychiatry and other mental health professions rely on is the Diagnostic and Statistical Manual version 5, or the DSM-5 for short.
Now, who publishes that text?
That's published by the American Psychiatric Association.
And what does the 5 stand for?
It's the 5th revision of that text.
And how is it put together or its content generated?
It's a compendium that is the work of panels that specialize in different areas. So, for example, schizophrenia and psychotic disorders is one of the general classifications of the types of different disorders. And so there is a panel and some subpanels with respect to each of the different diagnoses or each of the different conditions that fall under the schizophrenia spectrum. And those panels are responsible for reviewing the scientific literature, reviewing the history of the DSM and how that condition has been addressed diagnostically, determining whether any revisions are warranted to the diagnostic criteria, and then making their proposals to the larger committee that is comprised of the editors of the DSM-5.
Does the DSM-5 address the significance of having one manual with specific criteria and why that's important in your field of psychology, or specifically forensic psychology?
It does address that directly.
Can you tell the members of the jury why that is and how it addresses that?
It put most succinctly, the authors and editors of the DSM-5 say, look, the benefit of relying on these
Sustained. Rephrase.
I'll just ask, why is it significant or why is it important that the DSM-5 exist and have specific criteria that are normalized across your field?
to improve the reliability and validity of making a diagnosis.
So did you utilize the DSM-5 when conducting your, or when doing your work in this particular case?
Yes, I did.
And how did you go about doing that? How did you use it specifically in your work?
How do I use it specifically in my work, or how did I use it in this particular case?
In this case. I'm sorry. Thank you, sir.
So in this case, once I had had a chance to review all of the records that had been provided to me and had a chance to review Dr. Toomer's deposition and his raw data, in part because he had identified a number of different conditions that he said he thought existed in Mr. Loyd at the time of the crime, I decided to take the strategy of working backwards, so to speak. And what I mean by that is that the common denominator for, in fact, it's part of the definition of a mental illness in the DSM-5, is that not simply that a person have some signs or some symptoms, but they have a constellation of signs and symptoms.
Sustained. Just rephrase the question.
So when you said you worked backwards, what were you looking for specifically as to the diagnoses that Dr. Toomer provided?
What I was looking for specifically is evidence that whatever the condition might be, that it affected his functional abilities, that he was in some way disabled by it, that it was clinically significant. That's the common denominator of mental disorders.
So explain that. When you said that there are indications or people can have signs or symptoms of mental illness, but that's not sufficient in and of itself?
Not in and of itself, no. In fact, that's a part of the diagnostic criteria. People can present with different signs and symptoms, but is the constellation of signs and symptoms of sufficient magnitude and seriousness that it's somehow disabling to them?
Okay. Now, did that approach, the working backwards as you described it, impact the way in which you conducted your evaluation with Mr. Loyd?
It did.
So can you tell members of the jury how you used that approach and how it played out in your evaluation with Mr. Loyd?
So I wanted to know ultimately I wanted to get inside of his head for January 9 of 2017. But before I got to that, I wanted to work through the process of understanding his functioning in the community in the time frame from 2014, when he returned to the community, up until December 2016 and January 2017. So I spent considerable time speaking with Mr. Loyd, questioning him and understanding what did he do when he got back out? Where did he go? How did he function? Was he able to take care of himself? Did he pay his own bills? Did he take care of himself? Did he have a place to live? Was he able to communicate with people, develop relationships? Those are all the functional activities of a day-to-day life that we're all engaged in. People that are seriously mentally ill will have problems, will have difficulties, sometimes disabling difficulties in one or more of those areas. So the concept here was to work from when he got back out into the community and explore his functional capacity for that period of time, from 2014 up and to and including January 9 of 2017, because that would give me a clue. If I learned about different functional impairments that he had experienced during that time frame, then I would follow up with questions about, if you couldn't work, what was the obstacle? What was the problem? People wouldn't hire me because I wouldn't show up, or I wasn't taking my medication, or what have you. But again, the point was to work systematically through these functional activities, his abilities and his capacities in the community leading up to the day of this particular offense, as a way of understanding and evaluating, did he have a genuine serious mental illness? And if so, in what ways was it disabling to him? And how was that disabling aspect relevant to his thinking, his emotions, and his behavior on January 9 of 2017?
Do you feel you had the sufficient ability to, through your conversation with Mr. Loyd, gain an appreciation of his functioning during that time frame?
Yes, I do.
Can you give us a sentence or two as to your opinion as to Mr. Loyd's ability to function during the time frame that you've described?
I found his functioning, his capacity for functioning in these day-to-day domains to be, in fact, exceptionally good, not disabled. He was very effective. He was very much of an entrepreneur, and a successful entrepreneur from a work standpoint. When he got back out to the community, when he left the community, there was no such thing as Facebook. When he got back out, he discovered Facebook, and he was a prolific poster on Facebook. Not only that, he learned to use it to stay in touch with old friends, new acquaintances, to make friendships, to express himself, to read about the thoughts of other people, and in particular to engage in finding prospective relationships with women, which was a very important part, a very strong and important motive for him in his life.
Now, based upon your conclusion about Mr. Loyd's functional abilities from 2014 up through the time of Lieutenant Clayton's death, did you form an opinion as to whether or not Mr. Loyd suffered from a mental illness or disease and the A prong of the insanity defense?
Yes, I did.
And can you explain to the members of the jury what your opinion is as to the A prong?
All right, my opinion is, and in the way that it relates to those functional abilities, my opinion is that there's no evidence that he suffered from a serious mental illness at any point during that, what are we talking about, roughly 2-year time frame. No matter what whether the argument is it was PTSD, whether the argument is that it was schizophrenia, whether the argument is that it was bipolar disorder, all of those conditions are known to result in significant functional disability for people. He didn't have any functional disability, so there was no real basis, and he certainly had not been diagnosed or treated for a mental illness during that time frame. So there was no basis, in fact, to conclude that he met the A criteria or the A prong for defensive insanity.
Now, you were discussing, you use the phrase signs or symptoms. Is foaming at the mouth a sign or symptom of mental illness?
It is not. I'm glad you asked me that. I heard that testimony, and I can comment further on that if you like. Yeah, so when I heard that, I recognized that it was being offered as obviously as a lay perception that Mr. Loyd must have been mentally ill, or even specifically, I think the testimony was psychotic at the time. And I know, as a practicing psychologist, that the first three things that come to mind when you hear foaming at the mouth are an overdose of drugs, a seizure, or rabies. Psychosis is not one of those things. Foaming at the mouth is not a symptom of, it's not a psychotic symptom. Psychosis isn't a diagnosis, and it's not a symptom of a specific type of psychosis, such as argued in this case, schizophrenia.
Now, initially, Dr. Gamache, did you form or reach an opinion as to the B prong of the insanity defense?
So what I told you and Mr. Lenneman at the time of my deposition was that I'd not bothered to take that step, and I explained that there were a couple reasons why I had not at that point, but since then I have.
All right. And what information allowed you to reach that second prong conclusion or opinion that you received after your deposition but before your testimony here today?
In particular, it was the testimony of Mr. Loyd himself, and to a lesser degree, the testimony of Dr. Toomer.
So can you tell the members of the jury what it was about Mr. Loyd's testimony on Saturday that leads you to a conclusion as to the B prong or B prongs possibilities of the insanity defense?
The thing that struck me the most, and that I was able to directly correlate with something that I had interviewed him about, was the way that he described his reasoning, his thought process, and his moral compass, if you will, in January, and specifically on January 9 of 2017. And it reminded me about something that I had interviewed him about and that we had a very interesting discussion about. And that's something that you heard some testimony about as well, and that was specifically Mr. Loyd's decision to acquire guns and ammunition during this time frame between 2014 and 2017. And I knew about that. I knew he had done that.
Sustained.
Can you tell the members of the jury what it is about Mr. Loyd's decision to obtain firearms during that 2.5-year time frame that is relevant to whether he knew the consequences of his actions or that they were wrong?
When I spoke with him about that, I inquired directly about his reasoning and his thinking and how he made the decision about that. And it was very clear. His reasoning was, I know it's wrong. I know it's against the law. In fact, he intentionally didn't tell his probation officer for that very reason, but morally, he justified it to himself. And part of the justification was he didn't want to stop working at Texas Chicken, where he says he was making $1,000 a week. And so what he described to me was kind of weighing the balance. I don't want to give up this good paying job. I know what I'm doing is wrong in the legal sense, but I'm going to justify it in my own head. I'm justifying it as an appropriate thing for me to do, even though it's wrong legally.
So what is your final conclusion as to the B prong of insanity as relates to Mr. Loyd as of January 9th of 2017?
It's effectively the same thing. I have no reason at all to doubt that Mr. Loyd appreciated that what he did was legally wrong. Now, he justified it in his own mind. He engaged in his own personal calculus about what was important to him. And I gather what was important to him.
Sustained.
I'll just ask you a last simple question, Dr.
Sure.
Gamache. Based upon your conclusions on both A and B prongs, do you have an opinion, or can you tell the members of the jury your opinion as to whether or not Mr. Loyd meets the legal criteria for insanity in the state of Florida?
If I'm asked to render an opinion about that, my opinion would be no, he does not meet the legal criteria.
That's all I have, Your Honor. Thank you, Doctor.
Cross.
Yes.
Good afternoon, Dr. Gamache.
Good afternoon, Mr. Lenneman.
We know each other because over the last 8 years, you've testified in several of my cases for the state of Florida when they were seeking death. Is that correct?
I don't know that every case was a death case, but we've met before, and some of them were capital murder cases, yes.
So Vernon Stevens was one of them. Remember that? Vernon Stevens.
I recognize the name, I can't recall the case.
And the other one was Byron Birch, B-U-R-C-H. Is that correct?
Apologize, it sounds faintly familiar, but I don't remember the case.
Now, you consider yourself a very good psychologist, do you not?
Yeah, I think that's a fair statement.
And as a matter of fact, in your profession, to keep work flowing freely, it's important to do a good job for your clients. Isn't that right?
So when you ask me if I consider myself to be a good psychologist, I say that because I really focus on trying to do a good job and doing quality work, yes.
And as a matter of fact, you indicated the work you do for both the state and the defense is evenly split. Isn't that true?
That's correct.
And wouldn't it be fair to say that in 2015, you had approximately 50 to 75 death cases that you had worked on up to that point, and you indicated it was kind of like a 50-50 process on those. Is that right?
You know, I don't recall that. As a ballpark figure, that might be right, but I don't recall that. I don't recall testifying to that. And I don't know off the top of my head.
And you'd agree with me that you want to bring the best of you to the table when you are testifying for whoever you're testifying to, right?
Doesn't matter who I'm testifying, who's called me to testify. I definitely want to do a good job. I want to do a quality
And
job.
as a matter of fact, you want to make sure that there's no possible conflict that's going to interfere with your ability to testify. Isn't that right?
Well, I typically, when I get a new referral, will check to make sure that I don't have a conflict in the case, yes. That's a routine part of my practice.
If I can have a moment, Judge, I'm sorry. And isn't it true in your career, Doctor, that you have worked for a great number of law enforcement agencies?
I have. Well, to be clear, I haven't been employed by them, but I've done consulting work for them.
Okay. And we're talking about more than 10, is that correct?
I don't recall the exact number, but at one point I had contracts with a number of law enforcement agencies.
And as a matter of fact, FDLE brought you in to help them solve cold cases. Isn't that right?
I consulted with FDLE. In fact, I was the principal investigator on a research project to evaluate psychological factors relevant to serial murders, serial lust murders, and serial rapes.
And you worked for the U.S. Marshal's Office, is that right?
Again, I had a contract with the U.S. Marshal's Office, and I did consulting work.
And you contracted with the Pinellas County Sheriff's Office, is that right?
I did.
And you contracted with the Tampa Police Department, is that right?
I did.
You contracted with the Hillsborough County Sheriff's Office, is that right?
Yes, I did.
We already talked about the Florida Department of Law Enforcement. And there were a handful of other agencies besides the 6 or 7 we just talked about that were smaller than that, correct?
Some of them were smaller. There were a couple other larger ones.
Okay. Now, I noticed when you were testifying, you indicated that when you're going through your records, there was no indication that you received Facebook pages. Is that correct?
I'm sorry, are you saying, as I testified today, there was no indication I'd seen Facebook pages?
Well, you went through everything you reviewed, and
Okay, so you are talking about today. I understand your question now. And so that was simply an omission. I reviewed a large amount of media, specifically or particularly Facebook postings by Mr. Loyd.
Okay, and so you know there was approximately 30,000 pages of Facebook in this case?
You know, I heard you say that on Saturday. I don't honestly remember, but I know it was a huge volume.
Okay. And it was a mistake that you kind of overlooked the fact that you had reviewed Facebook pages?
Not at all. I was asked, I think, to be succinct and not itemize everything, but that's certainly an omission, and thank you for pointing that out.
And when did you receive those Facebook pages?
I don't know the exact date. I know that I've been working on the case since November 2019, so it certainly would have been between November 2019 and earlier this year, but I couldn't tell you off the top of my head exactly when.
And you're aware that when I took your deposition, I was emailed a copy of all the records that you were provided. Is that correct?
Are you talking about the email that I sent to you?
Well, it's originally dated December 29, 2019, correct? That's the one you forwarded?
I don't have it in front of me. I've got it with me. I don't have it in front of me, but you were provided with two itemizations of the documents that I reviewed. One came directly from the state, and the morning that you took my deposition, we had prepared one of our own and sent it to you and to the state.
And did you review the one that I got from the state?
I did not.
Would you like to review it?
It's entirely up to you.
I just want to ask you if you see Facebook on there. I'll approach the witness, Judge.
You may.
Doctor.
Thank you. No, if this is the itemized list that the state provided you, I don't see it on there, but it is on my list.
Okay, and your list is prepared by who?
By me.
Okay.
Well, by me with the help of my assistant. Okay. She catalogs every document as it comes in.
And that was, if you compare that to any other part of these documents in terms of the volume, that was pretty much the largest volume, correct?
Yes, that's a fair statement.
And you understand that these Facebook pages contained a number of writings, hundreds and thousands of writings of Mr. Loyd. Isn't that right?
That's correct.
And in those writings, he talks about the police, he talks about race, he talks about white America, all throughout those. Isn't that correct?
All of those things and more, but those are some recurrent subject areas. And I paid a lot of attention to that.
I'm sorry.
I simply said, and I paid a lot of attention to that. I thought it was important in this case.
Well, I didn't hear you mention it being important. Is there a reason why you didn't bring up? Because obviously you prepared for your testimony.
Absolutely.
You're very good at what you do.
Thank you.
And so you even prepared this chart to show the jury how much you know?
I did not prepare it to show the jury how much I know. I had prepared it probably a year ago in another case, and I've shared it with attorneys, both defense attorneys and prosecutors that retain me, as a potentially useful diagram for understanding how we apply the process.
And those would be in the realm of the 35 to 40 times that you worked for the state in a death penalty case. When there was the issue of insanity and they hired you on that, that's what you used, correct?
Well, the statute hasn't changed that I can think of during the entire 35 years that I've been doing it in Florida, but as I just testified, that is a illustration that I only prepared about a year ago.
So when you did not talk about the Facebook page postings, was that something you discussed between you and Mr. Williams?
Well, your question includes the predicate that I didn't talk about it. Actually, I'm pretty certain I talked about it during the deposition that you took of me. I certainly talked with the state about it, and I'm happy to talk about it today. I think it's important. I apologize, I did omit specific reference to that when I was just trying to give them a quick outline of what I had reviewed.
Because unlike you, Dr. Toomer relied heavily on those Facebook pages.
To the contrary, I found them to be incredibly important, and I'm happy to explain why. I think it's useful for the jurors to know why. May I?
Well, let me ask you, can you tell me, Doctor, what is a delusional disorder?
Sure. A delusional disorder falls in, there are different categories of disorders. One category is thought disorders, and it's referred to now as the schizophrenia spectrum. Delusional disorder is one type of schizophrenia spectrum disorder. And I can describe the distinguishing characteristic of it if you like.
Well, isn't it true that it's a false fixed belief that are held despite incontrovertible evidence to the contrary?
Okay, so that's a different question, actually. So there's a distinction. It may not be obvious to you, but it is important to understand. So the DSM-5 includes some fundamental definitions that are relevant to mental disorders. Delusions can be experienced in response to more than one type of disorder. Delusional disorder is a specific diagnosis where the primary symptom, in fact, the only symptom, is a delusion or delusions, plural. But the definition of delusion isn't part of the diagnostic criteria per se. I think you read it. It seems I don't remember word for word what you said, but I think you left out an important part of it. It's a fixed, false belief that is adhered to despite what the evidence would seem to indicate, that is not shared by a subset of the population that you identify with. And I'd be happy to give you some examples, including specifically how that's relevant in Mr. Loyd's case.
Okay. And you stayed away from that in your testimony because you don't have to admit that you don't find, at least in terms of the belief that law enforcement is trying to kill or was trying to kill Mr. Loyd, that that's a false fixed belief, correct?
I'm sorry, I did not follow that question. Maybe if you could restate it.
You looked through, you claim, Facebook pages, is that correct?
I'm testifying under oath. I studied the Facebook pages that were provided as part of the evidence in this case.
Well, let's talk about that for a second. We'll
Sure.
get back to the false fixed belief. Isn't it true after you study everything, you have a meeting with your captains, people who pay your bill, and you tell them things like, well, here's the advantage of me evaluating Mr. Loyd, here's the disadvantage. Isn't that right?
I would disagree that they're my captains. They don't directly pay my bill. The state of Florida does, but I certainly confer with them and consult with them about what my opinions, my preliminary opinions are based on review of the records and the pros and cons of conducting an examination of the defendant. And it's the very same kind of consultation that I do with defense attorneys.
Well, isn't it true that you do that before you go to talk to Mr. Loyd? You did that before you went to talk to Mr. Loyd?
I did do that before I went to talk with Mr.
And
Loyd.
you explain to them what is the pros and cons of you going to evaluate Mr. Loyd?
Yes, I did.
Because they make the final decision, right?
That's important to understand. I don't get to decide anything specifically about what I do. It's up to the attorneys that retain me.
So in other words, if you as a doctor want to do something and they say you shouldn't, does that mean you can't or you won't?
Well, it doesn't happen very often, but if I suggest to an attorney, whether it's a prosecutor or a defense attorney, that I think that doing something, either doing a particular piece of research or doing a clinical interview of a defendant is important, and that in fact it's crucial to the case, and they say, well, we're not going to allow you to do that. I mean, they have the right to do that. They also have the right to limit my testimony when I appear. There have been occasions where an attorney might say, no, I don't want you to do that. And my response is, well, you know, I think that's so critical that I'm not comfortable going forward if you don't want me to do that.
And in this particular case, there was a decision made that you were being hired specifically, as you had said on direct examination, to test the hypothesis of Dr. Toomer. Is that correct?
That's correct.
So you went into this situation with the goal of testing the hypothesis of Dr. Toomer.
That is correct, and that's what I told the state, that the examination could potentially aid me in advising them about whether Dr. Toomer's opinions and conclusions were supported or were not supported.
Okay. And before you watched Mr. Loyd testify on Saturday, you didn't test the hypothesis of Dr. Toomer. Isn't that right?
That's not correct. That's inaccurate.
Well, you said what was important to you was, in addition to his deposition, was his testimony at trial.
That's correct. I did say that.
And when did you watch his testimony at trial, Doctor?
On Saturday.
So on Saturday, when we left each other in deposition, you had said you only addressed prong one of the evaluation. Isn't that true?
I think I'm either confused by your question or I'm not sure about the time frame. You asked me when did I listen to the testimony of Dr. Toomer, and I said Saturday, meaning just this past Saturday. You and I haven't seen each other until today.
Exactly. So when you came in and gave the deposition on...
You're referring to when we sat out in the hallway then?
No, I'm referring to October 6, 2021.
Right.
Remember that deposition?
Yes.
Okay. And isn't it true that you told me in that deposition that you only addressed prong one and didn't go any further, correct?
That as of the date of that deposition, I had only formulated an opinion and shared it with the state about the first prong, that is to say, whether Mr. Loyd suffered from a mental infirmity, defect, or disease on January 9 of 2017.
So as of that date, you hadn't even looked at prong two, is that correct?
Well, I had, in fact, attempted to look at it, but I was obstructed in doing so.
When you say you were obstructed, and we were going to get to this, but I'll bring it up. You did an evaluation of Markeith, isn't that right?
I did.
Now, you said Dr. Toomer's evaluation wasn't videotaped. Is that correct?
That's what I was told, yes.
But both you and Dr. Warner's was.
I don't know about Dr. Warner's.
Do you know why yours was videotaped?
Well,
Objection as to the relevance of that question.
Sustained.
We've had conflict in the past. Isn't that true, Doctor?
I want to answer that in the most professional and tactful way. You have been difficult to deal with.
Okay. And you kind of think when you get involved in the case, you're like the third lawyer on the case. Isn't that right, Doctor?
I've never thought that. And I've never gotten any feedback from anybody that thinks I act like a third lawyer on a case. I'm not a lawyer, to be clear.
Okay. As a matter of fact, in 2013, when we were preparing for the penalty phase of Vernon Stevens, and the court had
Objection, Your Honor. Relevance and it's not in discovery.
Sustained.
Have I videotaped you before, Doctor? In your evaluation of my client?
I don't recall.
Now, it's your opinion that Mr. Loyd has a long-standing fixed belief that law enforcement are racist, that the criminal justice system is racist, that people that are not the same skin color as him are racist.
Objection. Compound question.
It's one.
Sustained.
You would agree with me that it's your belief that you think Mr. Loyd has a long-standing fixed belief that law enforcement are racist?
Yes, it's my opinion that Mr. Loyd has long believed that law enforcement is racist.
A fixed belief?
It's been long-standing, so it seems to be relatively fixed, yes.
And as a matter of fact, you believe that Mr. Loyd believes that the criminal justice system is racist?
He does. He believes the criminal justice system is racist and corrupt.
And you believe that Mr. Loyd has a fixed belief that people that are not the same skin color as him are racist. Is that right?
Yes, that's true. It's reflected in both my interview with him and in his Facebook posts.
But although you think he has a fixed belief about that, you don't believe that he has a fixed belief that the police were trying to kill him.
No, I don't believe that he has a fixed belief that the police were trying to kill him specifically.
You actually believe that this belief, you don't find it fixed, but this belief is reasonable because Mr. Loyd, based on the circumstances he was in, should have been concerned about the police killing him.
So if you're talking about that specific belief and the belief that he was at risk of being killed by the police on and around January 9, 2017, I believe that he did perceive that risk, and it was a rational perception on his part. He was wanted as a suspect in a murder, an attempted murder. He was on the run, and he was very acutely aware that he was considered armed and dangerous. And that creates a potentially very risky and volatile situation.
Isn't it true, Doctor, that when we were talking about this long-standing fixed belief regarding law enforcement, isn't it true that you don't believe that's delusional in part because there are subsets of the culture that we live in have the same belief that he identifies with? Isn't that right?
Not simply because there are subsets of the culture that share that belief, but because he identifies with some of those specific subsets, including the sovereign nation, the people that believe in the sovereign nation, the black nationalists, and in particular, Black Panthers, and several other groups that share the same kind of fundamental beliefs and thoughts. In fact, he even uses language or phrases or shorthand from some of those different subsets in the things that he does and in the things that he says or in the things that he writes. While Mr. Loyd, make no mistake, he's an independent thinker, he's not the type to really affiliate closely with one particular group. He's not afraid to borrow thoughts and ideas. And that's the fundamental distinction here. That's why it's my testimony that Mr. Loyd doesn't suffer from a delusional disorder. He doesn't suffer from delusions. He has these fixed beliefs. They relate to corruption or racism that's systemic in our country, and that he relates to the history of slavery. And that's not uncommon at all. In fact, it's particularly prominent these days as there's been more sort of tribalism and talk and publicity about those kinds of things. But it's been around quite some time. And those Facebook posts, contrary to your questioning of me, I considered them extremely important. This is something that has evolved in my practice of psychology. Years ago, we might occasionally encounter cases where somebody had left behind a diary. That would give us a window into their mind, into their thinking, in their emotions. These days, with the internet, lots and lots of people record their thoughts, record their emotions, record their beliefs on a daily or nearly daily basis. It's new material, it's important material, and it's significant material, particularly in this case where Mr. Loyd talked at length for 2 years about these kinds of thoughts and beliefs. They weren't disabling to him. He found other people that shared the same thoughts and beliefs, but not everybody acted the exact same way that he did. It's not a delusion when it's something that is widely shared by a subset of the population. I can give you a couple other examples of that go outside the specific ones that pertain to Mr. Loyd. Other cases that I've evaluated that have similar fixed beliefs that many of us might consider to be false, but they're not delusions and they're not the product of a mental illness.
Now, you had a 4-hour evaluation of Mr. Loyd, didn't you?
4.5, something like that.
It was videotaped and transcribed.
Yes, it was.
You had an opportunity to read the transcription?
Yes, I have.
Where in that 214-page document is a single question about Facebook to Mr. Loyd?
Is this copy indexed?
It is
That'll
a
make
copy.
it
It's not
faster
indexed.
for me to... Because I don't recall from memory. This is not indexed.
No, I understand that. I'm asking you.
Okay. I couldn't begin to search through all of this at the moment. I've got notes that I made from the transcript. It might be reflected in there.
Please.
But we definitely talked about it.
So check your notes.
Okay.
Did you provide those notes to me?
I just made them when I went through the transcript to prepare for testimony today.
Okay, well, Judge, I'm asking for, Judge, can we come sidebar on that while he looks?
Shall I continue to search for that?
Did you look in your notes?
I did.
Do you see any reference to them in your notes?
I have them right here. I'm happy to share them with you, but I don't see specifically the word Facebook in my notes, but I distinctly recall talking to him about the use of it, and I can give you an example of that.
Well, I'd like to see it on paper, because an example is that you're stating it without support. That supports the entire evaluation that you had.
I'll look for it, given that it's not indexed. It might take me a minute. I don't want to
All
delay
right, folks,
things.
this seems like a good time for you all to take a break while the doctor looks through his notes. So why don't you guys take your afternoon break? Thanks. All right, folks, everyone can just be at ease while the doctor looks through his notes, and then you all can look through them. While the doctor's looking through this, we're back on the record. Mr. Loyd and his attorneys are in the courtroom, as are the state attorneys. I got the exhibit from this morning from the defense. State, you have an objection to that? Remember the chart that the witness drew on?
The one that is different than the one he drew on in court?
I didn't look at it, to be honest with you. I just knew I received it because I just wanted to talk about it only in court. So you're objecting?
I am, Your Honor. Basically, what the email indicated from Mr. Robinson was that he deleted the one that he drafted in court in front of the jury, but redid it and added some additional things and then signed it. So I would object to an exhibit that's been prepared now outside of the jury's presence, now being admitted. I understand it's a little unfortunate that Mr. Robinson wasn't able to memorialize what he did in court, but I would object to him introducing this additional exhibit.
Mr. Lenneman, your response? Can't hear you. What?
I have to call him to see if he saved that. I don't disagree with the state on the one he sent.
Yeah.
Why he would do that? Professional witness for a long time, but I'm going to call him when we get out of court to see if I can get.
Right, so we all agree that the current exhibit is not admissible since it has information that was not presented to the jury,
Yes,
correct? All right, so I can delete this email?
yes.
All right, thank you. All right, so we're back on the record on State versus Loyd. He's present with his attorney. State Attorney's Office is present. Dr. Gamache, have you gone through all of your notes?
Yes, I have.
All right, does State wish to review his notes or defense?
We do not.
Defense, you want to review his notes? All right, do it now while the jury's not here. You done?
Yes, ma'am.
All right, let's bring the jury back in. Doctor, you might want to be careful that pile doesn't end up on the floor.
I had left it there for him, but
Okay, yeah, thanks. State recognized presence of the jury.
We do, Your Honor.
Defense?
Yes.
All right, Mr. Lenneman, you may continue with your inquiry.
Yeah, we left off where I had asked you, or made the statement that you didn't ask him any questions about Facebook in his interview, and I gave you the video conference transcripts, the evaluation, to have you go through those and look to see if there were any. And
Yes.
apparently you have some.
yes, I found, do you want me to say more than yes, or? The answer is yes.
Okay.
Multiple.
Okay, well, let's talk about what they are.
Sure.
And just so we're clear on my focus, you went on and on about how interesting and important and all that about what he was actually writing in those. Correct?
I don't know that I went on and on, but no doubt I did emphasize that I thought that his Facebook postings were important.
Well, let me ask you first, do you have any questions that you asked him that even come close to that?
Absolutely. By my count, there's somewhere around 35 pages in a 220, 230-page transcript of my four and a half hour interview of him, where
Okay,
we
let's-
talk specifically about his use of Facebook and about the messages or the themes of messages that were included in his Facebook posts.
Okay, you may need this.
I've made note of the specific pages.
Oh, I understand. But
Okay.
There's a continuation. And so we're not looking
All right.
for an isolated point, we're looking for what the truth is, okay? So let's just go through the first one. What page?
The first one that I found,
Yeah,
the first reference is on page 20, actually. So it was shortly into the interview.
Mr. Lenneman, do you have your mic on?
oh, I do not, Judge.
Yeah.
I do have it on, I do have it on me. Okay. Okay, page 20?
Correct.
Okay. Okay, what's the question?
We're just asking questions about the deposition.
I'm not sure what you're asking him.
There are no questions on page 20 that you ask about the Facebook, isn't that correct?
Well, I didn't phrase every question that related to Facebook by specifying Facebook. On page 20, I did in particular, because we were talking about how he adjusted and adapted once he returned to the community from prison. He began describing, or I asked him and he began describing about socializing by use of Facebook. It was a brave new world to him.
Well, here's my question, Doctor. Did you ask him a question about Facebook, or was that a continuation because he brought it up?
I could go back and look to be certain, but to be clear, I didn't have to ask him a question saying, do you remember posting such and such on Facebook in order to inquire, for example, about racism? I knew he had posted a lot of things on Facebook about racism. My eyes were tired from reading those thousands of pages of Facebook posts too. But we talked about that during the course of the examination. I can point to specific questions where that came up during the examination. So
Well,
it's kind of...
Let's get to those questions.
Let me finish.
Doctor.
It's naive and narrow to think that any question that I asked him that related to Facebook postings or that was psychologically correlated with that began with Facebook, Mr. Loyd. Do you remember this on Facebook? Instead, what were his Facebook postings about? They were about racism. They were about corruption in the system. They were about distrust and hatred for the police and for the criminal justice system. And we covered a lot of those things in the course of the 4+ hours that I spent with him. I didn't have to prompt him by saying, do you remember posting this on Facebook? But there were many instances where it related directly to those Facebook postings. About, I'll give you specific examples if you like. Thank you for giving me the opportunity to go through and refresh my
Thank you for giving me
memory.
the page number, Doctor. You're looking at your notes.
I'm
I gave
get-
you 219 pages. I want you to look.
Mr. Lenneman, you saw my notes. I've got the page numbers on there.
Doctor, let him ask a question and then you answer the question.
You said you went through and found all these postings and you took aside these pages from this evaluation. But you're not telling me what's said that you claim. Like just a minute ago on page 20, you said, oh yeah, we talked about that. I asked him a question. If I remember correctly, I don't see a question on there. So tell me what the question is on page 20. No, okay. No, you have the, Doctor, did you not, before the jury came in,
Yes.
pull out the ones you claim are Facebook?
I'll be happy to show the jury. What I noted was each and every page where I found reference to dialogue that I had with Mr. Loyd that either directly related to his use of Facebook or indirectly related to the attitudes and beliefs that he espoused on Facebook. You only allowed me to give you the first page of this.
Doctor, you pulled out the pages that you think apply.
Absolutely.
You have them up there.
I did not pull the pages out. I made
No,
a note
no,
about
you
what
pulled-
page.
You actually pulled Facebook pages, didn't you?
Do you mean, I'm not sure I understand your question.
Did
What
you-
what do you mean, did I pull them
Did you take the pages that were relevant to you and pull them out of that?
out of this?
Yes.
This isn't his Facebook postings.
No, out of the interview that you claim you asked him all these relevant questions about Facebook.
You asked me this before. I did not pull them out. I made note of them
Well,
so that
first of
we
all,
could go
when
back to
When
them
did you make note of them?
during the recess while the
Okay.
jury was out.
Well, you got that in front of you. Let's start with page 20. What question did you ask him?
So if you want to narrow it to just where Facebook comes up on this particular page 20, we're talking about his dating relationships and his relationship with women and his activity in that regard. And he says, I'm inquiring about how he did that because it's pertinent to understanding what, was he disabled or not? Could he socialize with people? Could he meet them? Could he get their numbers? So my question was, you had their numbers and you would just call them or text them, or how would you, and before I could complete the question, he responded both. And the rest of my question was, how would you get things going with them? Answer, both. They would see me, and then Facebook was running. They would see me on Facebook and contact me and stuff like that.
And so that wasn't a question from you, that was a statement from him, correct?
That was a question from me where he referenced his use of Facebook. My question was, how did you make the acquaintance of all of these females? And his answer to me was through the use of Facebook.
Okay, what's the next one? Next page.
The next would be page 64.
And tell me about the question you asked him on here about Facebook.
A second to get to it. So at this point, I had begun to inquire about his relationship with Sade Dixon and how he had become acquainted with her. And I asked him specifically on page 64, how did that develop? And his response was, I met Sade online. She sent me a friend request, so I go on there like every other female. I do this, send me a friend request. I go on that page, make sure it's real before I accept you and your page. And he continued about that.
Okay, and then there's a question on that page, line 16, that you actually include the word Facebook. You want to read that to the jury?
Sure, I missed that, I think. So this was my question to Mr. Loyd. So you got out. How did you get familiar, that sophisticated with your use of Facebook? Did somebody teach you, or you taught yourself, or what?
Okay, and when is the next question that you ask?
Page 65.
We were on 65. That's the one you read. at
Oh,
the
I'm
bottom,
sorry, you're right.
65.
We covered 65. 66.
Okay, what's the question you ask?
So I asked a question. He had described to me just prior to this how his daughter had gone on Facebook and kind of acted as his female guard on Facebook. She would block females that she thought were undesirable for him. And so my question was, I was trying to make sure I understood what he was saying. My question was, so she was trying to be protective of her daddy then, is that right? And his answer was yes. And I said, I got it, all right. So you met Sade on Facebook, she sent you a friend request, and then he responded to that. And we continued in terms of my understanding how he developed a relationship with her.
Okay, what's the next one?
Next would be, let's see. Well, I've got 66, 67, 68, 69, and 70.
Okay, on any of those, do you actually pose a question that includes Facebook?
If you mean, is Facebook part of the language in my question?
Yes.
I'll look quickly. I don't recall. It does not appear that it was specifically a part of the language that I used in my question, but it was certainly the topic we were talking about and the description, the account that Mr. Loyd was giving me of his use and familiarity with it.
And as a matter of fact, on those 3 pages, he was talking about meeting girls, right?
Yeah, let's see. He was talking about meeting girls, and he was talking about having conflict with girls over issues of infidelity as discovered by virtue of online activities,
Okay.
including Facebook.
When is the next question you ask?
The next part of it that relates to Facebook postings is page 110.
And what question did you ask that relates to Facebook on that page?
My question is actually, let's see. My question is actually back at 108. He gave a rather lengthy answer, but my question on 108 was, all right, so you said don't talk about what happened. Give me just a second, because I'm not sure the context of that. Okay, now I recall the context. So I felt that it was important for me to understand his thinking and reasoning after the death of Ms. Dixon and during the time that he was on the run from the police before Lieutenant Clayton was killed. And part of what I thought would be important to that would be understanding and questioning him about, from the moment that this happened with Ms. Dixon, you know, what were you thinking? What were you expecting? What were you believing? What was the decision-making process?
Doc, what's the question?
I'm getting to that.
No, you're not.
Yes, I absolutely am.
Gentlemen,
Being the
gentlemen.
witness.
All right. This is how this is going to go. You're going to ask questions. You're going to answer questions. You're not going to interrupt each other. You're not going to talk over one another, and you are not going to get into arguments. You may proceed, Mr. Loyd.
Doctor, you referenced 108, page 108.
That's where my question was.
So I want you to tell me, read the question to the jury, and then you can say what it's about.
There are actually three of them, three questions on that page, or three, it's a continuation. He's clarifying, he's nodding yes or answering yes or something like that. But it begins, so, all right, so I know that something happened on December 13th, and it may or may not be important for us to talk about that in some detail, I'm not sure, but I'm familiar with the events. Mr. Loyd responds, yes. I continued, that happened on that day. What I want to do for now, though, is I want you to just talk to me about after the incident at her house, or at her, I guess it was her parents' house. And he responds, uh-huh. And I continued, where this happens. I want you to talk to me about help me understand what you did, where you were, what you were doing, and what was going through your head after that. Mr. Loyd responds, all right, so you said don't talk about what happened? And I continued I clarified my question. Well, it's up to you. If you think it's important for me to know about what happened now, then go ahead and tell me. But otherwise, we can start with after that incident and get to the date in January that we need to talk about. But if there's something that you think is important for me to know about that, then feel free. And then his answer begins on 109 and continues through, I think, 112, and his answer pertains to the conflict between he and Ms. Dixon related to Facebook and Facebook postings and beliefs that they began to share that each of them had been unfaithful.
And so in those three questions, I didn't hear any verbiage that include Facebook with a question mark.
No, you heard it correctly. I didn't put any verbiage of that nature in there, nor did I necessarily, although I had some suspicion that it would prompt a response that related to Facebook from what I read. I didn't necessarily expect him to relate that, but he did.
Okay, so what is the next page?
Next is 133.
Okay. I want you to read the question out loud that references Facebook.
There's two questions. Neither of them use the verbiage Facebook, but the questions are 133, line 2. Well, I meant, who were you referring to? You meant the police were trying to, and he interrupted the question. He said, the police, yes, to the police, like, and I continued the question, how? How would that be? Help me understand how you believe that the police were motivated to kill you. And then he went on, and I can read his answer, but it
Yeah,
was...
why don't you read it, Doc?
Okay.
Overruled, go ahead.
Go ahead, Doc, read it.
Because they've been trying to kill me. The police always telling me, even before I went to prison, they was always telling me they're going to kill us. They're going to try to frame. It's not my first time facing the death penalty. This time, they just had more. They got more to work with because I'm involved in the situation. Last time I was facing the death penalty, I had absolutely nothing to do with what was going on, but they were framing us and lying, and it was paying witnesses to come lie on us.
Okay. So is there anything else based on your question that relates to Facebook?
Beyond page 133?
Yes.
Yes, 138.
So we're skipping over to 138. So what you're saying, if I understand you, is the questions you asked on 138 are related to the answers or questions you asked on, 133 are related to the questions you ask or answers you get on 138. Is that correct?
No, that's not what I said. You asked me if there's what the next reference is, what the next part of my examination that pertains to his Facebook postings.
I meant to ask, and I'm sorry if I didn't do it correctly.
All
I
right.
meant to ask, other than the question you asked and what you read in 133, was there anything else that pertained to Facebook on that page?
Give me just a second. I think I read out loud to the end of that page, right?
I think so.
I asked him a follow-up question about the case that he was referring to where he alleged that he was framed.
Uh-huh.
You want me to read the question and answer?
Again, Your Honor, objection.
I'm going to sustain us to the answer, but allow us to the question.
Let's go to, what's the next thing that you wrote?
138.
Okay, and tell me, read me the question that is related to Facebook on 138.
So I'll begin on line 15. My question was, and the basis, what you considered to be the foundation of knowing that the police were out to kill him, was because the police told your family, no, we're not going to go tell the media to run a different story. Mr. Loyd, yeah. They say they're not responsible for what the news plays. Me. Okay, so how is that trying to kill you? Mr. Loyd, because they've been killing us, they kill us for nothing. Me. Yeah, but how is, and he interrupted me, Mr. Loyd, I'm talking about black people here in America. We get killed by the police on a regular basis.
Sustained.
All right, so what is the next page that you have about Facebook?
I'm on that page now, 139.
Okay, and read the question that you did in regards to Facebook.
So what were you thinking about your options were at that point?
Okay, and he responded to you?
He did.
Okay, what is the next page? And in his response, is there anything about Facebook?
There isn't anything where he specifically names Facebook, but he describes, again, beliefs, fixed beliefs that he has shared on Facebook.
And so he's describing fixed beliefs that he shared on Facebook, and they were obviously, at that point, in your mind, a fixed belief. You didn't know it was a false or not, correct?
It was a fixed belief about racism and injustice in the criminal justice system and in police and law enforcement in particular.
Okay. But you never went to the actual pages of the Facebook to investigate that, did you?
Just like you, I read those pages. I already had all of that information.
Okay.
I didn't need to ask him again, you know, do you remember posting this on Facebook, or did you ever post this on Facebook?
Because
What I was looking for is the statements
Let me
that...
ask the question, doctor. Because if he gives you an answer that you relate to Facebook, and it appears on its face that someone who is involved in that writing has a false, fixed belief, that could be a problem to you. Isn't that right?
If somebody is posting on Facebook and they are expressing what appear to be fixed, false beliefs that are unique to them and that are readily disprovable and that persist despite them being confronted with facts to the contrary, that could be evidence that would support that somebody was delusional.
Okay. Doc, what's the next page? And I apologize for calling you Doc, Dr. Gamache.
Where did we leave off? 138, 139, we've covered those. I've got 138, 139 twice, 140 twice, 145, and it goes on.
All right. So on those pages, 138, 139, 140, are there any questions that include the word Facebook?
Not that I recall, no.
Okay. And
Again, I've tried to clarify that I didn't need to use the word Facebook to inquire about the underlying beliefs.
Okay. So what's the next page?
Well, I gave you several at once. Again, to be clear, 138, 139 twice, 140 twice, 145,
Okay, so up to 140, we just talked about that. There are no questions that use the word Facebook.
not to my recollection, no.
Okay. And now you're going to 145.
Correct.
Are there any questions on that page that use the word Facebook?
Where I use the word Facebook? No.
Yes.
On 145, I said, no, go ahead,
Okay.
continue.
Go ahead, I'm listening.
That's all I said. The rest of it is his statements to me.
Okay. And does his statements have anything to do with Facebook?
Yes.
How?
He's talking about how his language was, I've been through this shit before, and that's the same kind of thing that he posted on Facebook.
So you have a specific instance on page 145 where he's saying something that is completely related to Facebook, which would actually support or confirm that his state of mind and thinking on page 145 is consistent with his state of mind and thinking in Facebook. That's not important to you?
Compound question.
Sustained. Break up the question.
Yes. On page 145, he's talking about something you said was related to Facebook, right?
Correct.
Okay. He doesn't reference his Facebook at all in the following dialogue, does he?
He doesn't, and I didn't say that he does.
Okay. But what you're saying is he had facts that he presented to you that are consistent with his Facebook postings. Is that right?
What I'm saying is during my interview with him, there were repeated instances where whether either one of us used the word Facebook or not, where he talked about, where he expressed the very same kinds of beliefs, the very same kinds of attitudes that he had expressed on Facebook. Sometimes we literally talk about it in the context of Facebook postings, not even necessarily using the word. In other times, he's just talking generally, but what I'm identifying is how these generalizations are consistent with his posts.
But up to page 145, I haven't heard anything that is consistent with his postings in regards to his delusional thinking, his fixed false belief, racism, or any of that.
Well, we're a little more than halfway through. Much of the rest of it relates directly to that, and I'm happy to share it.
Okay, well, let's keep going. What's next?
162.
Okay. Is there a question on 162 that uses the word Facebook from you?
No.
In this post, on this page, or whatever follows, does any of that come from anything to do with his Facebook pages that include delusional thinking, fixed false beliefs, mental illness, any of that?
Not delusional thinking, but certainly this theme of the system being racist and police being racist. And in this instance, it's related to my inquiry about his perception of Lieutenant Clayton, I believe.
And he actually gave you what he believes happened. Isn't that right?
Well, not directly in relation to that question, because the question was how he perceived her, but I inquired about directly what he recalled happening.
And he described that for you, right?
He did to a point.
Well, tell me when the point stopped. Point to a sentence or a question that you asked that redirects him.
All right. Page 179, line 19.
So he talks about that all through those pages, the events that occurred with Lieutenant Clayton.
Well, it's not one continuous narrative from him. I'm asking him questions step by step, breaking down from the minute he arrives at Walmart until he leaves Walmart.
And let's talk about, Doctor. You said that I interrupted your evaluation. Wasn't that your testimony?
I don't recall if I testified to that today or not, but if I didn't, I'll say it now.
Okay.
You did.
As part of your role working for the state of Florida, you're able to gather information from a defendant that the state of Florida, wouldn't normally be able to gather in a case involving insanity. Isn't that right?
In a case of insanity, the defendant is raising their mental state at the time of the crime. So the prosecutor is entitled to retain their own experts to independently assess that. If the defendant, I'm not a lawyer, but my understanding is if the defendant doesn't raise their mental state at the time of the crime, then I wouldn't be able to ask those kinds of questions.
And so during that period of time, you were asking him question after question after question, and many of those questions were not open-ended. Open-ended question goes like, so what happened? Tell me what was going on.
Objection to the relevance of any.
Sustained.
He brought it up, Judge, on direct.
Sustained, rephrase.
And you were asking him many leading questions, and you were challenging him. Were you not?
Same objection.
Overruled. I'll let him answer this question.
You were challenging him, weren't you?
I did challenge him, and I'd like the opportunity to explain why I did.
Please.
So there is an important distinction to be made between conducting a clinical interview with somebody that is willingly coming to you for help versus a forensic interview. In forensic interviews, defendants aren't particularly enthusiastic about talking with an expert that's been hired by the state, and they're not particularly enthusiastic about answering questions. And so if I simply treat them like a patient with depression that's come to see me to get some help with their depression, I'm going to have a different style than when I'm trying to gather information in order to answer questions for the court and for the trier of fact. So yes, when I did not perceive Mr. Loyd's responses to be, or when I did not perceive his answers to be necessarily responsive to my question, I would ask the question in another way, or I would challenge him about something that wasn't consistent.
And as a matter of fact, you would make statements to him that were things like, well, that's not factually supported, or how do you do that? Isn't that right?
It's possible. If you can direct me to a page in line, I'll be happy to look at it.
179, question starts with right. That's when I objected
Give me a
initially.
second.
179.
Right. So line 17, I responded to something he was telling me. This pertained to the moment when he comes out of the store, out of the Walmart, and is confronted by Lieutenant Clayton. And he's giving me an account of that. And I said, right. And I would understand that. I would understand if that was factually supported, but, and then you interrupted me.
And didn't I say in the...
Objection to what counsel said.
Sustained.
Okay, so let me understand this. I know you're not a lawyer, but in this particular case, unlike many other cases, you're not videotaped. Isn't that correct?
No, I was videotaped.
No.
This entire exam was videotaped.
I understand that, but most cases that are capital, they don't videotape.
No, I wouldn't agree with that.
So that's video. Go ahead. Go ahead.
If when I'm hired by the defense, they typically don't videotape me. But when I'm hired by the state, the defense usually insists on videotape.
Okay.
And I'm agreeable to that. I think it's a good idea.
Okay. Well, if you're agreeable to that, you remember Vernon Stevens?
Yeah, I don't. You mentioned that name before. I'm sure you're asking accurately that it was a case that I did. I don't recall.
And as a matter of fact,
Objection, relevance.
Sustained.
so we were talking about it being videotaped, and then this was transcribed, where everything he said is taken down. All the questions, all the answers. Is that right?
That's correct.
This is a document that was providable to the defense and the state, right?
Excuse me, and to me, yes.
Okay. So you're aware, you know, doctor, that if you give a prior inconsistent statement, I can impeach you with prior statements you made. Isn't that right?
Yes.
So if you said in a transcript, the light is green, you're saying on the stand, the light is blue, I can impeach you with the light is green statement. Isn't that correct?
Objection, relevance.
Sustained.
And did you know whether Mr. Loyd was going to testify or not?
At that time, I did not.
So that transcript would have no value unless Mr. Loyd testified. Isn't that right? Because it's not allowed to be introduced.
Objection, relevance. It's a legal
Sustained.
conclusion.
Sustained.
All right, what is the next page after 179?
$185.
And what is the question that you ask that includes Walmart reference?
I'm sorry, the question that I asked that includes what?
I'm sorry, the Facebook reference.
My question begins at the bottom of page 184. Question, okay, so that didn't happen until after the death of Lieutenant Clayton.
Where is this? What, I'm missing this. What page is this?
Bottom of 184, top of 185.
Gotcha. Okay, go ahead.
I read it.
Yes, sir. Oh, and what does it have to do with Facebook?
His answer has to do with and correlates with his Facebook postings.
And what's his answer?
Objection, relevance.
Sustained.
It doesn't have the word Facebook in it, does it?
No.
As a matter of fact, it's like you said before. He's talking about things that you would believe, depending on what a psychologist believes, but a person who's doing an interview, it's important to determine whether what he's saying is delusional, paranoid, because it's consistent with many of the other things he said, right?
Well, that's my exact point, Mr. Lenneman. You seem to be very fixated on some concrete reference to Facebook. And what I'm trying to explain to you, what I've tried to explain multiple times, is that the question may not have used the word Facebook, the answer may not have referred to Facebook, but it's the theme, it's the thought process, it's the beliefs, it's the attitudes that he espoused on Facebook, that I became familiar with in reviewing the records, and that he talks about specifically in the context of the death of Lieutenant Clayton. That's the connection.
But you never actually put the Facebook pages, which you claim to have read, into action by saying, Mr. Loyd, you're saying this. What do you mean by this? What's going on with this, Mr. Loyd? Is that
Objection,
correct?
asked and answered.
Sustained.
What's your next page?
Continues with his second answer on 185, and then on the next page I noted is 189.
Okay, just so we can save time, because you've said this many times, going through the rest of the pages, is there an actual question that has the word Facebook in it that you ask?
I do not recall, and it's not indexed. I don't have a quick way to answer that. But when I went through it during the recess, I don't recall seeing Facebook literally in the questions that I asked for the rest of the examination. It may be, but I don't remember seeing it.
Okay, let's make this clear. I gave you 219 pages to look through.
Yes.
You sat there for the entire break that the jury was out, going through page by page by page. Isn't that correct?
That's correct.
At the end of the pages, you stuck it up on the corner and indicated you were through.
That's correct.
So now I'm asking you the question again. Do you recall any questions that have the word Facebook on them?
Asked and answered.
Sustained.
On page 189, do you have that in front of you?
I do.
The defendant actually tells you, he wanted.
Objection.
Sustained.
This goes to impeachment, Judge. May I come sidebar?
Yes. You may proceed.
Yes, Doctor. In any of the 200-plus pages of this evaluation, did you ever ask my client a single question about racism? Other than when he brings it up and talks about it, did you ask him any questions?
I can't recall a specific question, but I literally didn't need to ask because he volunteered that information to me many times during the examination.
Did he talk to you about the media, Doctor?
Is this a different subject?
Yeah, we're done with Facebook.
Okay. Yes, he did.
Okay. And didn't he tell you that the media was lying on him?
Yes, he did.
And that he had his niece reach out and try to reach both the police and the media?
Objection. Self-serving hearsay.
Sustained.
Doctor, how important is culture to any given evaluation done by a psychologist?
I consider it to be very important. I consider it to be, and I considered it to be very important in this case.
Did you ever talk to any of my clients' family members?
I did not, but I certainly had information about statements that they had made
And that was
in other
from-
interviews, so I didn't see the need to interview them directly myself.
And that was from the last penalty phase that occurred in the killing of Miss Dixon.
Some of it was from that, and if I'm not mistaken, there's so much to remember about this that I'm not entirely certain, but I think Dr. Toomer had indicated that he also spoke with some family members of Mr. Loyd.
Okay.
And of course, as I said, I listened to the testimony of two of his siblings.
Now, after we talked about Facebook and your evaluation and all of that, you had said on direct examination that you wanted to get inside his head and understand his function. Is that right?
And understand his thinking, his reasoning, his emotions, and his actions on the day of this offense.
Well, isn't it true that you can never, or it's not scientifically reliable to ever just evaluate on a moment in time when something happens? Is that correct?
Well, the law specifically is referring to this moment in time. Can I ever 100% reconstruct in my mind what happened and what was in the defendant's mind? No, I doubt that it's ever a 100% reconstruction because the information, the data that I'm getting may not be entirely accurate, but that's certainly the focus, and one of the best sources for that kind of information is the defendant.
Okay.
He's the only one that knows for sure what he was thinking and what he was feeling at the time. We can, as a psychologist, I can make certain inferences from his behavior and from his history, from his background, from his past conduct, and I did that in this case.
Okay.
And
But
culture was an important part of my analyzing that.
Okay, tell me about why culture, in your opinion, was important and how you used it.
Well, again, as I explained, the definition of a delusion. How do you know if something is really a delusion? Lots of people, and in fact, lots of groups or subsets of people have fixed beliefs about things that, I may think they're not entirely plausible. Lots of people may think they're not entirely plausible or that it's somehow distorted in some way. But just because they have those beliefs that I don't really see, I wouldn't necessarily share those beliefs, and not everybody else would share those beliefs. It doesn't mean that it's the product of mental illness. And I offered to give an example of that before. I'm happy to do it now because I think it would really help everybody understand.
Does that example have to do with my client being black and you looking at the culture that he comes from, originates from?
No, I would say it has to do with understanding why I attached such significance to understanding the culture that he comes from and the part of that culture that he identifies with.
In the last question I asked you, doctor, you talked for about 3 minutes and you didn't even answer my question. Is that something you do regularly? Is that
Argumentative.
Sustained.
you didn't answer my question? My question was, in regards to culture, how did you use this in the evaluation?
I considered what Mr. Loyd has said, what Mr. Loyd said to me, what he has posted a lot of on Facebook, on social media, and what he has said to others about his beliefs. I contemplated that in the context of his background and history, and I refreshed my memory about some subsets of the culture, of our culture in the United States, that share very, very similar beliefs. I also made note of the ways that he symbolically identifies with those subsets of the culture. So in other words, this is something, these are beliefs that he shares with a proportion of our population. Whether that includes me or not, I'm a psychologist evaluating him. That's not important to me. But it is important to understand it from the context of where he comes from and what he thinks and what he believes. And so in that process, I researched the neighborhoods that he grew up in. I knew a little bit about them. I'm familiar with Orlando, but I made a point of looking at them and looking at their history. I researched some of the different groups or subsets of the population that I know from past experience and past cases to espouse, to endorse the kinds of beliefs and thoughts that he has. And I mentioned some of those before, including sovereign citizens, Black nationalists, Black Panthers, and he uses some of the terms, he evidently gets some of the terms in support of his belief directly from those kinds of sources. So I thought that was incredibly important in trying to figure out, is this just something that Mr. Loyd, that was generated inside his head on the basis of some mental illness that he suffers? Or is this something that's a somewhat more widespread belief among a subset, and he identifies with it, and he talks in the same language and expresses some of the same thoughts and beliefs? My conclusion was, it's the same kinds of thoughts and beliefs.
And in that investigation you conducted, did you generate any documents that showed you did the investigation?
Sure. I printed out some things, or I saved some things on my computer that were related to that.
And
I've got some of them with me today.
You didn't provide that to the state?
I don't remember if I did or not. I don't think so.
Now, you had talked about one of the things that you used in determining your decision on Mr. Loyd's state of mind was the thought process that he went through in acquiring guns. Is that correct?
I told you that today, yes.
Yeah. And you didn't tell us that he actually told you in that interview that he was working at a chicken place and making $1,000 an hour. I think you mentioned that, but he got robbed. Isn't that right?
$1,000 a day, not an hour. And yes, he described to me being robbed twice while working there.
And is there a reason why you didn't say that on direct?
I don't remember being asked a question where that would have been responsive.
Okay.
But I definitely talked about how that related to his decision-making with regard to breaking the law and acquiring guns as a convicted felon.
I have no further questions, Doctor. Thank you for...
You're welcome.
Redirect.
Briefly, Dr. Gamache, we did in fact have a conversation yesterday about whether or not to address the Facebook issue, right?
I didn't hear his question, Judge.
My question was, we did have a conversation yesterday, today's Monday, yes, yesterday, about whether or not to bring up the Facebook post on direct examination.
You'll have to forgive me. I know we talked yesterday, that may have been part of our discussion, and certainly that's your decision what to ask me. I don't independently recall right now.
Did we discuss streamlining your direct examination?
Yes, we did.
In other words, making it shorter and more easy to understand given the volume of the testimony?
And now that you say that, it was probably in the, I do recall now that it was in the context of streamlining. I apologize, I didn't remember that initially.
We also discussed the idea that Mr. Linneman would bring it up on cross-examination and you could deal with it then.
You did share with me that you anticipated that, yes.
Now, You, on a couple of occasions, wanted to give an example of a delusion that is not a false belief and how you distinguish between a fixed belief and a false belief. If you'd like to give that example, please do so.
Sure. If I interview a defendant in a case and they tell me, and let's even make it even closer by analogy to Mr. Loyd's case, not only do they tell me, but there's some writings that they have made where they're describing the belief that they're not really a human being, that they're some immortal alien, and that they just are encompassed by a human skeleton, and they've been around for eons and eons of time, and that their objective is to escape this human skeleton and return to their immortal alien state. Doesn't sound particularly plausible to me. Sounds like it could be a fixed false belief that this person is experiencing, until I look carefully at the subset of the culture that they belong to. And I've had that experience, that kind of scenario, and what I discovered was that that individual was expressing their belief in Scientology, that that's a core belief among Scientologists, and that represents anywhere between 200,000 and 4 million people in this world. So we don't diagnose all Scientologists as suffering from some kind of delusion because that's their belief. It's shared amongst the people that they identify with. It doesn't necessarily spring from some mental illness that they suffer, even though many of us may find that to be peculiar or unusual.
That's all I have. Thank you, Your Honor. Thank you.
All right, may this witness be excused. State?
Yes, Your Honor, he may.
Defense? All right, thank you, doctor. You are free to go.
Thanks, Judge, I appreciate it.
All right,
Okay. Thank you again.
call your next witness.
Dr. Michael Maher, Your Honor.
Right here.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
Yes, I do.
Have a seat, sir. You may inquire.
Thank you, Your Honor. Could you please tell us your full name and spell your last name, sir?
Michael Scott Maher, M-A-H-E-R.
And what do you currently do for a living, Dr. Maher?
I'm a physician and psychiatrist licensed to practice medicine in the state of Florida. I have my own practice in Tampa.
How long have you had your own practice?
Since 1973, I'm sorry, 83. 38 years.
Is a portion of your practice forensic in nature?
Yes, it is.
And by that you mean you examine individuals for the purpose of providing opinions in law that are related to law. Is that a fair statement?
That is correct.
Okay. Now, at some point a few years ago, did you become involved in the case State of Florida versus Markeith Loyd?
Yes.
And how was it that you became involved in the Loyd case?
I was contacted by his defense team to evaluate him with regard to that case and the charges in that case.
And you said that case. Which case are you referring to?
The Dixon case.
Okay. Now, were you sent materials regarding the Dixon case?
I was.
Were you also sent materials regarding the murder of Lieutenant Debra Clayton?
Yes.
Did you review all the materials?
Yes.
And that would include the ones regarding Ms. Dixon, correct?
Yes.
And did you also review the materials regarding Ms. Clayton or Lieutenant Clayton?
Yes.
Now, what specifically were you asked to do in regards to your evaluation of Mr. Loyd? In other words, was it narrow in focus or was it more broad?
I was asked to evaluate him with regard, particularly with regard to the Dixon case, and asked to assess his competence to proceed and his state of mind at the time of the incident, and other factors which may have been relevant to mitigation with regard to a death sentence.
All right. Now, you concluded that Mr. Loyd was competent, is that right?
Yes.
And can you just give the jury a brief overview of what that means? We haven't heard that term yet.
Sure. Very briefly, the state of Florida has some guideline criteria that they consider to be essential in determining if an individual is competent to proceed in a criminal case. Essentially, those guideline criteria are that they understand the charges, they understand what penalties they might face, they understand that there's an adversary system, somebody working for them, somebody working against them. They have the ability to communicate with their lawyer. They have the ability to behave in a proper manner in court, and they have the ability to testify if called on. Competency also may include other factors. Those are the state mandated guideline criteria, and other factors might include specific factors related to mental health issues.
You also said that you evaluated Mr. Loyd for sanity at the time of the Dixon case, is that right?
Yes.
And what was your overall conclusion as to Mr. Loyd's, whether or not he met the criteria for sanity under Florida law at the time of the Dixon case?
My conclusion was that based on the legal criteria for sanity in the state of Florida, and I want to make it very clear that sanity and insanity are not terms we use in medicine today, but it does have legal meaning that I utilized in evaluating that. And my conclusion was that he was legally sane at the time of those events in the Dixon case.
Do you recall the time frame between the murder of Ms. Dixon and the murder of Lieutenant Clayton?
Not precisely. Best of my recollection, it was several weeks.
Okay. Did there come a time where you and I had a conversation?
Yes.
And was that last Thursday early morning? That would be Thursday, October 28th,
Yes.
Around 6:45 a.m.
That sounds correct to me.
Early,
Yes.
right. And did you and I have a general conversation about Mr. Loyd's state of mind and the evidence that supports his state of mind over the period between the Dixon murder and the Clayton murder?
Yes.
Did you share with me your conclusion regarding Mr. Loyd's sanity at the time of the Dixon murder?
Yes.
And without saying what you said to me, did you describe in general terms how those two offenses would relate in terms of insanity?
In general terms, yes.
Right. In general terms, what relation does your finding of sanity have in the Dixon case to the Clayton case 3 weeks later, regarding the factors present between the two offenses?
The first thing that I would start with, looking at that issue, as you pose the question right now, is that he suffered from mental illness, and in considering the legal criteria for sanity in Florida, one has to consider whether a person suffers from mental illness or not, so that's one of the first criteria to consider as a psychiatrist. It was my conclusion that he did suffer from mental illness, that mental illness was of a chronic nature, ongoing nature, so that given that it was my conclusion that he suffered from mental illness at the time of the Dixon events, that he still suffered from that mental illness several weeks later at the time of the killing of the police officer.
Okay, and as to the second problem?
And the second issue is whether that mental illness so affected him that either he didn't know what he was doing or he didn't understand in a very concrete, simplistic, common sense manner that it was wrong. And I evaluated the details of the Dixon case and reached a conclusion regarding that.
Okay, and how would the details of that case be any different than the details surrounding Lieutenant Clayton's murder as you know them from your review of the records?
The insanity criteria are very specific and very particular, as I understand them, to the exact case and the exact circumstances. It is not sufficient simply to say a person is mentally ill and they sometimes get confused. One must, a professional such as myself, must apply those to the exact and particular circumstances, state of mind, truly the moment when the events related to a criminal offense occur. And I made that assessment with regard to the Dixon case. I did not make that assessment with regard to the police officer case.
Did you tell me your belief as to Mr. Lloyd's sanity during the Clayton murder when we spoke on the phone last Thursday morning?
I'm sorry, I didn't hear the question.
Sure. I said, did you tell
Is your
me
mic on, Mr. Williams?
I'm sorry?
Is your mic on?
Very much. No, it's not. I got caught finally. Sorry, Judge. I said, did you tell me your belief, and I'm using the word belief specifically, as to Mr. Lloyd's sanity at the time of the Clayton murder when we spoke on the phone last Thursday morning?
Honestly, I don't remember the exact word that I used. I could answer that, I could respond more fully to that question if you want me to.
Sure, please. Best of your recollection.
Sure. What I recall is that I offered to discuss the general issues of a case of insanity that might include a self-defense insanity hybrid or a combination of those versus a case that did not include a self-defense type of issue or consideration. And I indicated that in the Dixon case, it was my belief that there was an issue related to a possible self-defense insanity combination, but there wasn't such an issue related to the other killing.
And following our conversation, was it your understanding that you were going to be called as a witness for the state of Florida?
Yes.
And you received an email with materials from me last Thursday afternoon. Does that sound right?
I specifically requested a copy of my testimony and deposition in the Dixon case, as I had not reviewed them, and it was years ago.
And then you received communication that you were going to come and testify this afternoon as a state witness.
Yes.
Did you receive a phone call from, well, let me back up. Did you ever email or call me prior to today indicating that circumstances had changed regarding your belief or opinion prior to today?
Not prior to today.
Right. But you did receive a phone call from Mr. Lenneman yesterday afternoon, right?
Yes.
And then you called me this afternoon around noon because you wanted to me to know some more specific information.
Actually, I called you early in the morning. I don't
was
think you
here.
got the message until
Yes, sir.
noon.
So what was that specific information you wanted to relay to me this morning?
That I had reviewed my deposition and testimony, and also I told you that I had spoken to defense counsel,
You did, yes, sir?
and I wanted to make it abundantly clear, as lawyers sometimes say, that I had reached a conclusion within a reasonable medical certainty that I was prepared to offer in court on the Dixon case, but not on the police officer killing.
So is it your belief that you and I had a miscommunication
On
on
the
Thursday morning?
Yes.
Okay.
Apparently, based on what you told me today, yes.
Okay. And so do you have an opinion currently on Mr. Loyd's sanity at the time that he murdered Lieutenant Clayton?
I haven't evaluated that to the point that I could offer an opinion in court, no.
Specifically as to the second prong?
That's correct.
That's all I have, Judge. Thank you,
Cross.
sir.
Thank you.
Hello, doctor. You are a psychiatrist,
That's correct?
and we have worked together for many years, is that right?
That is correct.
And most of the time, maybe even all the time I bring you in, the cases that we do involve the death penalty. Is that right?
Very frequently, I'm not sure if it's exclusively, but yes.
And besides you, we have other doctors who participate in the case, is that right?
Yes.
Relevant, Your Honor, objection.
Sustained?
Now, you indicated that you had reviewed materials in preparation for your opinion, both involving Dixon and involving Clayton, is that correct?
Yes.
And those materials include information from other doctors, is that right?
Yes.
Okay. So at some point when I hired you, I asked you to go and meet with Mr. Loyd, is that right?
Yes.
And you have a process of your own that you use to evaluate him, is that correct?
That is correct.
And that includes a clinical interview,
Yes.
history,
Yes.
records,
Yes.
family members,
Yes.
and in the course of your interview, you made some conclusions about Mr. Loyd, is that right?
Yes.
Okay. What were those conclusions?
That he suffered from a variety of conditions, most prominently a psychotic condition related to delusions, false beliefs that have no basis in reality. Also that he suffered from conditions related to trauma and post-traumatic stress disorder related to childhood and adult experiences. Also that he had a history and pattern of substance abuse and qualified for a substance abuse diagnosis. I also concluded that there was a history of brain damage and a traumatic brain injury diagnosis was appropriate and probably related to the psychotic experiences.
And when you say he had a delusional disorder, can you explain to the jury what a delusional disorder is?
Yes. We all have various beliefs. Some of our beliefs are clear and essentially everyone would accept that they're accurate. I believe that most of the jurors are wearing masks, clear belief. We also have other beliefs that are more subjective and more individualistic. And some of those beliefs might be accurate, some might not be accurate. I might, for example, believe that this is my lucky day and I'm going to buy a lottery ticket and I'm going to win the lottery this afternoon or this week. And that I'm going to win it is unlikely. It's likely that that belief is wrong. A delusional belief is a wrong belief where I'm absolutely certain that it's going to happen. So if I go out and max out all my credit cards and charge even more than I can because I can somehow charge more, put myself at risk because I absolutely believe that I'm going to walk over to that 7-Eleven across the street and buy one ticket and win $1 million, that's a delusion. That's a false belief which has no basis in reality and is just out of this world wrong. Now, there is a gray area between the two, but beliefs that run through a lot of a person's life, contrary to what I've just described, a belief that runs through a lot of person's life is more and wrong and absolutely in contradiction with common sense reality is more likely to be a delusional belief and an indicator of mental illness.
Now, you indicated that you relied on some information from some of the doctors.
Yes.
Did you rely on data from Dr. Sesta?
Yes.
Okay. And was that important to you?
Yes, it was of some significance.
Okay. And can you generally just give us what the finding was that you relied on?
Objection, calls for hearsay.
Sustained. Rephrase the question, Mr.
Okay.
Latimer.
So when you are considering your diagnosis and your evaluation, you rely on other doctors' findings in some form or fashion. Is that right?
Yes.
Okay. And you're aware that Dr. Sesta gave the MMPI to
Yes.
the RF? Okay. Are you familiar with that?
I am.
What is it?
It's a psychological test of a very long list of questions that are answered true or false that have been statistically and scientifically studied in order to come up with some conclusions about how people answer that test and how that might be related to diagnoses or other personality characteristics.
And so what was your determination in terms of the things that Dr. Sesta found in that testing that were important to you?
The MMPI number 2 in particular, that is the second version of it. That's what the 2 means in MMPI. So the MMPI-2 showed patterns that strongly supported the conclusion of the presence of psychosis. There were some other details, but that was the strongest, most significant thing that I considered to be relevant in consulting his findings.
And built into that test is a system of validity that checks to see if people are faking or not faking?
There have been over the years various efforts to determine whether people are honestly trying to answer the test, whether they're confused and not answering the test accurately because they're confused, or other things that might distort the results from a genuine effort to answer the questions honestly and forthrightly. So yes, there have been efforts to develop what are called scales to determine what we would call malingering or faking, confusion, disregard, illiteracy. If you're illiterate and it's not known and you try to do the test, that tends to show up in certain ways. So those scales have been identified and research has been done to try to utilize them in a consistent and scientific way.
And do those scales of symptom validity include underreporting?
Yes.
Did that happen in Mr. Loyd's case?
Yes.
And so what we're talking about here is, describe what underreporting is.
When a person has certain qualities or characteristics and they're asked about them and they endorse or respond only to some of those, that would be considered underreporting. So if a person, for example, has a problem, a medical problem that causes them stomach cramps, and they report either on an evaluation or to their doctor that they only have stomach cramps a little bit once a month, but actually they have them a lot and they're very painful and they happen every week, that would be underreporting.
Okay. Now, how important is culture to your evaluation?
It's very important. Understanding cultural differences and cultural history is very important to psychiatric evaluation.
And why is it important?
It's important because in psychiatric evaluation, we're always trying to understand the individual in their context, in their family, in their community, in their larger social context, the ethnicity, so on. And people from different racial, ethnic, social backgrounds have different ideas and belief systems. For example, to take something from years ago, there is a pattern among certain people in Appalachia to eat clay when they're pregnant. This sounds kind of silly and maybe crazy to people, but it's a very consistent pattern in certain Appalachian communities that women who are pregnant are inclined to eat clay. It's in their culture. So if a psychiatrist is evaluating a person from that culture and finds that they were pregnant and they were eating clay, that has a very different meaning than if they're from a culture where there's no history or inclination to do that. In the absence of a cultural pattern, that would be a very bizarre symptom. In the presence of a cultural pattern, one would think, well, you know, it's really not good to eat clay when you're pregnant, but it's in their culture, it's something that people in that culture believe, so we have to understand it in that context.
Is it your experience when you deal with someone from a different culture, someone who's black, that you run into some issues because of the cultural difference?
Yes.
And how often does that happen to you?
It happens very regularly. Let me modify my answer, if I may, briefly.
Sure.
Use the word, if someone who's black. That's a distortion, because you have to look way beyond the color of the skin. And there are people who are African American, who would identify themselves as black, who have a very different cultural background than other people who are identified on that superficial racial basis that way. So just to be clear, it's not just black and white. It's much more detailed than that.
Okay. And you said it happens quite often?
Yes, very regularly.
Now, when you got involved in this case, did you have to take that in consideration?
Yes.
Why?
Because Mr. Loyd's background was particularly strongly rooted in a very identifiable and powerful cultural background, which some, not all, African Americans, self-identified blacks, have experience with. So it was very important for me to consider his background, his history with police, his family history, his history with incarceration, which need to be understood in that cultural context.
Now, in the course of any evaluation that you do where there's a cultural component, is trust a factor that, or mistrust a factor that you have to deal with?
Yes.
Why?
Cultures which aren't seen as the predominant or majority or in power culture almost universally have lower levels of trust in authority figures than dominant or majority cultures. So he was from a culture where distrust is of authority figures, of police, of other authority figures, is a strong component.
Was he a significant advocate of the racism that occurred over time and things like that?
Yes.
Okay. Now, when you said, going back to the MMPI 2R, that it reported that Mr. Loyd was underreporting, is that right?
Yes.
That means he wasn't being completely frank about everything. He was holding
Objection
back.
asked and answered.
Sustained.
And Dr. Sesta is white, right?
Yes.
You're white.
Yes.
Dr. Toomer is black.
Yes.
Would Dr. Toomer have a better in with someone like Markeith than perhaps you?
Objection calls for speculation.
Sustained.
Was Dr. Toomer involved in the first case that involved Ms. Dixon?
Yes.
Dr. Toomer was involved?
I don't know.
Okay.
I don't know if Dr. Toomer was involved.
Have you gone back and read the testimony from the trial?
I read my testimony. I have to acknowledge there is much of that I do not remember.
Okay. Those are all the questions I have, Judge. Thank you.
Redirect.
Yes, Dr. Mayer, did you reach the conclusion that Mr. Loyd was insane at the time of the Dixon murder because you're white?
I'm sorry. I think I got all that, but I want to make absolutely sure I understood your question.
Sure.
I didn't hear it.
I object, Judge. That's a mischaracterization of what I said.
Overruled. He can ask
My
the
question was, did you reach the conclusion that Mr. Loyd was sane at the time of the Dixon murder as a result of your being a white psychiatrist?
No.
Thank you, Judge. That's all I have.
Can I have a
All right.
recross?
No. All right, may this witness be excused? State.
He is excused and released by the state. Yes, Judge.
Defense.
Yes.
All right, thank you, doctor. You're free to go.
Thank you, Your Honor.
All right, state, call your next witness.
The state calls Dr. Tonia Werner.
What? I don't think it.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth, so help you God?
I do. Have a seat, ma'am. You may inquire.
Thank you, Your Honor. Good afternoon, ma'am.
Good afternoon.
Could you please tell us your full name and spell your last name?
My name is Tonia, Tonia Werner, Werner.
Where are you currently employed, Dr. Werner?
Where am I
Where?
currently employed?
Yes, ma'am.
I'm employed at Meridian Behavioral Health Care. It's a community mental health center in Gainesville, Florida.
What is your title at Meridian?
I am the Chief Medical Officer and Vice President of Medical Services.
What is a community health center? In other words, can you tell us what your organization does for the community?
Yes. So we have a wide variety of services. We have inpatient and outpatient services for psychiatric and substance abuse issues. And we basically provide services for the underinsured and the uninsured individuals in the community.
What are your daily activities in your role as Vice President of Medical Services and the Chief Medical Officer?
So I start my day out on the inpatient unit. We have two inpatient units for psychiatric services, 2 adult units, one in Lake City and one in Gainesville. And I run the one in Lake City. And so I start my day out seeing patients and treating inpatients.
So would you agree that most days, if not all days that you work, you actually see and treat patients?
Yes, sir. Right now, and probably for the last year, because of the staff shortage, I've worked 7 days a week. So I work Monday through Sunday seeing patients.
You referenced the fact that that Meridian Behavioral serves underserved individuals in the community.
Correct.
Can you give us sort of an understanding of the demographics of the patients that you serve at your health center?
Gosh, we treat everybody. So we have white patients, Black patients, Asian patients, Latinos. We get some migrant workers that are traveling through Florida that don't even speak English. We take everybody. We do not turn anybody away from our facility. And that's what a community mental health center is for.
So what is the financial situation of most of your
We have a lot of homeless population, a lot of migrant population. So typically lower socioeconomic status.
Now, could you walk us through, getting away from what you do now to how you got there, your educational and professional background until you got to Meridian, please, starting with your degrees?
Yes. So I graduated from the University of South Florida in Tampa with a degree in chemistry. My medical school education was at American University of the Caribbean. I then did, and that was 4 years after college, then I did 4 years of residency at Connecticut Valley Hospital and under the auspices of Yale University in Connecticut. Following that, I came back to Florida in 1998 and did a 1-year fellowship in forensic psychiatry at the University of Florida. And then I stayed on faculty at the University of Florida from 1998 till 2015 when I retired from there. And at that point, I was the vice chairman of the Department of Psychiatry and the chief of the Forensic Institute at the University of Florida.
Now, over the course of this trial, which you're just now joining, but we've been doing for a while, the terms psychologist and psychiatrist have been used. Can you differentiate between those two specialties?
Yes, so a psychologist has a PhD or a doctorate level degree of study, and a psychiatrist, such as myself, has gone to medical school. So I'm actually a medical doctor and can prescribe medications where they cannot.
Are you licensed in the state of Florida?
I am licensed in the state of Florida.
And what do you have to do to become licensed in the state of Florida?
To be licensed in the state of Florida, you have to demonstrate that you have the appropriate education and training. You have to pass background checks.
Do you have any board certifications?
I do.
Can you explain the board certifications you hold to the members of the jury? They've already heard what a board certification is, but if you want to give a brief overview, that's fine.
Yes, so ours is a little different probably. We have, when I took mine, we had oral tests and written tests that we had to pass. So I'm board certified in general psychiatry and also in forensic psychiatry.
Do you have any specializations in neurology?
My board is in, our boards are in, we're certified by the American Board of Psychiatry and Neurology, so the ABPN. So for psychiatrists, 25% of our written exam is neurology questions. And for neurologists, 25% of their exam is psychiatry questions. So they're kind of intermingled.
And just generally, what is neurology?
Neurology is the science of the nerves, which includes the brain, the spinal column.
In addition to your work at Meridian, do you consult with attorneys in a forensic capacity?
I do.
Can you tell the members of the jury what that portion of your practice looks like?
It's probably about 10% maybe.
Of what you do overall?
Correct.
Right. What types of cases do you work on in a forensic capacity?
I do civil cases and also criminal cases, so a wide variety of cases.
When you're retained in criminal cases, are you retained primarily by one side, the other, or both? If you could explain, please.
It's typically probably I'm more hired by the prosecution and appointed by judges, but I do work with the defense also. So I do have cases with the defense. It's probably 50% prosecution, 20% judge, and 30% public defenders or defense attorneys.
Now, your work in this case, State of Florida versus Markeith Loyd, came at the request of the Office of the State Attorney. Is that right?
That's correct.
And more specifically, we contacted you and asked you to evaluate whether or not Mr. Loyd met the legal criteria for insanity. Is that accurate?
That's correct.
And can you tell the members of the jury how much you charge per hour for your forensic work, please?
Yes, and so I don't charge for it. Meridian does because I work for them and they get the money. And for criminal cases, there's a state mandated fee, and I don't know if it's $325 or $350 an hour. They bill for it. I just give them my hours.
So that money goes to your facility, not directly to you?
Correct. That's correct.
Can you tell the members of the jury, and you don't need to list every one of them, but even categories of the materials that you reviewed in preparation to reach an opinion in this case?
Yes, so I had a lot of information. I had a lot of depositions, a lot of the police records, statements from different witnesses. I received a stick of information that had Facebook pages on it, some videos of some of the other experts interviewing Mr. Loyd, so just lots of information. Medical records from Department of Corrections.
Did you feel that you had sufficient information and materials in addition to your interview with Mr. Loyd, which we'll talk about in a moment, to render a complete opinion in this case?
Yes, I rendered an opinion based on all of the information that I reviewed, correct.
And did you in fact conduct an interview or evaluation with Mr. Loyd on September 27th of this year?
Yes, I did.
And was that interview video recorded?
Yes, it was.
Now, I'm telling you that the jurors have already heard about the prongs and a detailed explanation of insanity in Florida, so we're just going to skip right to that part.
Yes, sir.
Can you give us an overview of how you went about determining whether or not Mr. Loyd met the first prong of insanity, which is whether he had a mental illness or disease at the time of this offense?
Yes, so that I came to my conclusion on that based on my interview of him and my review of all of the records and documents that I was provided and just my years of training, education, and expertise in that matter in formulating a diagnosis.
Did you reference the DSM-5 or use it in any way in reaching your conclusion?
Yes, of course, I did.
You say of course. Why would you say of course in regarding that manual?
Yes, so that's a publication by the American Psychiatric Association, and it's published by them, and it includes all of the diagnoses that we recognize at this time. It changes over time with different editions and different volumes, and we as psychiatrists use that as a way to explain to each other what's going on with our patients.
So did you reach an opinion as to whether or not Mr. Loyd had a mental illness or disease at the time of the murder of Lieutenant Clayton in January of 2017?
Yes.
And what is your opinion regarding whether he had a mental illness or disease?
Yes, so I diagnosed Mr. Loyd with antisocial personality disorder and cannabis use disorder.
Now, is antisocial personality disorder a mental illness or disease?
Yes.
All right, explain that to the members of the jury and how it fits in with insanity.
How it fits in, I'm sorry?
With the first prong of insanity under Florida law.
Yes. So antisocial personality disorder is a disorder. There's a list of different personality disorders, or a variety of them. And it's something that's kind of developed over time in individuals. And it basically is how they think about things and how they process things, and it lends into their behaviors in different situations. Antisocial personality disorder has a lot of...
What's your objection? I'll overrule that.
Go ahead,
That
ma'am.
objection, yeah. go
Well,
ahead.
may I ask a question, Your Honor?
Yes.
Could you tell the members of the jury what the general features of antisocial personality disorder are?
Yes, so there are different features of it, such as aggression, getting into fights, law-breaking behaviors, limited remorse for victims of crimes, lying, deceitfulness. Those are all characteristics of typically of antisocial personality disorder.
So does antisocial personality disorder, your diagnosis of it, allow you to say that Mr. Loyd meets the first criteria for insanity under Florida law?
The first prong of the insanity defense actually specifically excludes antisocial personality disorder.
So do you believe he meets the first prong of insanity under Florida law?
I do not.
Now, as to the second prong, can you explain to members of the jury how you came about reaching a conclusion or opinion as to whether he met the second prong of insanity under Florida law?
Yes, so when I interviewed Mr. Loyd, I specifically had him spend time and walk through with me his actions and his behaviors leading up to the incident, and then what he did following the incident.
So the first part or possibility is that a person did not know what he was doing or the consequences of his or her actions.
Correct.
What information did you have that guided your decision as to whether Mr. Loyd knew the consequences of his actions on January 9th of 2017?
Yes, so in my interview with him, he was very clear that he understood what he was doing and the consequences of his actions, that if he shot someone, they could be killed. So it was clear that he understood that part. It wasn't that he thought that the officer was an alien. There was no, it was very clear that he understood that he had weapons and that if he shot someone, they could die.
What about the second possibility that even if Mr. Loyd knew the consequences of his actions, that he may not know that it was wrong, what he did? Did you evaluate that, and if so, how?
I did.
Please go ahead.
So a lot of that plays on his actions following the incident, the crime, in that he left the scene, he ran, he explained to me that he was driving down the road, he saw an unmarked car, he saw the unmarked car make a U-turn, so he made evasive actions to avoid the police. He went into an apartment complex, He changed vehicles, he drove through a fence because he was very clear that he did not want to go back out the front of the apartment complex because it was a single entrance and exit, and he knew that the police were there and that he would run into the police. So he drove through a fence in the back to evade, again, getting caught. He went into another apartment complex, he changed his clothes, and then got on a bus and rode away, and then hitchhiked his way to Jacksonville. So he was very clear that he understood that, to me, that what he did was wrong and that they were looking for him. So, and he was evading them.
Dr. Werner, based on everything you reviewed, do you have an opinion to a reasonable degree of medical certainty as to whether or not Markeith Loyd was sane at the time of his offense on January 9th of 2017 under Florida law?
Yes.
And what is your opinion?
My opinion is that he was sane at the time of the crime.
That's all I have, Your Honor. Thank you. Thank you, Dr. Werner.
Cross.
Good afternoon, Doctor.
Good afternoon.
Now, you said you do about 50% of your forensics for the prosecution?
In criminal cases at this time, probably, yes.
Okay. And how many death penalty cases do you have right now?
I don't know. I'm not sure, because some of them go on for years, so I don't know how many I have right now that are still going on.
But you have a bunch, right?
I'm sorry?
You have a bunch.
I'm not sure.
Do you have several?
I can think of this one and one other one.
How many death penalty cases have you worked over the years?
A number.
Now, you would agree with me, Doctor, that the evaluation process is an important process in this type of...
Is your mic on?
It is, Judge. Hello?
Okay. Sorry, go ahead.
You would agree with me that the evaluation process is important in this particular case?
Yes.
And when we're talking about the evaluation process, you mentioned about some of the steps you take, but essentially what you do is you receive a phone call, email from the prosecutor, right?
Or defense, or I can be appointed by the judge, correct?
Okay. And the judge you're appointed for what? Competency?
Competency, sanity.
Okay. Under what circumstances are you appointed for sanity by a judge?
I don't recall.
Okay.
I've also been appointed by the governor in death penalty cases.
I read that. I read that you actually were involved when someone was getting ready to be executed. You went up there with some other doctors to make sure that they were competent to be executed before they were executed, right?
Correct. The Florida statutes prohibit the execution of people that are not competent, don't understand the process, correct?
But you were able to find them competent, is that right?
I'm sorry?
You found him competent.
Sustained.
Some of them, yes, some not.
Objection was sustained,
Sorry.
Doctor. I'm sorry.
So now, in the course of an evaluation, you get contacted by the party, in this case, the prosecutor, that hires you.
That's correct.
And then they provide you a whole bunch of material to review leading up to your ultimate evaluation of an individual like Mr. Ritter, all right?
Yes, that's correct.
And I think you mentioned some of the documents that you had reviewed in this case. Is that right?
Yes.
Okay. And so besides reviewing those documents, you want to memorialize what your actions were and what your findings are, right?
Yes.
Okay. And in your case, you prepare a report.
Correct.
Okay, in this case, it's like 12 or 13 pages, is that right?
Yes.
And it's important to be accurate in that report, isn't it?
Yes.
Because you use that report, in essence, to refresh your memory and to prepare for a hearing like today. Is that right?
I reread it, but I also look at some of the other data that I
Okay.
need to look at. Correct.
Do you have in front of you the video conference evaluation transcript?
No.
May I approach the witness, Judge?
You may.
This is the video conference evaluation of Mr. Loyd done by you September 27, 2021.
Thank you.
You're going to need it. All right. You do an interview of Mr. Loyd in that video conference, do you not?
Yes.
And this one lasted about 2 hours, is that right?
I believe so, yes.
Okay. And then you memorialize in your report some of the things that you guys talked about, correct?
Correct.
Some of the answers he gave you,
Yes.
correct? Now, you have background information, right?
Yes.
But I don't notice anything that you put in your report about him dealing with racism. Is that right?
Correct.
He told you he'd watch racial movies like Roots, Mississippi Burning, Rosewood. Is that right?
I don't recall him telling me that, but I do recall him telling that I've read or saw him telling other examiners that.
Why don't you look on page 11, see if that refreshes your memory.
Yes.
So he told you that he watched movies like Roots, Mississippi Burning, right?
Yes, correct.
About people hanging from the trees, which he identified as true life, right?
Correct.
Burning
I'm
death,
sorry, where is that on here?
line 15 through 17.
Correct.
Burning our houses down.
Calls for hearsay.
Sustained.
It's not hearsay, Judge.
Sustained.
And he said, which is an easy mistake to make, that he was making...
Objection calls, just reading hearsay in the record.
I'm not reading
He
hearsay.
hasn't, stop. Ask the question, don't answer anything. What's the question?
Okay, the
Don't-
question is, did he tell you he was making $1,000 a day?
You can answer that, Doctor.
I don't recall specifically.
Okay, would anything refresh your recollection?
If you want to point me to the page, I'm happy to look at it.
Page 21. Lines 15 through 17.
Correct. He said when he was working at Texas Chicken that he was making $1,000 a week.
But you heard that he was making $1,000 a night, right?
I don't know if I heard that or if that's a typographical error.
You don't know if you heard it or it's a typographical error?
Correct.
Okay. So in your report, you put $1,000 a night, correct?
I'm not sure if you want to refer me to that page. I'm happy to look at
Page
it.
3 of 12, under employment history.
What it says is he stated he could make $1,000 on the night shift. It doesn't say per day or per week.
Okay. He told you that he was with Trinica Hobbs for 4 years on the streets, meaning he was out of prison, correct? Page 24.
'24 of the transcript.
Yeah, 24
Sorry, I was
transcript.
looking at my report.
Lines 8 through 11.
Yes, on the streets, 4 years, and my time lockup on and off. She would be on and off because I was in prison.
Well, you didn't put in your report that was 4 years on the street, correct?
I wrote, he was in a relationship with Trinica Hobbs for 4 years, beginning in the late 1990s, period. He described the relationship as on and off while I was incarcerated.
Okay, so you didn't put down the correct answer he gave you, which was he was in this relationship for 4 years on the streets.
Correct, I did not put on the streets in my report.
Okay. You wrote that he reported being beaten at 15 years. Is that correct?
I'm sorry, what page are you referring to?
Page 4. We're going in chronological order, just so
Okay.
you know.
Yes,
But he actually told you that he was 16, 17, 15, I can't remember the year, correct? That's
I
on
don't
pa-
recall.
Page 25, see if you can refresh your recollection.
Yeah.
Page 29, lines.
Oh, I thought you said 25, sorry, I
I'm
wasn't
sorry, I
seeing
may
it.
have said 25. Page 29, lines 15 through 17.
Thank you. When were you kidnapped? I want to say I was 16, 17, 15, I can't remember the year.
And you just put 15.
Correct, I did.
You said in your report that he denied any history of loss of consciousness. Is that correct? Consciousness.
That's correct.
Okay. But he told you that he was knocked on the head unconscious. Isn't that true?
I'm sorry, refer me to the page.
31, lines 11 through 13.
Right, and I think later on, if I remember that correct, he said that he did not fall down, which would indicate that he didn't lose consciousness.
So you decided to, even though he told you, to omit that from your report?
No, sir, on page 32, line 6, so they called themselves junkmen, they hit me with the skate first, and I said, and it knocked you out? No. Basically, I guess you could say I was out on my feet. So that's not a loss of consciousness.
Well, you asked him a specific question, did you not?
Yes, and
He
then
responded yes.
at one point, he responded yes, and then he clarified it further that it was a no.
And you decided not to include that in your report?
Correct, because he clarified it that it was a no, that he did not get knocked out.
Do you cherry pick what you put in your report?
No, sir, I do not cherry pick what I put in my report.
And isn't it true that you put in your report under psychiatric history,
Sustained.
did you ever say that Markeith Loyd told you that the staff reported when he was hospitalized at Laurel Oaks, they don't see anything wrong with him?
Yes, I did.
And isn't it true that in the evaluation you did with him, he told you that they said they think I'm crazy? I'm referring to page 35, lines 16 through 19.
Yes, he stated that in a family meeting, that they told his mom some things about him. They think I'm crazy and I need long-term.
Okay? And that wasn't included in your report, right?
Correct. I'm sorry, it is. He recalled a family meeting where his mother was told he needed quote-unquote, needed long-term treatment. He recalled he was angry and threw charts.
But that's not what he says. He says they think I was crazy. Isn't that right?
Yes, in the transcript, it says that, yes.
So you decide the way you want to put something in your report. Is that right?
No, I mean, it's important to understand, I don't have this transcript when I'm writing my report. When I do the interview, I'm taking notes, and then I write my report from my notes. So I don't have word for word what he said, the way that we're going through it now when I'm writing my report. I have notes that I'm writing as fast as I can for 2 hours while I talk to him and interview him.
And isn't it true the reason that they're not used to that is because they don't videotape you that often?
That's not true. I'm videotaped quite often up in Alachua County in Gainesville.
And do you know why they videotape you?
Sustained.
He told you that I believe in the higher power.
Objection.
Sustained.
Isn't it true, Markeith Loyd conveyed to you that
Objection, Judge.
Sustained.
did Markeith Loyd ever say to you
Objection, Your Honor.
Sustained.
he told you that he was probably 8?
Objection.
Sustained.
May I come sidebar, Judge?
You can. may proceed, Mr. Lonergan.
Thank you, Judge. Did you have conversations with Mr. Loyd about the incident leading up to his arrest involving Sade Dixon?
I did.
And you stated that, did you state something in the first paragraph of the incident leading up to his arrest about when he pulled the gun?
With regards to the incident with Ms. Dixon? Is that what you're referring to?
Yeah, it's in the first paragraph, the last sentence, actually the last two, page 7 of 12.
Yes.
And isn't it true that that's not what he told you?
I don't recall specifically. I'm happy to review it if you tell me what page it's on.
Page 59 through 60. And so we're clear on this. You wrote that he stated he then pulled out his gun. Her brother came out of the home and attacked him. He shot both of them in self-defense. So I'm particularly interested how you characterize her brother coming out of the home after he already has his gun out.
Okay.
Do you see that?
Yes. Yes, so on page 59, it says, she comes out, we're talking about what we're going through.
What line are you on?
I'm sorry, line 18.
Okay.
And she ends up asking me about my exes, and I tell her I just had sex with one of my exes, and she goes back in the house and gets a gun and comes out and calls me to the side of the house, to the back side of the house. I come over, she has a gun, so I pull out my gun.
Okay.
I'm like, Sade, what you gonna do? Parts are missing, I'm just trying to make it short. That's okay. I'm just telling the relevant parts far as,
Judge, I would object at this point.
Sustained.
She doesn't say, isn't it true that it's never in the interview that he says that he pulled out the gun before her brother came out?
it is, sir. The very next line is, anyway, her brother comes out and his account is different, but anyway, he attacks me and whatever, and our ship blows up.
Where do you see that he still had the gun out?
He never said that he put it away.
Okay.
So I'm just saying he had the gun out, and then the brother comes out and attacks him. He never
Okay.
told me that he put the gun back away.
Okay, so he didn't tell you you put the gun back away, but you've had an opportunity, of course, to look at all the Dixon material, the police reports, statements given by him, statements given by Ronald Stewart. You had all that to review, right?
That's correct.
Okay, but nevertheless, you tell your own version.
No, sir, I told the version that he told me here, and he said he was trying to make it short. I told what he told me. That case was not the crux of the opinion that I was asked to formulate.
Okay. Okay, did you ever describe the issue of the news reports?
Objection, Your Honor. There's been no
Sustained.
testimony.
Did Mr. Loyd ever say to you that
Objection, Your Honor.
Sustained.
you said you had conversations with Mr. Loyd as part of your evaluated process?
Yes, I interviewed him.
And did you ever talk to him about, you don't have to tell me what it is, I'm just asking the question. Did you ever talk to him where he said that the police were setting...
Objection.
Sustained.
Did Mr. Loyd ever talk to you about him wearing a bulletproof vest?
Yes, he did.
Did he tell you that he wanted to see if it worked?
Yes, he described that.
And did he tell you that, did he talk to you about...
Objection, hearsay.
Sustained.
What did he talk to you about his prayers being answered by God?
Objection, hearsay.
Sustained.
I'm asking a question, it's not hearsay, Judge.
Yes, it is. Sustained.
All right, doctor. When you evaluated him, you knew how important it was to take into consideration culture. Is that correct?
That's correct.
And it's your belief that you did taking culture, correct?
Yes.
What things did you do to taking culture?
So we're trained as psychiatrists and to take in social diversity. So it has to do with religion, race, background, where they were raised, socioeconomic status. So all of that is taken into consideration. And it's difficult, but it doesn't necessarily play into the question of sanity at the time of the crime.
So it's your testimony that culture does not play into the determination by you of insanity at the time of the event?
Sometimes it does. In this instance, it did not play into whether he appreciated the wrongfulness of his actions and understood what he was doing.
Well, before you get to the wrongfulness, you have to get to whether he is mentally ill or has a mental defect, right?
That's correct, and I did.
Okay. So besides this little area, which obviously is an important area where you're making that decision, you have all of his life before, correct?
That's correct.
And then you have what happened afterwards, correct?
That's correct.
And so it's super taking culture on the before, isn't it?
It's equally important, correct? Yes,
As well as the after. Is that correct?
that's correct.
So in reality, culture is important.
Yes.
Now, you said you work at a clinic. That's a full-time job, right?
That is.
And so is this something you moonlight in?
No, sir.
You do this as part of your job for the clinic?
That's correct.
Okay, and I heard you said you don't get paid. They take all the money.
Correct. They do the billing, correct.
You
Yes,
don't
it
get
goes to them.
You don't get any rewards for that.
Correct.
It's part of your salary.
Yes.
If I can have a moment, Judge?
Yes, sir.
Anything else? I'm done, Judge. Now you can make an objection.
Okay, let me just do this. State, do you have any, are you going to have any redirect?
We do not, Your Honor.
All right, then let me see the attorneys at the bench. May this witness be excused, State? Oh, I'm sorry. I'm sorry. May this witness be excused.
She may, Your Honor.
Mr. Lenneman? Yes. Thank you, doctor. You are free to go.
Thank you, Your Honor.
State, call your next witness.
State rests its rebuttal case.
All right, ladies and gentlemen, I kept you a little late because I knew this was the last witness, all right? All of the testimony and evidence in this phase of the trial has now been received. I'm going to send you all to the hotel tomorrow. There will be jury instructions, closing arguments, and we will hand the case to the jury for verdict. We're going to start somewhere between 9:30 and 10. I have a couple of issues I need to resolve, so I don't know exactly when we're going to start, but you will get the case tomorrow. Juror 642, is there anyone who can help you this evening and bring? Tomorrow's when it can be picked up. What time does the pharmacy open? And what time does the pharmacy close? And what, don't tell me the address, just tell me what part of town it's in. West, north, south? You want to just write it down and give me that? All right. All right, if you'll give that to the deputies, I'll work on this, ma'am, and we'll get it resolved for you. Have a good evening, folks. We'll see you tomorrow morning, somewhere between 9:30 and 10. I need to talk to the lawyers for a little bit, but I want you to get to the hotel so you can get your dinner. Did you read it? All right, I'll talk to you guys when I'm done with this. Okay. Mr. Linneman, you have a motion? Yes, Judge. At this time. I can't hear you. You got to turn your mic on.
At this time, Judge, the defense would move for judgment of acquittal in the light most favorable to the defense. We renew all prior objections. We don't believe that the evidence supports premeditation in this case, and I'm citing the case of Fowler versus State, 921 Southern 2nd, 708, that the state did not carry its burden to rebut defendant's prima facie case of self-defense.
Anything else?
No.
Response, State?
Well, the issue of premeditation is, generally speaking, a question for the jury. I'm unaware of any evidence or facts that would make it not such in this situation. While the defendant may have testified that this was self-defense, the video alone regarding the actions of Lieutenant Clayton and the testimony regarding her use of force make that a jury question and not a question for the court to direct the verdict one way or the other. I'm happy to look at
I think
the
your
case.
mic's off again.
Nope, it's on this time.
I can't hear you.
It's just late,
Yeah.
Judge, that's all
Okay.
it is. I said I'm happy to look at the case law that defense counsel cited, but I'm unaware of any law that would lead this court to direct the verdict on the issue of self-defense based upon the evidence that's been provided to this point.
Mr. Linneman, you get the last word if you want it, because it's your, no. All right, court's heard all the testimony in this case. I believe the state has met their burden sufficient to go to the jury. Intent, premeditation, all of that. Premeditation are jury questions. There is sufficient evidence from the video where the jury could find that it was a premeditated killing. So motion for JOA on all counts is denied, and the court's ruling as to the court having made their or met their burden on all count is on all counts. All right, jury instructions, gentlemen. We need to go through these if we intend to turn this over to the defense, or I'm sorry, to the jury tomorrow morning. Why don't we take a quick 10-minute break and then come back and go through these jury instructions? Is there a lot of controversy? I know you guys were going to talk, and I got the updated ones from you, Mr. Buxman.
I think the only controversy would be the heat of passion and self-defense instruction, and whether they want the NGI on the verdict form of all.
Okay, that's what I thought we were going to end up talking about. Has any change been made to the heat of passion or your requested justifiable use of deadly force instruction? Okay. Yeah, but this has all kinds of stand your ground, which he's not entitled to. He's a convicted felon. That all has to come out. All right. All right, take a 10-minute break, folks. Let me try and resolve this juror issue, and I'll be back. Thanks. All right, we're back on the record on State versus Loyd. He's present with his attorneys. State Attorney's Office is present. We're not going to start until 10 o'clock tomorrow morning so we can solve the medication issue with the juror. Okay. Jury instructions. Let's take them one at a time. Everyone can remain seated during this. 3.1 and 3.2, any objections? Okay. I can't hear you. You don't have your mic on. What?
My client is indicating that he would like to waive his presence to this part.
That he what?
He wants to leave.
All right, Mr. Loyd, you have a right to be present during jury charge conference. Are you aware of that?
Yes, ma'am.
All right. I'm happy to have you remain for the entire thing, but are you saying that you do not want to be present during this time?
No, I waive.
Okay. And you understand that if we make decisions on these final jury instructions, you are waiving objections you might have that your attorneys might not make?
I don't know nothing about it, so I wouldn't be able to say nothing anyway.
All right, so you want to waive your presence for jury charge
Yes.
conference? All right, thank you, sir.
I'm
Have a good
relying on my
evening.
attorney.
We'll see you tomorrow.
Take care, buddy. Okay, so you said 3.1, Judge?
3.1, 3.2, any objections?
No objections.
Okay. Here, I can move to the center again.
Tried all day to do that.
7.1, introduction to homicide.
No objection.
Justifiable homicide.
No objection.
Excusable homicide.
No objection. Judge, do we leave, on the justifiable, is that standard to leave in the dwelling house?
That's part of the standard instruction
Okay,
on the justifiable homicide?
yes,
That is the standard instruction.
okay.
7.2, first degree murder of a law enforcement officer.
No objection.
Your Honor, if the court is inclined to give the heat of passion instruction, this is where it would appear at the end of this instruction.
Right.
Others. So I don't know if you want to correct the heat of passion at this point in time.
Okay, let me just read through this one more time. This looks like the same one we had the first time, and I didn't see anything wrong with it. Okay, so that was going to be one of my questions, which is heat of passion. All right, first of all, State, are you objecting to heat of passion?
Yes, Your Honor. I don't feel that there is any evidence to support a heat of passion instruction. The claim of the defense in this case has been either insanity or self-defense. I don't see any record evidence to support that the killing was done out of an unreasonable fury or blind and unreasoning fury, which is kind of the focus of the heat of passion instruction.
The case law is pretty clear about the scintilla of evidence. I mean, someone could interpret Mr. Loyd's testimony to be heat of passion. I'm going to read it.
Yes,
Now,
ma'am.
the question now becomes, I read this, I made some notes, I left them all at my house this weekend. So, State, do you have any specific objection? You've objected to the instruction. Do you now have any objections to the requested instruction?
No, Your Honor. I believe it tracks the statutory language, and what I will do is incorporate the defense's language into the jury instructions I provided at the end of the applicable counts.
Okay.
But I didn't see any discrepancies with the proposed instruction and the standard instruction. I'll read over it again tonight, but
All right, so here's what I normally do when it's the same instruction over and over again about the lessers, which is I don't read every single line of this. I just tell the jurors, you have it in writing, and I've been affirmed on this. You have it in writing. It's the same instruction, but it applies to this lesser, as opposed to reading this for every single, because it is the identical instruction for each one.
Okay.
All right.
No objection by the state.
All right, thanks. All right, 6.1, introduction to attempted homicide. Any objection? Still reading?
Yeah. No objection.
Justifiable, I can't talk anymore, attempted homicide. Any objections?
No.
Excusable attempted homicide.
Rich, I'm not seeing those in this.
What?
I'm not seeing the instructions you sent me. What page are we
You
talking
don't see this instruction? It's on page 7 and 8.
I downloaded it from the, oh.
I just emailed Mr. Lenneman the copy of the instructions I sent earlier. Let me find it, Your Honor.
Okay. So, 6.2, attempted first-degree murder of a law enforcement officer. This is the first lesser. So normally what I do when I'm reading that heat of passion is I just insert it after each lesser, like break it up and insert it. You understand what I mean? Instead of reading it as one long heat of passion, because it does become confusing, because I haven't even told them what the lessers are yet. I break it up and put it behind each lesser.
You want a separate heat of passion instruction then?
Yeah.
Yes, ma'am.
So you understand what I'm saying? It doesn't go.
So.
Okay. So the heat of passion is being requested only as to the killing of Debra Clayton, correct?
Correct.
All right. So it's just as to Debra Clayton, and then the lessers on first-degree murder of a law enforcement officer. You following what I'm saying?
One heat of passion instruction applicable to all, for the count one and all of its lessers? Or do you want
Correct.
the heat of passion language at the end of count one and at the end, again, at the end of each?
Yes, so that I don't, so they don't get confused.
Count one and again at the end of each of the lessers.
Yeah, it's 66 pages of instruction, so yes, please. As to count one only. At least when it printed 66 pages, including the verdict forms. All right. So 6.2, this is count two, attempted first-degree murder of a law enforcement officer. This is the count that goes to Captain Carter.
No objection. Let's see.
Count three, aggravated assault, 8.2.
No objection.
Count four, carjacking, 15.2.
That's a standard, right?
Yes.
It's been a while since I've done a carjacking, but it looks like the standard to
No
me.
objection.
count 5, possession of firearm by a convicted felon, 10.15.
No objection.
Three point 4, lesser included. This is going to be as to first-degree murder of a law enforcement officer. These are all category 1s, first-degree murder, second-degree murder of a law enforcement officer, second-degree murder, and manslaughter. If I remember, I pulled it out, and I think these are all the category 1s, right? Yes, Your Honor. Are any category 2s requested? State? Defense?
I'm just looking, Judge.
Okay. Glasses is the other one.
So it's second-degree murder and what? Because I don't have it in front of me.
Second, what?
What are the lessers?
Hold on. Hold on, because this isn't actually my book, so it's not marked the way mine is.
These are the category 1. No, this doesn't.
All right, 7,
I'm seeing it now, Judge. I have no objection.
you're not requesting any category 2s? All right. So actually, the only, yeah. So first-degree murder, second-degree. All right. So, good. 7.2, first-degree murder. This is without the law enforcement element as to count 1. Any objections?
No objection.
Correct. 7.4, second-degree murder of a law enforcement officer.
No objection. Why don't you take over, Ted? He's got no problem.
And
Ted's
this
taking
one-
over for me right now, Judge.
I'm sorry, what?
Ted's taking over.
You taking over? Okay. Will you be responsible in front of a microphone so I can hear you?
No.
Will you be responsible in front of a microphone so I can hear you? Oh, sure. Yes. All right, so this one has heat of passion at the end of it. All right, Mr. Moreau, any objection to 7.4 with the addition of heat of passion at the end?
No objection.
All right. 7.4, murder in the second degree, removing the element of law enforcement. Any objections?
I'm sorry, 7.7?
7.4, murder in the second degree, no,
Right,
no law
no.
enforcement designation.
No objection.
All right. 7.7, manslaughter.
No objection.
And then this would be the last one that has a heat of passion at the end. You know, I don't know the answer to that.
Probably not, Judge.
Defense, Mr. Moreau, you think heat of passion applies to? That's a good question.
I've never thought about it, but probably not.
It probably wouldn't, just because of the nature of manslaughter.
Precisely.
So, oh, good, that's less times I have to explain it.
Culpable negligence, it doesn't make sense.
That's right, because this wouldn't be a heat of passion, so you're right. 7.7, without a heat of passion. All right. 3.4, lesser attempts on attempted first-degree murder of a law enforcement officer. So these are also category 1s that are listed here. State, are you requesting any category 2s on this one? No, Your Honor. Defense?
Just a second, Judge.
This would be 6.2 is the standard. Well, there is one that's missing, which is attempted aggravated battery. And we're going to talk about them just because they're category ones. I want the record to be clear. The category ones on this one are attempted second-degree murder, attempted manslaughter by act, attempted aggravated battery, intentionally caused great bodily harm. I don't think that one's applicable, but I'll hear the defense if you want me to. Captain Carter wasn't shot, and he wasn't injured. You know where I am?
Judge, I'm pulling up, I didn't have the category twos, so
This is category ones I'm talking about. Attempted ag battery is a category one of attempted murder. As is attempted battery. But both of those require some kind of touching, and there wasn't in this case. I just want the record clear on this, that you're not requesting it. And then I'll get to the category twos.
At this time, Judge, we're not requesting it.
All right, any category
category
twos
two.
that are being requested? You good on these category ones? Attempted first, attempted second of a law enforcement, attempted second, and attempted manslaughter by act. All right.
That's
Is
not
that a
fine,
yes?
Judge. Yes, Your
Okay.
Honor.
6.2, attempted first-degree murder. This is without the designation of law enforcement for Captain Carter.
Right, no objection.
All right. 6.4, attempted second-degree murder of a law enforcement officer.
No objection to that either.
6.4, attempted second-degree murder without law enforcement designation of Captain Carter.
No objection.
6.6, attempted manslaughter by act.
No objection.
3.4, lesser included of aggravated assault.
No objection.
Any category twos requested by state, defense?
No, Your Honor.
All right, so we're reading improper exhibition of a firearm and assault, the two category ones. 10.5, improper exhibition of a firearm.
No objection.
Assault. Any objection?
No, Your Honor.
All right, 15.2 is carjacking, and so, get to that one.
I believe there's a category one lesser of carjacking ag assault, which I did not include because it's separately charged as count 3.
It's actually assault. It's not even ag assault. It's just assault. So, all right, so, right. Yeah, ag assault is the category 2 for some reason. I'm just looking at it. I don't write this stuff. I just read it off. The category ones are robbery, grand theft of a motor vehicle, and assault if assault was charged. And then we have aggravated battery. The category twos are aggravated assault is listed under category 2. I'm just reading it. So let me start with, Mr. Marrero, is the defense requesting assault as the category 1, or are you waiving that one?
I, and, let me see here. I mean, we'll ask for it, Judge. We're not
You want
waiving
it?
Yes.
Okay, so we're going to reread assault.
Or the court can just instruct.
8.2, well, I need it in the written form.
Okay.
I'll just tell them it's the same instruction that was read on the other one,
Yes,
but
ma'am.
I'm going to have it in written form. And then, State, are you requesting any of the category 2s? Defense, are you requesting any
No,
of
Your
the
Honor.
category 2s?
No.
No? Okay. So 15.1 is robbery. Any objections to that one?
No, Your Honor.
14.1 is grand theft of a motor vehicle. Any objections to that one?
No, Judge.
And the original 8.2 is going to go back in here.
Oh, yes.
Then 3.3, possession of firearm. All right, there is no lesser included of possession of firearm by a convicted felon. So we're done with the lessers. All right, so now we have the possession of firearm, discharge of a firearm causing great bodily harm instruction. Any objections from defense?
I'm sorry, Judge, you lost me. What page are you on now?
3.3, we're on page 36.
36, okay.
Yeah. Because the counts all include firearms, counts 1 through 4 include firearms.
Right.
This is the possession of firearm, discharge of firearm. Well, counts 1 through 5 all include firearms.
Okay.
So this is the standard instruction.
Count 5 is not a 1020 life crime anymore, so. There.
You didn't charge it as a 1020 life? Honestly, I haven't paid any, honestly, I paid almost no attention to count 5. Y'all didn't charge it that way?
We did as a possession of firearm by a felon, but I don't think it's a 1020 life pursuant to this instruction anymore. Nothing you guys saw. No, I'm sorry, it's in here.
It is, I was going to say, it's in here. Yeah. It's been a very long day, so.
But it's only as to possession, not discharge for the count 5.
Let me know when you're ready to comment on this one, Ms. Moreau. Do you have any objections to this instruction?
No, Your Honor.
Okay.
To the aggravation. No.
3.3A, aggravation of felony by carrying a firearm.
No objection.
All right, now we're going to get to insanity. All right, the issue in this one was the last paragraph.
Correct.
State, what's your position on the last paragraph?
I'm taking it out. You don't want it?
I think the court's obligation is to instruct the jury properly, and I don't think there's any set of circumstances in which he would be released from custody regardless of the verdict. Jury that you must conduct further proceedings.
Well,
On this case, you would be.
the weird thing is, if he was found not guilty by reason of insanity, I still have to have the commitment hearing.
Yes,
But he's never going to be released.
that's my point.
I thought
I
we-
will leave,
How about-
whatever the defense wants, I don't have an opinion on this one, Judge.
Yeah, I thought we all had agreed on this, because at the beginning of jury selection, the way we dealt with this.
We've agreed something has to be read, but we haven't agreed on the wording. So my proposed wording would be, if your verdict is that the defendant is not guilty by reason of insanity, that does not mean he will be released from custody. I would take out the word necessarily. And maybe just put a period there. I don't know,
Why is it in italics, Judge?
because we had to talk about it.
Oh, it wasn't, that's not
It's
the way
not
it's
an,
in the...
it's not going to look like this in the end.
No, but in the standards,
No. The italics and the bold are the things that we had issues with and have to
Okay.
talk about. All the type will look the same.
okay.
So I'm saying, if I just read, if your verdict is that the defendant is not guilty by reason of insanity, that does not mean he will be released from custody. And put a period there.
I object only because,
What are you objecting to?
only because if the jurors are confused that he's going to get out and decide that they're going to vote against it because of that,
It says that does not mean he will be released from custody.
I'll just bring up what you said.
What
about
is it you want it to say?
He will never get out. He will die in prison. It will be
Well, I'm not going to
sufferable.
use that terminology.
He'll be in isolation.
I'm not using that terminology, so if you want to try again, you can.
Okay, we'll go with yours.
All right, so just have it read, take out the last sentence, which is, I must conduct further proceedings. All that's going to do is confuse them. They're not going to be able to follow the distinction. And we have told them he's serving life in prison, so.
And I'm clear, the defense has no objection to removing that second sentence.
You're not
no
objecting?
objection.
Okay. And the court has denied their request for whatever it was that he wanted me to say, which I didn't write down, but I'm sure the court reporter got it. All right. 3.6H, justifiable use of force by a law enforcement officer. Any objections to this one?
No objection.
All right, that would bring us to justifiable use, the one that the defense is requesting. State, you wish to be heard on this?
Yes, Your Honor.
Go ahead.
Objection is, I think, the one, the
I'm sorry.
justified. The second sentence of that indicates that if Markeith Loyd was not otherwise engaged
Yeah,
in activity, which is to stand your ground.
that one's out.
Judge, I'm sorry, what page is that on? It's not the next page.
This is y'all's requested
Oh, okay, yeah,
instruction.
okay.
Yeah, hold on.
Yeah.
You can sit through this, Mr. Brunson, thanks.
I don't think he's entitled to that second sentence because he was engaged in criminal activity. The statute changed in 2014,
Yeah.
precluded.
Yeah, I'm not reading that.
Okay.
You got it?
Yep.
All right, so that's the simple one. There's another one in here that is a stand your ground. Let's do the two stand your ground ones. Go to the second page of this. go to that last how the defendant had no duty to retreat.
Yes.
That's a stand your ground language, and that he's not entitled to that.
I agree.
Any other changes that are requested by the state?
Yes, Your Honor.
Which ones?
We don't have an objection to the first paragraph. The second, third, and fourth paragraph, I don't think are applicable in this case. In the jury instructions, it does not say that that is to be read in each case. That is read as applicable to the facts of the case. Here we have the above paragraphs are, if you read them the way they are written, if you read them, it would basically permit a defendant to use deadly force each and every time an officer pulls a weapon to effect the arrest of somebody or to take a felon into custody. The language up there in paragraphs 2, 3, and 4 pertain to a situation where you have a layperson who doesn't have the authority and the right to use a firearm to take a felon into custody or to use whatever force is reasonable. So if you read those three paragraphs, paragraph 2, 3, and 4, and then you read the paragraphs dealing with the justified, the law enforcement officer's justification of using force, they're inconsistent. So my suggestion would be to read the first paragraph and then begin with the paragraph starting, a person is not justified in using force to resist an arrest by a law enforcement officer, and continue there.
So just so that we're clear on the record, you're saying, read, it is a defense to the crimes of first-degree premeditated murder of a law enforcement officer, first-degree murder, second-degree murder of a Leo, second-degree murder, and manslaughter if the actions of Markeith Loyd constituted the justifiable use of deadly force. Deadly force means force likely to cause death or great bodily harm. Great bodily harm means great is distinguished from slight, trivial, blah, blah, blah. And then jump to the last paragraph on the page, which is a person is not justified in using force to resist an arrest by a law enforcement officer or to resist a law enforcement officer who is engaged in the execution of a legal duty if the law enforcement officer was acting in good faith and he or she is known or reasonably appears to be a law enforcement officer. Then go on to the next page. However, if an officer uses excessive force to make an arrest, then a person is justified in the use of reasonable force to defend themselves, but only to the extent he reasonably believes such force is necessary.
Correct, Your Honor, because
And I'll get to the rest of it in a minute.
that last
right.
paragraph that you read, starting with however, addresses the defendant's ability to use whatever force is necessary in this situation.
All right, defense, you want to be heard on this?
Yeah, Judge, I need to see it because we can't find it. What page is that on?
This is yours.
It's your requested instruction that you
Oh,
emailed
okay,
to all
I
of
can
us.
find that.
Nan, did you count how many copies we need? You're my counter. Well, court
So
reporter.
which paragraphs, Rich? Al?
All right, so look at, here's the paragraphs we would take out. Paragraph 2, the use of deadly force is justifiable if Markeith Loyd reasonably believed that the force was necessary to prevent imminent death or great bodily harm while resisting another's attempt to murder him. And then the paragraph following that that starts with Markeith Loyd was justified in using deadly force. Those two would come out. So I would read paragraph 1, and then the last paragraph on that page, it says a person is not justified in using deadly force. Then go on to the next paragraph, which is, however, if an officer uses excessive force.
Yeah, so what is the reason that those first two come out?
Not the first two. The first
sec-
paragraph stays, paragraphs 2 and 3.
Okay, the use?
The state is saying that if I read that, basically anyone who's being arrested by a law enforcement officer who's drawn their weapon is justified in returning fire.
Yeah, but there's other predicates that go into that. That's just not alone. There's other predicates that have to be met.
So I don't think that the paragraph that is the use of deadly force is justifiable and ends with another's attempt to murder him. I don't believe that that needs to be read. I am inclined to read that first line of the next paragraph. Markeith Loyd was justified if he reasonably believed that such force was necessary to prevent imminent death or great bodily harm to himself, because then it's immediately qualified by, well, actually, that's not true. The problem is that the law surrounding arrest and lawful arrest by an officer.
I
The
believe,
law is pretty clear that you can't resist with violence, except if the officer is using excessive force. And that's been the law in Florida for as long as case law has been around. You cannot resist an officer with violence unless they are using excessive force against you.
and that legal concept is covered in the paragraph
Right.
below. So I think the two paragraphs are inconsistent if read together.
I agree with that.
Okay, so I'm going to take out those two paragraphs completely.
The use of force is justifiable and another's attempt to murder him. Right.
Yeah, I'm going to take that out, and then the Markeith Loyd was justified in using deadly force. So I'm going to read the first paragraph, then I'm going to read the last paragraph on that page. A person is not justified to resist arrest. Then I'm going to read, however, if an officer uses excessive force, then a person is justified. Then we get to the next paragraph. In deciding whether Markeith Loyd was justified in the use of deadly force, I think that one should be read except for that last sentence, which is a stand your ground defense, which he's not entitled to.
I agree, Your Honor.
So I
Come
get-
up here and look at this, Mr. Letterman.
All right, I can see what, the one you're talking about, you're taking out after another attempts to murder him.
Yes.
You say you're taking that out.
And I'm taking out the next paragraph that starts, Markeith Loyd was justified in using deadly force, because it contradicts what the next two paragraphs say, and it's also not Florida law.
Okay, so, but going back to the other one.
What other one?
The one above that.
In defense, it is a defense of the crimes of first-degree murder?
No, Markeith Loyd was justified in using deadly force if he reasonably believes that
Right.
such force was necessary. Is that somewhere else in here? Because I think that's the law.
Yeah, if you keep reading, keep reading.
Okay, I get the duty to retreat comes out.
Well, yeah, retreat was going to come out regardless,
Right.
because that's stand your ground. The rest of it I would read, other than the stand your ground line that we took out.
So that, in deciding whether Markeith paragraph, you're getting rid of the last sentence.
That one's being read, except for the last line, which is a stand your ground defense.
Right. So I don't think that the first part of the sentence up here is adequately covered. And so I'm talking about Markeith Loyd was justified in using deadly force. I agree that
You cannot use deadly force when being arrested unless the officer uses excessive force, which is covered in the last paragraph, in the
Okay.
top paragraph of the second page.
no objection.
All right. Let's move on from this. We've come to a decision about this one. All right. 3.7, plea of not guilty. Any objections to that one? It's a standard.
No objection. Judge.
3.8, evidence of other crimes. Williams rule. Any objections?
No, Judge.
3.9, weighing the evidence. I take it, did you take out the defendant testifying?
I did not, but I will fix that.
I also had a question about you must consider the testimony of some witnesses with more caution than others. I vaguely remember discussing it, but I don't remember why it was in here.
It was in there because of the claim in the first trial that Brian Stribby got some kind of a deal. That was vaguely brought out in this case, but I still don't think there's any evidence of it, so I have no opinion one way or the other, Your Honor.
Defense, you asking for that paragraph?
Yes.
All right, we'll leave it in. So you gave me two 3.9s, and I can't remember why you gave me two 3.9s.
One
Oh, yeah, the
defendant
second one has
testifying.
the defendant has become a witness.
Correct,
So
Your Honor.
Let me get rid of this one. All right, so 3.9's good with the paragraph about defendant testifying. 3.9A is being removed as the defendant has testified. 3.9B, defendant statements. That's usually a confession one.
I'll defer to the defense, Your Honor.
Yeah,
There-
I don't think that should come in.
What?
I don't think it should come in.
Okay, so 3.9B is not coming. 3.10, rules for deliberations. I didn't see any problems with this one. All right, remember, I'm going to stop at this point. I'm going to read all of this and then stop at 3.9, and you all, at 3.10, you all will do your closings. So I'll read to the end of 3.9.
Okay.
Cautionary instruction, 3.11. That's a standard.
Right.
3.12.
It's fine, Judge.
I'll get to the verdict forms in a minute, but, all right. 3.12A, single defendant, multiple counts. Any objections?
None.
3.13, submitting the case to the jury.
No objections.
This is the one where we took out,
Took out the cell phone stuff,
we took the cell phone out,
and I changed the language on,
the exhibits.
yes, ma'am.
Okay. All right, so that one's good. All right, verdict as to count one. Any objections to this one? It's in order, right? Yep. First degree, second, manslaughter, yep. Not guilty by reason of insanity. Any objections to the verdict as to count one?
No.
All right, verdict is to count two. I have to tell you, I did not hear Dr. Toomer, and I did a word search yesterday, but I'm not 1,000% sure on what I'm saying. I didn't hear him say, his entire opinion was he was not guilty by reason of insanity. He was insane at the time he shot Clayton, but I don't remember him giving an opinion on any other count.
No, I don't, we don't want any other count.
So we agree that the only evidence that was offered was as to Clayton on insanity?
Yes.
Okay. So on count two, we're going to take out F, defendant not guilty by reason of insanity. And so we have, let me make sure the order is correct. First degree, second, attempted manslaughter, and not guilty. Any objections to count two with the removal of not guilty by reason of insanity?
No, Your Honor.
All right. Verdict is to count three. Ag assault, improper exhibition, assault, take out, defendant not guilty by reason of insanity.
Correct, Judge.
Okay. Count four, carjacking, robbery, grand theft of a motor vehicle. You need to add assault to this one. So D becomes take out not guilty by reason of insanity and add assault.
Yes, ma'am.
Defendant not guilty. And count five, take out not guilty by reason of insanity, and this one has no lessers. Possession of firearm, defendant is not guilty. Special verdict forms. Any objections to the special verdict form? This is
No
as to count one.
No, Your Honor.
All right.
Do you want the special verdict forms after the verdict form for count one, or do you want all the specials at the end? Or do you care?
I can reorder it, but
Because they're numbered, that was the only reason.
Yeah, I'm thinking I want it to be after count one so that they know you need to make these decisions and then you need to make this decision as to count one. So they're not going back and forth. It's a lot of instructions. All right, so special finding regarding count one. Oh, that's the continuation of the manslaughter thing, okay. Then special finding count two, this again is the weapons findings, or the firearm findings. Any objections as to count two?
No, Judge.
All right, any objections as to count three?
No, Judge.
Okay. Well, count three doesn't have the special finding, I'm sorry.
Correct.
Count four is the one I'm talking about. Jeez, okay. Any objection as to special finding as to count four? That's just possession of a firearm.
No, Judge.
And then count five does not have a special, well. All right, I actually can't remember, and I don't know if it's because I'm really, really tired. Do you have to do the special finding on possession of firearm by a felon?
Yes, and I'll add it.
I think you do.
We do.
It's
That's my
that
fault.
weird one where even though you have to find it to convict him, you still have to have the special finding that he actually possessed the firearm. So
Judge,
you'll do
on
the
that
special
last
finding
page-
on that one,
On page
yeah.
66, it should be count five.
What?
It should say count five on there, not count four.
What does it say?
Count four.
Oh. Mine
page
says count
66?
five.
Now, there's two special findings for count four. One dealing with the carjacking and robbery for 1020 life, one dealing with the enhancement of the firearm for grand theft.
And then do
Okay.
we have to have one for assault?
Not misdemeanor assault, no.
Oh, that's right, I keep thinking it's aggravated assault, but it's not, it's the misdemeanor assault. All right, so count five does require a special finding,
Yes, ma'am.
so we'll add that one. All right, Mr. Buxman, if you would make, how many copies did you say, 24? We need 25 written copies of this. Please don't staple them together in case we find a mistake. It's a nightmare to unstaple all of it. And if you would please send me the electronic version of this also. And aren't you glad we're not starting until 10 tomorrow morning, folks?
Will do, Your Honor.
All right. Have a good evening, folks. And each one of you asked for 2 hours approximately for your closings? Yes, Your Honor. All right, gentlemen, have a good evening. Get some sleep. I'll see you all tomorrow morning at 10 a.m.